Johnson versus Taylor Schabusiness. The appearances are the same. Deputy District Attorney Saunders, District Attorney Lezay for the state. Mr. Fairwick is here for the defendant, and the Schabusiness is here as well. So we're on the court's calendar this morning, not just to complete the, or just to continue with the jury trial, but I asked the parties to report at 8:15 to voir dire, the last witness, about the issue that came up yesterday. Is the witness here?
That witness is here, Your Honor. In addition, Ms. Danelski is also here from Green Bay PD, who may have more information about technical issues if the court has concerns. But I can address this if you want to voir dire Lieutenant Libera first.
I would like to do that. So if you could come on up.
Please solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God. I do. Please have a seat and state your name for the record.
Jenna Luberta, L-U-B-E-R-D-A.
So, Lieutenant Roberta, we invited you back this morning to ask a few questions. I'm going to afford the attorneys an opportunity to ask those questions, to ask some questions as well. But I was looking at the two exhibits, 99 and 100, that appear to be the extraction reports. And I'm going to hand this to you. Actually, counsel, I don't have copies of those. So she's looking at the originals. Do you have a copy that I can look at while I ask some questions? And then I'm going to give each attorney an opportunity to ask some questions, but I have some specific questions I'm interested in. If they're your only copies, I'll give them back before you ask your questions. Okay, I'm looking at these reports, and the question that I had for the attorneys is if there's a way to identify when these searches occurred. First of all, and my exhibits are not numbered. I believe the one that says searched item 35 in the upper left corner is exhibit 99. Is that correct?
Yes.
Okay. So as far as the searches on these forms, everything that I see has a timestamp item in the far left. For example, item number 1, timestamp February 19, 2022. Does that tell me when this was searched?
Yes.
Okay. And each one of those search items seems to have one of those timestamp denotions on it. When I look at a Web 100, however, I don't see a similar indication as to when these were looked at. And so first of all, as far as Exhibit 100, are these searches or something else?
These are something else.
What are these then?
These are you referencing the actual photographs, or are you referencing the information?
Well, that's a good question. First of all, are the photographs affiliated with the information? In other words, you're extracting something, and these came from the phone, and all the data comes along with the photograph?
They are from the phone and affiliated with the search, However, I believe Analyst Danowski will be better able to answer that question for you as far as what's done on Google's end when I wrote the warrant.
Okay. So you're not able to, the question I'm driving towards is, how do we know when these were accessed by the defendant through the defendant's phone? And you're not able to tell me that?
Correct.
Judge, I think I might be able to clarify with a couple of questions. The exhibit that you see in front of you, Exhibit 100, that has those photos, and then they all have a date associated with them. I think of March 8th of 2022. Is that correct?
Correct.
And that is the date after the phone was seized from Ms. Schabusiness, correct?
Correct.
Now, that is an extraction report built upon the return that you received from the Google warrant, right?
Correct.
Now, did you also review an extraction report from the phone itself?
Yes.
And when you looked at the extraction report from the phone itself, were you able to find dates that corresponded with the photos of Jeffrey Dahmer?
Yes.
And when you looked at the phone itself, what were the dates that corresponded with the photos of Jeffrey Dahmer?
It was February 6th, February 12th, and February 13th.
And are those consistent with the dates of the searches for information on Jeffrey Dahmer that you saw both in the phone and on the Google warrant?
Yes.
Now, do you know why the March 8th, 2022 date was assigned by Google when you received that from the warrant?
No.
Okay. But I just want to confirm that you did two separate searches. One is the phone itself, and then there's a second that is from the Google warrant, correct?
Correct.
And the exhibit that you have in front of you, 100, that's from the Google warrant, not from the phone itself.
Correct.
Mr. Fraley, do you have any questions to voir dire this witness regarding these exhibits?
Well, I asked yesterday for copies, but I don't have them, so I'll have to take a look. Can I look at those?
Sure.
Could I approach your honor?
Yes.
Thank you. Should I call you Officer Liberta or Miss Liberta?
Miss Luberta is fine. Thank you.
Thank you. This Exhibit 100, it's a extraction report, and it says Google warrant return, correct?
Correct.
And this is information that is directly from Google,
Correct.
and it shows different searches. Is that fair?
Yes.
It's got like a byte size, correct, on it? Like the number of bytes?
I would have to look.
And then it's got a modified date on there. Is that fair?
That I know, yes.
And it's got a source file, correct?
I'd have to look at it again.
And then it's got pixel resolution, correct?
I'd have to look at it again.
Okay. And these are basically thumbnail pictures or photos?
I'd have to look at it again.
Your Honor, could I approach?
Sure.
Thank you. Okay, I see bytes size.
It's got different categories, correct?
Different categories, yes.
All the things that I just asked you about, is that fair?
Yes.
This, this March 8th, 2022 date, that is the date that the cell phone that is associated with these pictures was seized?
What is the question?
That March 8th, 2022 date, is that the date that's associated with when the phone was seized?
No.
Corresponds with those pictures?
It is not the date that the phone was seized.
Okay. What is that March 8th, 2022 date then? Do you know?
It says it is a modified, and then it has the date.
Okay. Do you know what that means, modified?
No.
Okay. I think you said these other dates, February 6th, February 12th, February 13th of 2022. What were those dates?
Those were the dates that searches for Jeffrey Dahmer or Jeffrey Dahmer in some way were done.
And is that what's on that Exhibit 100?
No.
Okay. No other questions?
Okay.
Judge, I do have as an additional exhibit for the court a report that was generated from the phone itself, which quite clearly shows the date stamp associated with some of these photos, and particularly the date stamp associated with Exhibit 101, which is the large picture that the state intended to address. So I can provide that to the court if it alleviates any concerns regarding the date of that particular photo. Ms. Lugard, I'm showing this one right as Exhibit 102. Can you review that?
This is the Celebrate report extraction of the device screenshots taken by forensic computer analyst Danowski.
And those are the screenshots that you testified to yesterday that you reviewed when you were doing your analysis of the phone extract itself, correct?
Correct.
And in that exhibit, are there a number of photographs depicted of Jeffrey Dahmer?
Yes.
And those have date stamps associated with them?
Yes.
Google, and those are in the Google Photos section of the device, is that right?
Correct.
And what is the date stamp associated with the picture of Ms. Schabusiness holding a cell phone photo of Jeffrey Dahmer next to her head and smiling?
Saturday, February 12th, 2022.
Thank you. I have no further questions on that point.
Do you want to voir dire the witness on that, Mr. Fraley?
Thank you, Your Honor. Ms. Liberta, does it indicate on this Exhibit 102 extraction report, created 3/2 of 22? Says that, right?
On the bottom, correct.
Okay. It says it on the bottom of page 1, page 2, and page 3. Is that fair?
Yes.
Okay. Nothing further. Thank you.
Just to clarify, that 3/2/22 date, is that the date that analyst Danowski created these screenshots?
Yes.
Thank you.
Okay, you can sit down. Is the state intending to call your other witness or have your other witness?
I think only if the court has concerns on this issue and as a predicate to admitting this testimony, I could call analyst Danowski if the court wishes.
Yeah, I'd like that recalled, so.
Sure.
Okay.
What's that? You can have that, yeah.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God?
I do.
Please state your name for the record.
Kendall Danowski.
Okay, Ms. Danielski, you have a seat.
Thank you.
I'm going to give you exhibits 99 and 100. I just had a couple of questions
Sure.
for you. I'm looking at the exhibit, I think it's 100. It's got the thumbnail photos on. And we've been talking a little bit about this exhibit, and it has a date listed by each image, and that date seems to be in the third column. So the first column is just the number. The second column is the file information. The third column is additional file information, and under that there shows a date modified March 8, 2022. Do you know what that date is?
I believe that date is basically when Google received that preservation letter, when they grabbed that preservation and then said, okay, we're going to take a snapshot of this data here and save it. I believe that's when that data is created. I went back and looked at a couple other Google warrant returns that we've had in the past, and it was of similar correlation. So, for instance, the preservation was sent and received by Google on the 25th, And then I saw the modified dates on all of the images to be the 29th. So it seems consistent that that would be the date that when Google receives that preservation letter, that's when they're saying, we're going to create a snapshot of all of this data.
Okay. And this data on this exhibit, what is this data? It's not a search on a cell phone, or is it a search on a cell phone? Because I'm contrasting it with Exhibit 99, which seems to, on the upper left-hand corner, it says searched items 35. You see where it says that?
Yes.
Okay. This
So,
one over on the other exhibit doesn't say that. So what is this?
so the one on the left, the search items, those are going to be Google search terms. And then the one on the right, data files, those would be images that would be under the Google Photos application. Both of these can be cloud-based, where data can be on the phone and in these applications as well. So if you were to log into a certain Google account, you could access these images from a computer as well. So
The fact that it's showing up on this report, what is that telling us about this information?
So this is telling you this is what was associated and within that Google account when Detective Liberta created that or sent that preservation letter. And the Google account can be accessed via the phone. A lot of times the data from the phone will be automatically backed up and synced to these applications. So if you're on Google and you're searching, where is Starbucks, that could go onto the cloud and translate to that as well.
So this report then does affiliate with something that was searched.
Yes.
Okay. So why does one report indicate that it's searched items? That's Exhibit 99, but 100 doesn't indicate that it's searched items.
So it's just different types of data. So the searched items would be like Googling where is Starbucks on the Google application, the Google search application, where the data files would be something like if you were to be searching on Google and save a file or download a file or take a picture on your phone, and then that's backed up and synced to the Google Photos application.
Okay, so it's something else going on the phone other than searching.
Yes.
And would there be any way to determine when that activity occurred by looking at Exhibit 100? So if I look at item 1, is there any way to determine when the phone performed a function that registered this piece of data in it?
It can, yes. So if you were to look at the photos app, the regular photos gallery on the phone, under the images from the phone extraction, so not the Facebook or the Google warrant return, it would show a lot of these images as well, because a lot of images saved in the phone's gallery that comes installed with the device get backed up and synced to this Google Photos application. So a lot of these thumbnails and photos you're seeing here would also be in the regular gallery on the phone, which you could see going through the phone extraction.
Okay. Is there any way for me to tell from this phone whether this data was collected by this phone, say, in 2022 or in 2015?
Yes, some should have associated dates and times with them. I was looking, and some of the pictures of similar nature did have some download dates and times associated with them, which I believe were from February of 2022, which would be consistent with some of these search dates and times on the Exhibit 99.
Sure. Let me be more direct. This exhibit that the state is offering me, I want to make sure, if I receive it, that there's some correlation in time between the events in this case and the events on this sheet. And by looking at this sheet, I can't figure that out. Can you tell me whether looking at this sheet, I should be able to figure that out or not?
Not usually by looking at the sheet. We'd have to look at the original phone extraction and find some of these duplicate or similar images, and then compare them and see the dates and times in the original phone extraction. I can't speak to Google and their servers and data after that preservation has been sent to them, so I can't say with 100% certainty what that modified time is on this form. That would be for them to speak to. I can say that the zip file we received from Google, the dates and times from that zip file are matched and were correctly parsed by my program. So it wasn't my program that edited and added in these dates and times. This is what Google sent us. So the best way to decide the dates and times for these images would be to either look at the captured screenshots that I took from the original phone extraction, or to go through the images from the original phone extraction.
I'm not so concerned necessarily with the March 8 date, because that was after the phone was seized. That was after the events that occurred in this case. And every single item on this form has that same date. It would seem, as a result, that that was some kind of recording date that was done when you received these. My concern is whether or not there's any way to pinpoint when this information was collected by this phone. And you're telling me, looking at this exhibit, Exhibit 100, there's absolutely no way you can tell that.
Correct. We would have to look at the phone extraction and compare the pictures with dates and times.
Okay, I'm going to let the other attorneys ask some questions. Mr. Lizette.
Okay. And I'm not going to ask any questions on that exhibit. I guess I would ask, could she see Exhibit 102? Then, Ms. Danowski, after you've reviewed 102, I would ask if you could identify what that is.
This would be a report created from my device screenshots that I took from the original phone extraction.
So whereas the previous Exhibit 100 is from the Google warrant, this extraction is from, or this report is from the extraction of the device itself, correct?
Yes, these were taken after the phone extraction completed successfully, and then I manually navigated the phone.
Okay. And do these photographs in this report allow you to associate a specific date with the photographs that are depicted in that report?
Yes.
And what date is that based on your review of that report and your review of the extraction of the phone?
This one is showing Saturday, February 12th, 2022, and that will correlate with the images below that date.
So, Your Honor, what I would propose, frankly, is that the state withdraw 100 and instead admit 102, which I think more clearly allows us to associate a date with the particular photos and more specifically the photo that's depicted in 101 that the state also wishes to submit.
Okay. So my understanding is the state is no longer offering 100.
Not 100. We would want 99. I think the dates on those searches is still accurate.
Mr. Freilich, you have an opportunity now to voir dire this witness if you'd like. She's not necessarily being recalled, which is a bit odd. She's already testified.
Right.
On the other hand, it might offer someone an idea that they want to call her at some point in rebuttal or in some other fashion. But when you voir dire the witness, I just want to indicate to you, you don't need to focus on 100 because they're not even offering it anymore. Okay?
Yes.
Very good.
Thank you, Judge. Ms. Danowski, referring your attention to Exhibit 102, it's a 3-page extraction report, correct?
It is, yes.
And on each of the pages, it says created date, and that's 3/2 of 22. Is that fair?
Yes, that would be when I captured the screenshots.
And these are just basically shots off the internet. Is that fair?
These are screenshots taken from the Google Photos application that was installed on the phone.
Okay. There's a date, at least on the first page, that says Saturday, February 12th, 2022. Is that correct?
Yes.
And then on the last page, it says Saturday, December 18th, but it doesn't have a year. Is that fair?
Yes.
So are these different pictures from different time periods?
So the date correlation would be, so the first one, Saturday, February 12th, 2022, you would start looking at everything underneath that belonging to that date and time. And I take screenshots in chronological order, and I always try to include the image above and below just to make sure there isn't any way to say that images were skipped or passed over. So you'd want to follow along chronologically, that any image that is after the one on page 1 that goes to page 2, which then goes to page 3, would all be under Saturday, February 12th, 2022. I'd have to see the screenshot below the December one to make a decision on that one, but from the ones I'm seeing, these would all be under the February 12th date.
But the last page, you would agree, it does say Saturday, December 18th, correct?
It does, yes.
Okay. And these are pictures where? In the Google Photos of this phone, or where were these pictures found?
These were located in the Google Photos application. Photos can be added to that application in many ways. A lot of times there's a regular gallery that's on a phone, and when you take pictures or you download pictures from the internet and save them to your gallery, they're later backed up and synced to the Google Photos application. So likely these photos at some point were on the gallery of the phone, or they could be added by logging into this account on a computer and then adding them that way, but they still would be synced with this phone.
Is it possible that these pictures could have been downloaded and put into the Google Photos app on all different dates?
Usually the Google Photos application is going to take the same date that that photo was captured. So that photo was likely captured Saturday, February 12th, 2022. It's just going to grab that date from the gallery and bring it right in with Google Photos.
But you don't know 100% when these photos were downloaded. Is that fair?
We would have to click on that photo and click information, and then it would give the exact date and time that photo was taken, or we could look in the original phone extraction under the regular images tab, which would be associated with the phone's gallery.
But as you sit here today, these photos in Exhibit 102, you don't know what date these photos were downloaded and put into the Google app application, correct? Is that fair?
I would say the pictures were taken on Saturday, February 12th, 2022, or saved at that date or time.
How do you know that?
Because that's how Google Photos associates dates and times with pictures and images.
Can you say that 100%?
Very certain, yes. In my experience when looking at this application, it's been very consistent.
Do you have any trouble with the fact that this Exhibit 102 has February 12th and December 18th, two different dates?
No, so that likely was the order that the other pictures were placed onto the phone. So that there could have been a time lapse of when the phone wasn't being used or when photos weren't being taken or added to the Google device. The phone usually has to be connected to Wi-Fi at some point for this backup and sync to occur. So maybe the phone wasn't connecting to the internet at any point or the Wi-Fi for that to happen. I can't say for sure without looking at the phone.
And in your occupation as a forensic analyst, you see all kinds of searches. People search for bizarre things for shock value. Is that fair?
I'm going to object. I think this is beyond the scope of what we're trying to accomplish here this morning prior to the jury being present.
I'll withdraw it.
Right.
Nothing further.
Any other questions from the state?
Not for the witness, no.
Okay. Thank you, ma'am.
Thank
can
you.
sit down. Anything else you wanted?
Just to clarify, I think what I would ask to do, Your Honor, is recall Ms. Luberta when we come forward. I have very brief questions for her regarding these issues. I don't intend to go into depth regarding these photos. I think we simply want to put in the fact that the searches were made and the photos exist. I would ask to briefly recall Analyst Danelski after Ms. Luberta, just to clarify the technical aspects of it, if Attorney Freilich has those specific questions, because she's going to be in a better position to answer those questions.
Okay. Any objection to that, Mr. Freilich?
Your Honor, I'm going to object because these witnesses have already been called, and now they're going to be called again.
Well,
I guess if he doesn't cross on those points, I'm not concerned, but if he starts crossing on points that raise the technical issues, then I want to be able to recall her to answer those questions.
well,
for the
we'll see
jury.
where the testimony leads, and then I will address that issue. Just to run through again, I've had the opportunity now to look at the exhibits that are being offered, and that's specifically 99 and 101. 100 has been withdrawn. I think yesterday I addressed some of the issues. I've had a chance overnight to frankly review the the elements of the offense that the state has to prove, just in thinking through this issue. And one of those elements, of course, regarding homicide is an intent element. That's element number 2 on the homicide. And then if you look at the jury instruction, it explains to the jury what they can look at. It certainly indicates that the jury cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. The second count, the mutilating a corpse, that has an intent element with it. But in reviewing what's being offered, particularly Exhibit 99 and then 100, I've indicated that items 1 through 9, I don't believe are, I'm not going to allow those to be referenced. If this were to go to the jury, I would want those redacted, because I don't think those types of references are such that their probative value outweighs the prejudicial effect. On the other hand, the items 10 through 35 relate to Jeffrey Dahmer, and the circumstances of the events of Jeffrey Dahmer's homicides are frankly conventional wisdom, not just in Wisconsin, although particularly here, but other places. And people are familiar with the nature of what occurred in that case. The events, now having listened to some of the events, particularly from the coroner, about the events of this case, there's similarities. And while the court has to be cognizant of issues relating to prior bad acts, that's not what this relates to. This relates to someone's demonstrating an interest in these, and there's numerous searches. So I'm looking at 10 through 35, and all of those relate to Jeffrey Dahmer, and I think that's relevant. Relevance, essentially, relevant evidence means evidence having a tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And I think this really goes to that intent element. The state referenced that. I also referenced yesterday the concept of motive, and while the state doesn't have to prove that, that kind of evidence often comes in. I'm satisfied for those reasons that this report is relevant to the extent that I haven't redacted it. 101, I'm also satisfied that my findings yesterday, as well as the additional findings I made today, remain the same. I'm going to allow that to be admitted. We've now voir dired these two witnesses, and I think the status of the case is such that we would bring the jury out and have Lieutenant Libera come back to the witness stand, because that's where she was when they left. Anything before we bring the jury in? Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. Then we'll bring the jury in. Okay, be seated. Ladies and gentlemen, welcome back. I hope you had a pleasant evening. We are ready for day 3 of the trial. I think the last witness that was on the stand, Ms. Liberta, if you could step forward, please. We'll get underway where we left off. And we're going to put you under oath again here in front of the jury.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God. Please have a seat and state your name for the record.
Jenna Luberta, L-U-B-E-R-D, and David, A, and Adam.
Okay, Mr. Lezay.
Ms. Luberta, I believe yesterday we discontinued when you were discussing your analysis of Ms. Schabusiness's phone and then a subsequent Google warrant obtaining the data from the phone. Can you explain the two different searches that you did on the phone and then on the Google warrant?
Sure. The first search I did of the phone, the cell phone device itself, was done on March 2nd, and that was just the contents of the phone. And then in discussing it with computer forensic analyst Danowski, she suggested that an additional warrant could be done for further information regarding the email addresses, the Gmail addresses that were connected to the phone, and that would have been a whole separate warrant and a separate search.
And when you were reviewing the phone itself, the extraction of the phone itself on March 2nd of 2022, did you note any searches related to Jeffrey Dahmer?
Yes.
Was there one? Was there more than one? How many?
24 total searches, such things like Jeffrey Dahmer, Jeff Boyardee, Jeffrey Dahmer's butt, Jeffrey Dahmer walking into court all sexy.
And did you subsequently look for that same type of information when you reviewed the warrant return from Google?
Yes.
And did you find essentially corroborating or similar information when you reviewed the Google search warrant data?
Yes, they were similar.
And, Your Honor, is Exhibit 99 available? And Ms. Luberta, what is Exhibit 99?
This is a Celebrate extraction report from the Google warrant return.
And what is contained in that exhibit?
Searched items.
And I would draw your attention specifically to items 10 through 35 on that. Are they numbered? Is that correct?
Yes.
And items 10 through 35, generally what is contained within those numbered items?
The searches that I had referenced earlier, Jeffrey Dahmer, Jeff Boyardee, Jeffrey Dahmer's butt, Jeffrey Dahmer walking into court, Jeffrey Dahmer walking in all sexy in court.
And is that an extraction report consistent with reports you've generated in the past or that you've seen generated in the past using this Cellbrite software?
Yes.
Your Honor, then I would move for the admission of Exhibit 99.
No objection, Your Honor.
Okay. Well, there were objections, but
Yeah.
those were noted, and I'm
Yes.
going to receive 99.
Yes, there were objections, but the court already ruled on that.
Then, Ms. Luberta, did you also, on March 2nd of 2022, when you were looking at the device extraction, did you do a search of photos on the defendant's phone?
I did a search of the device screenshots.
And what are the device screenshots?
So the device screenshots are screenshots taken by analyst Danowski of the photos contained in the Google Drive of the device.
And are those photos that she manually took herself based on the photos that were on the Google Drive of the phone?
Yes.
And did you review those screenshots?
Yes, I did.
And did you likewise see any photographs of Jeffrey Dahmer?
Yes.
Was there one, more than one?
Yes, there was more than one. Approximately 10, 12, maybe more.
And did those have a date associated with them?
Yes, they did.
What were those dates or date?
The date that I remember is February 12th, 2022.
And are those consistent with the dates of the searches that are referenced earlier in the Exhibit 99?
Yes.
Is Exhibit 102 available for the witness? Ms. Luberta, what is Exhibit 102?
This is a Celebrate extraction report of the screenshots taken by forensic analyst Danelski.
So this is a report from the device itself, is that correct?
Correct.
And does 102 depict the photographs of Dahmer that we had just discussed?
Yes.
Does it also contain photographs of Ms. Schabusiness?
Yes.
What is she doing in the photographs that are depicted in that report?
She's got a cell phone next to her head. There's a picture of Jeffrey Dahmer on the screen of the cell phone, and she's taking a selfie with it and smiling like they're taking a selfie together.
And what is the date of that photograph?
That was February 12th, 2022.
And is Exhibit 101 available for the witness? Ms. Luberto, what is depicted in Exhibit 101?
The photograph I just described.
Your Honor, I would move for admission of 101 and 102, and I would ask for permission to publish 101.
Same objections as before, Your Honor.
Okay, I'm going to receive 101, 102, and you can publish to the jury.
Your Honor, I think one of the jurors has his hand raised. Then, Ms. Luberta, is the screen now depicting Exhibit 101?
Yes.
And that's the photograph from Ms. Schabusiness's Google Photos from February 12th of 2022.
Correct.
Thank you. I have no further questions of the witness.
Okay, cross-examination, Mr. Freilich.
Ms. Liberta, you had talked to Taylor Schabusiness, correct? Did you talk to her?
No.
You found out that Detective Groff had spoken to her, correct?
Correct.
And did you find that? Did you find out that Ms. Schabusiness said that she was only able to
I'm
utilize
going to
her?
object, Your Honor. He's asking for hearsay information. He's not allowed to admit statements of the defendant through a witness. Only the state can elicit those things. And this witness also did not speak with Ms. Schabusiness herself.
I'll withdraw that, Your Honor.
Okay, questions withdrawn.
Did you find that a large portion of the data from this cell phone from Ms. Schabusiness was stored on the cloud?
No.
Did you put that in your report?
I don't recall.
This picture, when you were working as a police officer, you would see various images and photos on all kinds of people's phones, correct?
Correct.
People search and look at odd, bizarre things, correct?
Correct.
And based on your training and experience, people look at things for shock value sometimes. Is that fair?
I don't know if I can answer that question. Maybe.
This photograph in Exhibit 102 is basically a close-up picture of Ms. Schabusiness with a phone right by her, correct?
Correct.
You don't see any knives, you don't see any weapons, you don't see anything, correct?
Well, you see a picture of Jeffrey Dahmer on the phone.
But besides that, you don't see anything else, correct?
Correct.
And can you say that this photo was actually taken on Saturday, February 12th of 2022?
Yes.
These, did you see those other photographs of Jeffrey Dahmer and the other exhibits?
Yes.
Do you know when those photos were either downloaded or sent to the cloud?
I do not.
Okay, I have nothing further.
Redirect.
No, Your Honor.
Thank you. You can step down. State's next witness.
Judge, the next witness would be a statutory crime victim, just for the media.
Okay. I just indicate to the media, and they're acknowledging that the victim will not be shown on live stream.
Thank you. The state
And,
calls.
and I just want to clarify, the other media needs to be notified too. It's not just live streaming. Any other method of showing them anywhere is prohibited. Go ahead.
Thank you. The state calls Michael Thyrion.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God.
I do.
Please have a seat and state your name for the record.
Michael B. Thyrion.
Okay. The witness is yours, Mr. Saunders.
Mr. Thyrion, how old are you?
60.
And do you live in the Green Bay area?
Yes, I do.
Did you have a son named Shad?
Yes.
And is he now passed?
Yes.
How old was Shad when he passed?
24, 25.
Okay. Mike, I want to ask you about Monday, February 21st of 2022. Do you remember the day I'm talking about?
Yes.
On that date, was Shad at your residence?
Yes, he was.
Was that a residence that is in Green Bay?
Yes.
And at some point, did Shad get picked up by his mother?
I believe somebody came and picked him up.
Okay. And then I guess he left your home?
Yes.
Later in the evening, did Shad return?
Yes.
Was anyone with him?
Taylor.
And do you know who Taylor is?
Yes.
How do you know Taylor?
She's been at my place on half a dozen occasions.
And I guess what was Taylor's relationship with Shad, to your knowledge?
They were friends from middle school and high school.
So there have been previous times. I'm sorry.
That was my understanding. They were friends from.
And you mentioned there were previous times she was at your home,
Yes.
and you've had the occasion to speak with her?
Yes.
About what time of night did Shad and Taylor get to your home?
9 o'clock, 9 p.m. or so.
Was anyone else with them?
Yes.
Do you know who that was?
AJ?
So the three of them arrived. Did you see how they arrived to your home?
No, I didn't.
How long were they there?
Short time, and then they left.
Short time. Are you able to approximate how long?
15 minutes, and then they left, and Shad and just Taylor came back.
All right. So they came back for a little bit of time,
Yes.
and then did they leave again at some point?
Yes. And they said they were going over to Terrace.
So when was that second time that Taylor and Shad came back?
It wasn't long after they left. I'm going to say within 45 minutes.
During that second time that Taylor came to your home on February 21st, did you also have the chance to interact with her during that time period?
Small talk.
What was the nature of that small talk?
They were just they were looking for something. They were on some mission. I don't know. I was preoccupied with other things, and I don't even really remember what the small talk. Just asking.
Okay. Did you have the chance to kind of see Taylor's demeanor and how she was acting?
Yes.
Could you describe what you observed?
Nothing out of the ordinary. Just the way she was. She wasn't real speakative. Didn't talk a lot, but she was polite and respectful and always kind.
Was that sort of consistent with the prior occasions that you had contact with her?
Yes.
And then after they left, I guess that second time, did you see Shad again after that point?
No, I did not.
Thank you, Mike. I have nothing further.
Cross-examination, Mr. Freilich.
Mr. Thyrion, you live in Green Bay, correct?
Yes.
And your son, Shad Thyrion, was living with you in February of 2022?
Yes.
He stayed primarily with you, but sometimes he would go over to his mother's house on Stony Brook Lane. Is that fair?
That's correct.
Your son knew Taylor Schabusiness. They were friends, correct?
Yes.
They went to middle school together.
Yes.
They went to high school together at Bayport.
Yes.
On this particular date, Monday, February 21st of 2022, your son was at home
Yes.
initially, correct?
Yes.
Okay. And at some point, someone came to pick him up, correct?
Yes.
Do you know what time that was, sir? Like morning, afternoon?
I don't. I thought he left with Taylor and AJ.
Okay. And so they all three of them they left together?
Yes.
And then, how long were they gone before they came back to your house?
Wasn't long. Half hour, 45 minutes, something like that.
Okay.
I don't know. It wasn't long at all. I don't really recall. It's been a while.
Okay, that's fair.
They did come back. Just Taylor and Shad.
Okay. When they came back, did they get something to eat? Did they watch TV? Do you remember?
No, they said they were going back. They said they were going by Tara's house.
Okay. And do you know what time they left your house to go over there?
I want to say 10:30. Maybe not even that. I don't. I'm not sure.
Are you talking AM or PM?
PM.
And then at some point, is it your testimony that they came back again?
Yeah, that's when they left again. You know, they left at they were there at 9, and then they left for a little while, and then they came back, and then they left over to Tara's, and it was just her and Shad and Taylor.
Okay. When you saw Taylor Schabusiness on either occasion, did you talk with her about anything?
Just small talk.
Did she appear to be acting odd or bizarre?
No,
How about Shad?
no.
You said they were on a mission. Do you know, what do you mean by that?
I don't know. They just seemed like they were talking about, going somewhere or doing something, and I'm not really sure what was going on. I was preoccupied, and then they left shortly.
Okay, nothing further. Thank you.
Any redirect?
No, Your Honor, thank you.
Okay, thank you. You can step down. State's next witness.
State calls Detective Kevin Kemp.
Okay, you just step up right over here, detective, and turn and face her. She'll place you under oath.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God.
I do.
Please have a seat and state your name for the record.
Kevin Kemp, Kevin, Kempf as in Frank.
Okay, Mr. Saunders, the witness is yours.
Can you tell us how you're employed?
I'm employed by the City of Green Bay as a member of the Green Bay Police Department.
And do you have a current assignment with the Green Bay Police Department?
I am currently assigned detectives,
How long have you been employed in law enforcement?
just over 27 years.
And how long have you been assigned specifically to the detective division?
Currently since 2017.
Detective, I want to ask you about February 23rd of 2022. Did you become involved in a investigation of the death of Shad Thyrion?
Yes.
And I guess generally, what was your involvement in the case?
My involvement in the case was to assist Detective Groff in an interview.
And who did you interview?
We would have interviewed Taylor Schabusiness.
And for the record, do you see the person you know to be Taylor Schabusiness in court today?
Yes, I do.
Could you point out where that person's sitting and what they're wearing?
She would be sitting to your left. She's wearing a black suit coat with a multicolored shirt.
I'd ask the record reflect the witness identified the defendant.
It will so reflect.
Prior to the interview of Ms. Schabusiness, did you have the occasion to view her physical appearance?
Yes, I did.
Did you note any potential cuts or injuries to her?
Yes, I noted a cut to her left thumb and some superficial cuts to her hands.
And is that something that you subsequently documented in some way?
Yes, when I took photos of her, I also made sure I documented the cuts on her hands.
Been marked as exhibits 103 through 106. I'll ask if you recognize those exhibits.
Yes.
And what do you believe those to be?
These would be photographs that I took of Ms. Schabusiness's hands.
And those appear to depict Ms. Schabusiness's hands as you observed them in the interview room on February 23rd?
Yes.
And when, on February 23rd, would this contact have occurred? When did you begin the interview?
I believe I took the photos at approximately 6 a.m., and I think the interview started at about 6:30 a.m.
All right, so this was before the interview?
Yes.
All right. I'd move 103 through 107.
Any objection?
No.
103
Six.
through 107 will be removed.
Sorry, Judge, 106.
106.
And then I'd ask permission to publish as well.
Any objection, Mr. Freilich?
No.
You can publish 103 to 106.
Okay, and then it'll be in front of you, but also behind you, whatever's easiest here. So are we observing photograph 103 at this point?
Yes, you are.
Okay, and what does this depict?
This would be her left hand. There was a superficial cut in the palm below the thumb, and then you can see the cut on the thumb partially from a side view.
And then exhibit 104, is that what we're looking at now?
Yes, it would be. That would be her right hand and a superficial cut in the palm of her hand.
And then 105,
This would be the cut on her thumb, her left hand thumb.
and then 106.
106 is kind of a superficial cut on the index finger of the left hand.
Okay. And then at some point during the interview, was Ms. Schabusiness transported for medical care with respect to the thumb?
Yes, when she requested medical care, she was transported to the hospital. Before that, she declined.
Okay. And did you accompany her during that visit?
Yes, I did.
And I guess was there an attempt to have maybe the injury stitched up in some way?
Yes, we brought her up to get stitches or get medical treatment, whatever they felt was necessary.
And was that done ultimately?
She did receive medical treatment, but they did not give stitches due to the time.
What do you mean by that?
Apparently, it is if it's outside the 8 or 12 hour frame, the stitches can't be put in. It doesn't work.
Okay. And you had contact with Ms. Schabusiness about 6 a.m., you said?
Yes, so that's about when I started taking the photos.
When you, I guess, first encountered Ms. Schabusiness and were taking those photographs, what kind of clothing was she wearing?
At that point, she had like a black spaghetti strap top, I believe, on, and some black leggings, more tighter. spandex, I guess.
And were her clothing items subsequently collected by law enforcement?
Yes, they did an initial collection of the outside clothing, and then I also had those items of clothing collected from her.
Okay. And I guess was a female officer involved in collecting the inner clothing items?
Yeah, when the clothing is collected, she's actually removed from the interview room to a room where it's not recorded, and a member of the same sex would be with them when the items are collected.
And was that done in this case?
Yes.
And then the clothing items that were, I guess, collected from Mission Business, were those subsequently entered into evidence?
Yes, they would have been entered into evidence.
And that include the sweatpants or leggings or pants material that you talked about?
Yes.
After those photographs of Mission Business, did you participate in the interview of Mission Business?
Yes, I did.
And which other officer was with you?
Detective Groff.
During the course of the interview, did both of you sort of interject at some points and ask questions?
Yes.
Okay. Have you had the chance to review that February 23rd interview of Mission Business?
Yes, I have.
Okay. And that appeared to be fairly and accurately and consistent with your interview, as you recall it, of the defendant?
Yes.
All right. Thank you. I have nothing further.
Cross-examination.
Thank you. Morning, Detective Kemp.
Morning.
So on February 23rd of 2022, you were contacted by the lieutenant at about 4:13 a.m. to come and assist. Is that true?
Yes, that'd be approximate time.
Were you told to go over to 829 Stony Brook Lane?
No, I was requested to come to the station, that we were all going to meet at the station at that point.
And from the station, then you went to the house?
No, when I initially arrived at the station, I was asked to assist in interviews.
Okay. Did you go to the home at all on that particular day?
It would have been later that day that I would have went to the home.
You went to the home after the interview was taken?
Yes.
Tell me, when you got to the station, kind of like what occurred. What were the events that happened until you got into the interview room?
Basically, as I'm coming in, I called one of the supervisors to try to get a quick briefing, try to get some more additional information. When we arrive at the station, they give us a briefing of what is known at that time, and then job assignments are given out by our supervisors, and they ask us to do what needs to get done, and they start formulating a plan on how to go about the scene.
And what was your job assignment?
My job assignment was to assist in interviews.
Was it to assist Detective Ruff?
With Taylor Schabusiness, yes.
Okay. So when you got to the Green Bay Police Department or the station, was she there already?
She came in, I believe, about 5:30. She was brought into the interview room.
AM?
Yes.
Okay. And was there some things that had to be done before you started talking to her? Like taking pictures and things like that?
I believe Patrol did snap some initial photographs, and like I indicated, I believe they took initially her outer clothing items.
Okay. And then she was put into a suit?
That would have been after I took my photos. I took additional photos.
Okay.
And then she was, when we collected the inner clothing, because we were taking all of her clothing, she was placed into some type of clothing that we had, which was basically a Tyvek suit at that time.
Okay. It was early in the morning. Did Taylor Schabusiness appear to be tired?
She appeared to be no more tired than I was. I mean, she was able to talk, able to speak to me, understand.
How about her eyes? Did they appear to be odd, like where she was having difficulty seeing?
I wouldn't say that she had a hard time seeing. It didn't seem like that.
Did she have any slurred speech?
Not that I noticed.
When she was talking, was she making sense?
Yes, she was able to hold a conversation and answer questions and seemed to be coherent about what was being said and asked.
Was she calm?
Was she calm?
Yes.
Yes.
So then at some point, Detective Groff took some swabs, correct?
Yes, we would have swabbed her hands shortly after the photos were taken because there was some discoloration on her hands that appeared as it could be blood, so we decided to swab the hands.
And Mr. Saunders asked you about those exhibits, 103 through 106. Ms. Schabusiness did have cuts on her hands, palms, and thumbs, correct?
Yes,
And the substance that was on her hands, you don't know where that came from, if it came from the cuts or something else, correct?
I do not know, no.
And then, so then you and Detective Groff proceeded with your interview of Ms. Schabusiness, is that fair?
Yes,
Then at some point, you took a break, correct?
there were several breaks taken during the interview.
But then there was a break where you, where you had her go to St. Vincent's Hospital in Green Bay for some medical treatment of these cuts, correct?
Yes, I believe that was around 9:30 a.m. approximately. It was about 3 hours after the interview started, give or take a little bit.
So 3 hours later, approximately?
Yes, is when she asked for medical attention.
Did you accompany her to the hospital, or how did that work?
Yes, we had a MARC squad transport her up there. I rode up with her in the MARC squad, was in the room, or just outside the room at points, because I had to step out when they were changing her. And then when she was transported back, she was placed back in that MARC squad, and I rode back in that MARC squad with her.
Was Detective Groff with you when you went over to the St. Vincent's Hospital?
No,
You took her by yourself?
no, it would have been myself and another officer.
Okay. What time did you arrive back at the Green Bay Police Department?
I believe it was about an hour or 70 minutes later, off the top of my head.
Okay. Maybe around 10:30 or so?
10:30, 10:40.
And then you proceeded with further interview?
There was additional interview done.
Okay, I have nothing further. Thank you.
Redirect?
No, thank you.
Okay, thank you, Detective. You can step down. State's next witness.
State calls Detective Groff.
Step forward. Clerk will swear you.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God.
I do.
Please have a seat and state your name for the record.
David Groff, G-R-A-F.
Okay, then the witness is yours, Mr. Lezay.
Detective Groff, how are you employed?
I'm a detective with the Green Bay Police Department.
And how long have you worked with the Green Bay Police Department?
I have been with Green Bay for 27 years.
Do you have law enforcement experience prior to the Green Bay Police Department?
I do. I have 30 years of total law enforcement experience.
And what is your current role with the Green Bay Police Department?
I'm an investigator detective in the investigative division.
And how long have you been a detective with the Green Bay Police Department?
17 years.
And what were some of your other job duties with the Green Bay Police Department prior to working with the detective division?
I was a patrol officer for approximately 14 years. As part of my 17 years in the investigative division, I was also a narcotics investigator with the Brown County Task Force for 2 years. And since then, since coming back in 2010, I've been a detective.
Were you working as a detective with the Green Bay Police Department on February 23rd of 2022?
Yes,
Were you called in to investigate a suspected homicide of Shad Thyrion?
correct.
And what was your role in that investigation at the outset?
My initial roles was I arrived at the police department and received a briefing of what was going on, and I was informed that some family members of Mr. Thyrion were at the police department, and I was asked to interview Tara Pakinich.
And did you conduct that interview?
I did.
What was the purpose of having that interview?
Get some basic information as to observations that she had made
when she had last had contact with her son, who was on the residence, and basic information.
And once you completed your discussion with Tara, then what did you do?
I was then informed that Taylor Schabusiness was now present at the police department. I was asked to interview her.
And that interview, was that on the morning of February 23rd of 2022?
Correct.
Is that an interview that was conducted in a recorded interview room at the Green Bay Police Department?
Yes, it was.
Did the recording devices work? Is everything operating well?
They did.
Subsequently, have you had an opportunity to review the recorded interview of Taylor Schabusiness that occurred at the police department on February 23rd of 2022?
I have.
And do you believe that the recording of that interview accurately reflects your conversation with Ms. Schabusiness on that date?
It does.
And who was present during the interview with you?
Detective Kevin Kemp.
Was Ms. Schabusiness Mirandized prior to the substantive portions of the interview?
Yes.
Prior to moving into substantive questions with Ms. Schabusiness, did you make any physical observations of her?
Yes, I observed that she was wearing a tank top and some sweatpants that had dark colored, dark red substances on her, on the clothing that I was told by patrol that they thought could be human blood, as well as some minor staining on her hands.
And what did you do prior to interviewing her with respect to the clothing items and the staining on the hands?
I had the clothing items collected by a female officer, Officer Whitman, with the Green Bay Police Department, and I also took what we call buckle standard from Ms. Schabusiness using a buckle standard kit, and then I also took swabs of both her left hand and her right hand.
Could you describe the process that you used in collecting the buckle swab?
Yes, we have a kit that we use that contains 2 sterile swabs and some packaging material. So the kit is open. The swabs are used on one swab on one side of the cheek, one swab on the other side of the inside of the cheek, because that's where the buccal cells are located. Then the swabs are both placed into the packaging, labeled, and sealed.
And is that something that you have done routinely in the past through your work as a detective at the Green Bay Police Department?
Yes.
Did you follow your training and the department protocols with respect to the collection of that buccal swab?
Yes.
And can you describe for the jury what you did in terms of swabbing Ms. Schabusiness's hands?
Yes, I used, again, sterile swabs, and basically 2 swabs. One, I would put some distilled water onto the swab the hand, and then the second swab would be a dry swab, and then I would swab the hand. Place those both into packaging, seal them, and then I would do the same for the second hand.
Now, when you say you swab the hand, what portions of the hand are you swabbing?
I swab the entire portion, the palm, the top of the hand, and such.
And with respect to the buccal swab and the swabs of the hands, what did you do with those after you had completed them and packaged them and signed them?
They were placed into the evidence department at the Green Bay Police Department.
Is that something you yourself did?
Yes,
And did you maintain custody and control those items until they were placed in evidence?
I did.
We'll return to the specifics of the interview in a moment, but I want to move on. After you interviewed Ms. Schabusiness, about how long was the interview with Ms. Schabusiness on that date?
Well, it was over a period of time. There were several breaks. Let's see, maybe over a period of time of 6 hours or so.
And after you conducted your interview with Ms. Schabusiness, what did you do?
At one point, I did go to the scene briefly and just provided some information at the scene. I believe I also talked again with Ms. Pakinich because I had some follow-up questions that came up during that interview with Taylor Schabusiness concerning if Ms. Pakinich had in fact came down into the department or into the basement during a time period that Shad and Taylor would have been down there.
And I should also ask, while you're interviewing Ms. Schabusiness, are you remaining in communication with other investigators that are working on the case?
Yes.
And after the interview with Ms. Schabusiness, did you continue to stay in contact with other investigators about different aspects of the case?
Yes.
Subsequent to the February 23rd interview with Ms. Schabusiness, did you meet with her again for a second interview?
Yes.
And when did that take place?
February 28th, I believe.
And where was that interview?
That was also at the Green Bay Police Department in an interview room there.
Is that an interview that was also recorded?
Yes.
Was Ms. Schabusiness read her Miranda rights prior to that interview as well?
Yes.
And did she agree to speak with you on the 28th?
She did.
And who was present with you for that interview?
Detective Phil Scanlon.
Have you since had the opportunity to review the audio-video recording of the February 28th interview with Ms. Schabusiness?
I have.
Does that recording accurately set forth what you recall from the interview itself?
Yes.
Is the quality of the audio the same in that one as it is in the 23rd?
No, it's not. The quality of the audio in the second interview was a little less, than it was a little harder to hear.
Is there a reason for that?
The microphone in that particular room was not as sensitive as at other rooms.
And again, we'll get into the specifics of that interview, but I want to move into subsequent aspects of the investigation prior to doing that. At some point in time after the interview, did you assist in this investigation in other ways?
Yes.
What was the next thing that you recall doing after meeting with Ms. Schabusiness on the 28th?
Several things that I did was, one of the things that I did was I reviewed the evidence that was taken throughout the course of the investigation and chose several items that I wanted to send to the Wisconsin State Crime Lab for further analysis.
Is that generally how the process works with your department and the State Crime Lab? Is that the detectives select the items that will be sent to the State Crime Lab?
Yes.
And when you're deciding to send items to the State Crime Lab, are you aware of submission guidelines that the Crime Lab has?
I am.
What generally are the submission guidelines with respect to serious crimes such as this?
In these types of crimes, they ask that the first submission of evidence be limited to 10 items.
And did you send 10 items to the lab in this instance?
I did.
And when you were trying to select which items to send to the lab, what considerations did you have?
I took several considerations. There was quite a bit of evidence taken in this case. However, I was aware that there was at least two different scenes where evidence was collected, one being on Stony Brook Lane, the other being at Eastman Avenue, in which I had been information that Taylor and Shad had been at both residences. Also, I was aware that several knives had been found in the basement on Stony Brook Lane that were covered in what appeared to be human matter. And my concern was that was Shad's blood and tissue, so I wanted to confirm that. So I took the one knife that I chose was the bread knife, so to speak, that she had used mainly to dismember the body, according to Ms. Schabusiness, and that had been found in, I believe, the Jimmy Choo bag in the basement. So I chose that knife as particular for testing. There were several other knives located in the same areas, but I just decided to take the one knife. I also decided to send swabs that I'd taken from her hands to see if that was, in fact, DNA from Shad on her hands. I know hers blood. I also chose the swabbing from what was a res substance in the apartment and the bedroom of Taylor Schabusiness' apartment, A, to determine what that substance was, if it was blood, and also to determine if it in fact did belong to Taylor or Shad, so he could be linked again to that particular residence.
And then do you recall the other items that you sent to the lab in this case?
The other items that I had sent also was a the swab, the oral swab that was taken from Shad from the autopsy, and I had the penile swab that was taken during autopsy from Shad, and I also asked one of my forensic evidence techs to swab the dildo, and so I had the dildo swab, and I sent that also to determine again if any of their individuals whose DNA was on any of those items.
And how about any of the clothing items that were taken from Ms. Schabusiness? Did you send those to the lab?
Yes, I believe the sweatpants were specifically sent in.
And did you also send the known control buckle sample from Taylor to the lab?
Yes.
In addition to making the decisions regarding what evidence would be sent to the lab, did you participate in any search warrants in this case?
I did. 4 separate cell phones had been located during the course of the investigation, 2, I believe, at the Stony Brook in the basement, and 2 in the bedroom on Eastman Avenue. So I wrote a search warrant requesting that all 4 cell phones' data be extracted.
And did you have opportunity to review the extraction from any of the cell phone devices that were seized and searched with a search warrant?
I did.
Specifically, there's been some discussion already about Ms. Schabusiness's primary phone. Did you have an opportunity to review the Cellbrite extraction from Ms. Schabusiness's device?
Yes.
And is that something that you have done regularly in the course of your duties as an investigator with the Green Bay Police Department?
I have.
You're familiar with the Cellbrite program, how it works, and how to navigate it?
Yes.
In particular, when you were searching Ms. Schabusiness's device, what types of information were you interested in?
What was the type of data that was being accessed or used, or photos that were taken during the time period up into the date of the homicide? And you could do what they call a timeline report, and basically it will put in chronological order every single time the phone is accessed or a photo is taken or there's a phone call, there's a text message. So I looked at that timeline into the days preceding the homicide. And it also records anytime a phone will connect to a Wi-Fi network. It can specifically say what Wi-Fi network that phone had accessed. And I found that to be interesting in this case.
And what was important about that Wi-Fi access? We'll touch on that first. What's your purpose in knowing where the Wi-Fi connectivity exists here?
It helps put a location as to where exactly that phone was during a specific period of time.
Now, when you say Wi-Fi connectivity, can you explain a little bit for the jury about how that process works, where the device connects to the Wi-Fi?
Well, everybody has a Wi-Fi. I should say mostly everybody has Wi-Fi at home, and everybody has a router, and that router has a specific title to it. You know, it could be a self-made name, or it could be a name that is provided by the manufacturer. And so then, you know, when you look at your phone and you want to connect to somebody's Wi-Fi, you ask them, what's your Wi-Fi name? And they'll say it's, Graf family, whatever, and then you were able to connect to that. And so in looking at that, I was able to determine that over the course of several days, there was 2 specific Wi-Fi routers that phone had been accessing.
During the course of the investigation, were you able to obtain the name of the Wi-Fi router for the Eastman Avenue address where Ms. Schabusiness resided with Mr. Tomes?
Yes, I had personal contact with the owner of the occupants, Mr. Tomes, and he informed me that he had used AT&T as his service provider and provided me with the Wi-Fi name.
And similarly, were you able to get the Wi-Fi name for the Stony Brook residence as well?
Yes, I talked to Ms. Pakinich, and again, I was informed that the Spectrum was their internet service provider and provided me with their name also.
And then were you able to look at the extraction from Ms. Schabusiness's device and create a timeline for when that particular device was utilizing the respective Wi-Fi networks that you discussed?
That is correct. This is an extraction report that I completed from the data found in Taylor Schabusiness's cell phone.
And what specifically is addressed in that particular extraction report?
In this particular one, it is a timeline in terms of network usages, in terms of what Wi-Fi the phone was accessing, and it provides dates and times.
And using that report, are you able to then determine at what times the device is utilizing which of the routers?
Yes.
And what is the significance, or what did you glean from that report then with respect to the dates and times?
Well, I know that on February 22nd, 2022, starting at 12 a.m., it was utilizing the Wi-Fi from the Eastman Avenue address. And there's several entries over the course of time from midnight all the way up until (4 a.m.), and it utilized the router of ATT5 FTC9D E-Edward, which I had confirmed was the same name of the router from Mr. Thalm's apartment on Eastman Avenue.
At some point in time in the early morning hours of February 22nd of 22, does the phone connect then to a different Wi-Fi router?
Yes. Starting at approximately 6 a.m. on February 22nd, 2022, all the way through 10 a.m. or so. Oh, no, I'm sorry. Yes, well, 10 a.m. approximately. It was the My Spectrum Wi-Fi, which then again I had confirmed that was the Wi-Fi router at the Stone and Brook Lane address.
Now, did those, in order to have the phone connect to the particular Wi-Fi device, does that mean that the user necessarily has to be utilizing the device to do something specific?
I don't believe so, no.
There are certain programs that simply run in the background that are searching for, trying to connect to the Wi-Fi?
Yes.
And that doesn't necessarily give you a specific time frame, but does give you general time frames for where Ms. Schabusiness might have been at, Ms. Schabusiness's device might have been at certain points in time.
Yeah, I would say that is accurate. It's not specific, but it does give you general timelines, yes.
I think you mentioned earlier you were also looking for photographs in the timeline right around the time of the homicide. Is that correct?
That is correct.
Were you able to note any photographs that were relevant to your investigation in this timeline?
Yeah, I noticed that on February 22nd, 2022, approximately 12:56, 12:57 a.m., several photos had been taken of Shad Thyrion.
And those photos were present on Ms. Schabusiness's device, is that correct?
That is correct.
And they have very specific date and time stamps?
Yes.
Your Honor, I'll object to 108 and 109. They're similar, but some of the photos on one of the exhibits are more like thumbnail, and then the other one is the larger one. But we already have pictures of the alleged victims, so I would argue duplicity.
Okay, let me see the photos. So your argument is duplicity?
Yes.
Well, I've taken a look at 108 and 109. They're different. Certainly there's thumbnails on 108, which are smaller. Those photos, actually each one of them are different slightly. And there's some other data on 108. So I'm satisfied that I'm going to overrule the objection, and you can proceed.
And what is Exhibit 108 again, Detective?
108 is another extraction report documenting 5 photos that I had found in Taylor Schabusiness' cell phone.
And what's depicted in those photographs?
All photographs are of the head of Shad Thyrion.
You say these are in-life photos of him, is that correct?
I'm sorry?
These are photos of him while he is still alive, correct?
That is correct.
And 109 depicts what?
109 is a full photo of one of those particular photographs described.
And again, what is the date and time of the photographs in Exhibit 108?
February 22nd, 2022, one at 12:56 a.m., another at 12:56 and 57 seconds a.m., another at 12:57 a.m., another at 12:57 and 12 seconds a.m., and the fifth at 12:57 and 18 seconds a.m.
Have you, as part of your investigation in this case, had an opportunity to review photographs of the 2 residences, the Eastman residence and the residence on Stony Brook?
Yes.
Based on your review of those photographs and then the review of Exhibit 109, are you able to ascertain where that photograph was taken?
The photographs just described, the background is the same as the bedroom on Eastman Avenue.
Is that also consistent with the timeline that you noted from the Wi-Fi usage?
Correct.
That the phone would have been utilizing that device around that time?
Yes.
I would ask for permission to publish 109, Your Honor.
Okay. You can publish 109.
Is the screen now depicting Exhibit 109?
Yes, it is.
Thank you. Detective, I now want to return to the interview and specific conversations about what Ms. Schabusiness told you on February 23rd of 2022. First of all, can you start by describing, what her general demeanor was when you met with her on the 23rd?
Well, characteristic as a calm demeanor, no outbursts, no mood swings. She was quite frank in being able to answer questions and ask questions.
What was your ability to communicate with her?
Very good. She was able to answer my questions and with no issues.
You indicated that you had previous work as a narcotics investigator. Have you had an opportunity in the past to meet with and interview suspects who are under the influence of drugs?
Yes.
Did you note anything in Ms. Schabusiness's behavior, demeanor, or appearance that would have suggested that she was under the influence of narcotics at the time you were meeting with her on the 23rd?
I did not.
Can you describe going into that interview, how much information you had about the specific acts themselves.
At the particular time, I had very little information. What I knew was that Shad Thyrion had been found in a bucket in the basement, and also just the information that I had from talking to his mother about who was he last seen with and his last known whereabouts, according to her.
In terms of the specifics of what happened to Shad and where the rest of his body was, is that information that you knew prior to beginning the interview with Ms. Schabusiness?
No.
The information about Shad and what happened to him and where his body was, where did that information come from?
Ms. Schabusiness.
And to begin your interview, how did you begin asking her about the specific events?
I basically stated to her that with the information that I had, and the information that I had at that point in time was that Shad's head had been found in a bucket in the basement, and that she at one point had been with Shad. So I just asked her if she could tell me what happened.
And was she able to describe to you what happened?
Yes.
What did she say with respect to how Shad was killed?
How Shad was killed?
Correct.
She said that Shad had produced a chain, like a dog collar, and put it around his neck. Initially, it sounded like it might have been some sort of foreplay, but it got to the point that she started to strangle Mr. Thyrion and just continued to do so, according to her, for several minutes until he passed away.
Did she, as it relates to the strangulation, did she make any statements about her observations of Shad as she was choking him with that chain?
Yes, she stated that his head turned purple. He started to, I believe, blood coming out of his mouth. His tongue was protruded, I believe.
Did you ask her whether she chose to stop at that juncture?
I did.
And what was her response?
She stated that she wanted to continue to see what happened.
And did you ask her whether or not Shad had struggled at all when she was choking him?
She said that he did.
And what was her response to that?
My understanding is that Shad had been laying on the bed, prone, face down, and she was on top of him. And so she was able to choke and control his body, so to speak, that even though he was struggling, she was able to still maintain control.
Did you ask her about how she felt about what she had done?
Yes.
And what were her responses?
Objection, relevance, yes to elements, Your Honor.
I think they're certainly relevant as to her intent.
Overruled.
Her response was that she liked it.
Had she also at some point expressed some remorse or that she didn't necessarily want this to happen?
Initially, that was some of her comments, was that, it hadn't intended, but once she started to strangle Shad, that she found that she could enjoy it, and so she kept on strangling him.
Had she expressed anything to you about her use of drugs at the time of the offense or immediately prior to the time of the offense?
She said that approximately 2 days prior to the offense that she and Shad had been smoking methamphetamine.
2 days prior to the offense or 2 days prior to the interview?
I'm sorry, 2 days prior to the interview.
Did she mention anything to you specifically about drugs or paraphernalia that might be found in the residence?
Yes, she stated that there should be a pipe and some methamphetamine in the basement on a dresser or an entertainment center of some sort.
Did she express any knowledge about the location of the chain or chains that were used to strangle Shad?
Yes, she stated that there was 2 chains. One would be the same location area as where the methamphetamine was used, and another would be in another table in the basement.
And now, I think I asked this earlier, but you're in communication with the investigators who are on scene during the course of this interview, is that correct?
Correct.
And the information that Ms. Schabusiness is providing you about where things are located and what they might see in the basement, is that being confirmed by investigators on scene?
It is.
And the information that she's providing you, is that accurate with what they're observing?
Yes.
After the strangulation itself, what did Ms. Schabusiness tell you that she did with Shad?
Well, initially, we were aware of Shad's head being in a bucket, but we were not aware of where the rest of his body had been located. So there were several questions pertaining to where his body was located. And Ms. Schabusiness' response to that, it was still in the basement. Then she went on to explain that she, in fact, had dismembered Shad's body and placed the various body parts into several bags or a tote down in the basement.
Was she able to describe in detail the things that she did to dismember Shad?
Yes.
And again, are you matching that back up with information from investigators at the scene?
Correct.
Was she able to actually describe the types of bags or types of containers where she's placing body parts?
Yes.
And again, is that consistent with what investigators are later finding on the scene?
Yes.
Did she talk to you about how she dismembered or what she used to dismember Shad's body?
Yes, she stated that she used knives that she obtained from the kitchen of the residence.
Was she able to describe to you where those knives would be located in the basement?
Yes, she described that the knives would be in the same package or the bags that the body parts were also located.
And again, is that consistent with what investigators were finding on scene?
Yes.
In addition to the dismemberment, did Ms. Schabusiness discuss with you anything else that she did with Shad's body after she had killed him?
Yes, she did.
And what was that?
She described how she had sexual contact with the body in terms of playing with his penis. Also, she described that she had a dildo that she placed into Shad's mouth and to his anus, and that she also had cuddled the body.
Did she discuss performing oral sex on Shad?
That's correct.
Did she indicate about how long she had cuddled or played with Shad's body?
She indicated that, it was, I don't exactly recall how long of a period of time, but there was a period of time, I believe shortly before or after the start of dismemberment.
Did she talk to you at all about trying to clean up the scene or what she was doing with the blood during the course of the dismemberment?
Yes, I've been made aware that there was not a significant portion of blood found in the basement that would have been consistent with dismemberment. So I asked her about that, and her response was that she mainly used like the bucket and or the blue tote to capture a lot of the blood, and eventually did dispose of some of that into the shower in the basement. She also did talk about the dismemberment and the removal of body parts, and in fact that there should still be a portion of Shad's lower limbs, like legs, in the van that she had been operating. So she did describe how she did remove at least a couple of his body parts during the course of dismemberment. And when I say move, I mean out of the residence itself.
And did she specifically give you a reason for why she ultimately left the residence on that day?
She told me that she had heard lots of walking around upstairs, and she also heard that she thought she had heard some shots being fired in the area. In this call, there's some concern, and she just decided that she had needed to leave at that point.
Did she discuss with you what her intention was with respect to Shad's head?
One of the first things that she did say was that she did like the head, and that it was her intent to take the head as well as the genitalia that was in a bucket with her. That's why she specifically placed those items in the bucket. But she did mention that she had left the bucket by the stairs. And I don't know if she intentionally wanted to do that, but there was talk that it was her intent to take the head and the genitalia with her also.
At some point in time, do you discuss with Ms. Schabusiness a specific timeline for the events leading up to that evening?
Yes.
And what does she tell you about the timeline of her whereabouts leading up to this event?
2 days before the 21st, that Monday, is when she was at the apartment on Eastman Avenue with her friend AJ. They decided to go pick up Shad, which they did do. They were turned back to the apartment. At one point, they also did visit Shad's father, Michael Thyrion, and then also again returned to the apartment at Eastman Avenue, where they stayed there for a while. At one point, AJ left, and then Shad and Taylor then returned to Shad's mother's residence on Stony Brook Lane.
And the information that she's providing you with respect to the timeline, is that information that also was consistent with the other aspects of your investigation?
Correct.
Had she mentioned to you while you're discussing the timeline use of narcotics or controlled substances?
While they were in the apartment on Eastman Avenue, they did use, her and Shad smoked methamphetamine, and she also indicated that Shad and AJ smoked marijuana.
Had she talked to you about what vehicles she was using to travel around to these locations?
Yes, the entire time she was using her roommate, Mr. Dom's gold Chrysler minivan.
Did you ask her whether Mr. Thomas had given her permission to use the vehicle?
I don't know if I asked her specifically that question, no. But it was under impression that she was using it. At the time of the interview, I was not sure. I later found out that Mr. Thomas claimed that she has used it in the past, but not necessarily was supposed to use it that night.
Did she tell you any information about whether Mr. Thomas was involved in this crime at all?
He was just at the apartment the entire time, sitting in a chair basically, and according to her, he wasn't even aware of what they were doing because he was behind him or in the bedroom.
When you were speaking with Ms. Schabusiness, did you ask her about whether or not anyone else had come down into the basement at any point in time?
Yes.
And what did she say?
So then she stated that she believed that Shad's mother had come down with a cat.
And did she discuss actually having any interaction with Shad's mother at that time?
She said that she did not, and I asked Taylor if she thought that the mother had seen her, and she stated that she did not believe. So asked her what she did, and Taylor just stated basically that she kept quiet and was off in the like the finished part of the basement.
So I want to draw your attention then to the second interview with Ms. Schabusiness that occurred on February 28th, is that right?
Correct.
And that was also a recorded interview?
Yes, it was.
And you advised her of her Miranda rights prior to that interview?
I did.
And she waived those rights and agreed to answer questions?
Yes, she did.
Did you make observations of her demeanor generally on that day?
I would classify it as being the same, calm, was able to answer questions appropriately, no outward signs of any disruptions or mood swings.
And was she able to understand your questions and answer them appropriately?
Objection calls for speculation, Your Honor.
Overruled.
Leading? Argument for leading?
Pardon?
Argument for leading, alternative argument, Your Honor.
Overruled. Go ahead, ask another question, Mr. Lezay.
Thank you. And what was generally the purpose of conducting that second interview with Ms. Schabusiness?
Conduct some follow-up questions concerning that we had that came up during the course of the investigation concerning like her disposition of the body, what were her intentions of what they're doing with the body, and her cleaning up after herself.
And what did she say with respect to the purpose of dismemberment and then the cleanup?
According to Ms. Business, the purpose was that she realized she needed to remove the body from the residence so that she wouldn't be caught, and Shad was more that she could carry just in terms of being a whole body. So the dismemberment and putting them into bags was to facilitate with her being able to remove the body from the residence.
And did you discuss with her the attempts to clean up the residence as well?
Yes, and Detective Scanlon had been an integral part of the search of the residence itself, so he asked her several questions about cleaning up because he had observed some markings or on the cement down area that had been underneath the bed, as well as there was a squeegee in the shower down in the basement, in some items such as Clorox, wipes, and so he asked her about that, and she stated that yes, she did use the cleaning materials such as the Clorox wipes and the spray to clean up several of the areas in the basement, as well as using squeegee to clean up the shower area, and subsequently placed these wipes in the same bags that the body parts was found, which again is consistent with what Detective Scanlon had found.
And Detective, I think I asked you these questions already, but have you had an opportunity subsequent to the interviews to review the recorded interview from both the 23rd and the 28th of February?
Correct.
And you do believe that the recordings were accurate and consistent with your recollection of the interviews?
They are.
Your Honor, at this point, I intend to show significant portions of the first interview and a smaller portion of the second interview, but it's about an hour and 10 minutes in length for the first interview and about 4 minutes for the second, so I think now would be a good time to take a break.
Okay, ladies and gentlemen, we started a little bit late, but nonetheless, we're going to be watching a video, so I think what we'll do is take a break until 10:20. It's now about 8 minutes after 10. And with that, all rise for the jury. Anything to bring up before we break, Mr. Saunders?
No.
Mr. Fraley?
No.
I'm assuming there's been referenced it earlier, a stipulation as to what pieces of this video you're going to show.
The state's understanding, the specific times were provided, a copy of the excise video was provided to the defense.
Your Honor, that's correct. We talked about this issue, so.
Okay, very good. We'll take a break until 10:20.
Thank you.
Oh. I think the parties would ask that the court read a modified version of JI 158. I have it here.
Yes.
Counsel agrees. It just addresses some of the obvious edits that will be seen by the jury, just so there's no adverse inference to either party.
You agree with that, Mr. Fairley?
Yes, I do. I've reviewed it.
Okay. Then I will not read 158. I will read this version.
Thank you.
There's nothing else?
No.
We'll bring the jury in. Be seated. Ladies and gentlemen of the jury, you are about to hear and view an audiovisual recording. The state, the defense, and the court have agreed on relevant portions of law enforcement's interview of Ms. Schabusiness that will be played at trial. Recordings are proper evidence, and you may consider them just as any other evidence. Listen carefully. Some parts may be hard to understand.
Judge, the state is about to play what has been marked as Exhibit 110. On Exhibit 110, there are a number of files. The files are both the individual clips from the videos, but then also one continuous video. The state intends to play the continuous video. I think there's about a 2-second break of a black screen in between the respective clips that are going to be played. For the record, the actual name of the file is February 23 interview hyphen trial, and then there will be another clip played for the second interview, and that file name is February 28th interview hyphen trial. So those are the specific files from Exhibit 110 that will be played for the jury at this point.
Very good.
Okay.
I hate this fucking outfit. Never in my life. I'd rather be fucking Taylor than honestly. Clean the fuck up. What are you doing?
So if you don't understand anything, please let me know. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to consult with a lawyer before questioning, to have a lawyer present with you during questioning, and if you cannot afford to hire a lawyer, one will appointedly represent you at public expense before or during any questioning if you do wish. And if you decide to answer questions now without a lawyer present, you have the right to stop the questioning and remain silent any time you wish, including during questioning. Do you understand each of these rights?
Yeah.
Yes. Realizing that you have these rights, are you now willing to answer questions or make a statement?
Yes.
All right, what time is it? Well, a few hours ago, police were dispatched to an address on Stony Brook to parents' house, Shad Thyrion. Do you know Shad? I know how do you know Shad?
He's my ex.
He's your ex-boyfriend?
Yeah.
Well, they found a kind of a disturbing stuff at the house there.
Oh, really?
Yeah.
Yeah.
A lot of blood. Basically Shad's head.
That's fucked up.
Yeah, it's pretty fucked up.
I know.
And then, so we know you were there at one point
Yeah.
with Shad.
Yeah.
But we also know you left. Now that van, is that your van?
No, that's my neighbor's.
Your neighbor's van?
Oh, the guy I was staying at?
Okay, so this, where did you go? Which place, where did the police get you? Was that on Eastman? Is that correct?
Yeah.
Is that where you live?
Yeah.
Okay.
I'm staying there right
Okay, is that your apartment?
now. No,
No. Whose apartment is it?
that man.
And who is that man?
Got phones.
Scott?
Phones.
Okay. So, that's his van?
Yes.
Okay. And so, did you leave from Shad's house and go to Scott's house sometime today?
Yeah.
Okay. Well, they found part of Shad at his house, his mom's house. Found his head. Where's the rest of his body?
It's there, inside his house.
It is in the house?
Inside his house.
Okay. Can you tell me what happened?
It's a good question because I blacked out during that time. But, I need time to, think.
No problem. Take your time, have some water. Do you think the body is still there?
I don't see why not. Unless it's just up and move, which it could have, you know.
Where do you think mine would be?
I was right there by the bed.
By the bed, you think?
Yeah, I was cuddling it by the bed.
You were what?
I was cuddling it by the bed.
You were cuddling the body with it? Oh, okay.
Was it just you and Shad down in the basement?
Yeah.
Was anybody else down there at any point in time? When do you think you went to Shad's house?
Shit. What was it, like 2 days ago?
Okay. Did you stay there the whole time?
Mm-hmm.
Okay. You start to remember now what happened with Shad? A little bit, or do you remember some thought?
Shit. Oh, I don't know. There's this chain thing, right? And then yeah, like I was playing around with it.
Okay.
And like we were smoking the bitch, right?
Okay.
And then I'm terrible at explaining things, so let's see here. And then here comes the chain, right? And then you put it around his neck. Well, we were like playing around and shit, and then I don't know, I was tugging on it, and then I don't know.
You say you were smoking a bitch, what would that be?
Ice.
Ice?
Ice.
Okay. Have you taken any other drugs tonight?
No, this is still from 2 days ago. I know my eyes are fucking tight.
Were you smoking the ice?
Yeah.
And how, on a pipe or someplace else?
The one that's on the counter, or on the table. I left the baggie there.
Did?
I did.
Where?
Green baggie, and there should be right on
Well, where exactly? Eastman or Story?
at Shad's.
At Shad's.
Yeah.
Okay. And you say, where was this place? Where would it be? In the basement or on the first floor or second floor?
Basement.
In the basement. And it was ice in a, and it was a basket, basically a window bag, type of little small plastic bag.
Crushed up.
Crushed up. And just you and Chad. And so there was a chain. What kind of chain?
It's the one that's on the same place as where the bitch and usually on.
Where would that be again, please?
I think it's on a dresser.
On a dresser?
Is it? Oh, is it on a dresser? I don't know.
I don't know either. I haven't been there. I mean, as best as you can remember. So you think that there could be a chain and the ice on a dresser down in the basement?
It's just weird. I got like a weird flashback from it.
But what happened?
Yeah, it's short. It was real short.
What did you see?
It's just I don't even know anymore. Like it was weird. I was riding him like a donkey, okay, and then like I think so. I think that's what was happening. I was pulling and then like I don't know.
Were you two being intimate, having sex?
It was getting there.
It was getting there. Okay. So would this be considered foreplay?
Yeah, it was. And then I don't know. And then I just didn't stop. I don't know why. I didn't stop.
You guys done something like this in the past?
Not like that.
Do you use manual strangulation during sex at all? Is Shad like that?
A manual strangulation? Yes.
He likes strangulation?
I don't know.
You know what I'm talking about?
Yes, he does. Yeah.
And you do too, or just him?
Both of us.
So when's the last time you guys had sex besides potentially sworn?
Mainly me, but like we didn't even get it. Like, I'm sorry, but we didn't even get it.
Okay, so you didn't, alright, well, when's the last time you did do it?
I mean, I played with him a little after. I have no idea, like August.
And what would you guys like to do? Is there a certain role playing that you did with Chad? Or was it just some sort of strangulation? How would you guys basically have sex?
Like, I just want to, yeah, and we go at it.
But does anybody like strangle the other person?
I like doing that a lot.
Alright, so you like being strangled, like having your airway, or do you like doing it to somebody else?
I like doing it to somebody else.
Does Shad like to be strangled during sex?
I have no idea. I think so.
Have you done it before with him?
Yeah, he does. He likes it.
Have you used what we call props in the past?
Yes.
What?
Well, like dildo?
That or rope or chain or underwear or anything?
Yeah. I shoved a dildo in his ass and mouth.
In the past or just recently?
When he was there, when he was on the bed. Yeah.
So obviously you said you smoked some ice. Do you take any prescription medications?
No.
You have any mental health issues we should be aware of?
I don't know yet.
Have you been diagnosed with anything officially? Because I know that Shad has some mental health issues. It's according to his mother. Since high school?
Yeah.
Where do you guys go to school together? Freeport? Okay. Did you graduate the same class or?
Yes. He didn't graduate.
You didn't graduate? Alright. So then you guys were boyfriend, girlfriend at one point? For how long?
2 years.
2 years?
2 years.
2 years?
2 years.
And this is right after high school or
No, during high school.
during high school? Okay. And what year did you graduate?
16.
2016?
Yeah.
So you and Shad date after high school?
We seen each other.
Okay.
We definitely seen each other.
Seeing each other, but were you officially a couple, so to speak, or was it just, did you still have sex with him?
I did it once.
Just once?
Yeah.
After high school?
Yeah.
So when did you start seeing him again? Recently?
He's my buddy. He's my homie. So like, you know.
Alright, so you've always been friends?
Yeah.
Okay.
Yeah.
So, how did you get over to Shad's?
The minivan.
The minivan? When do you think you went there? You remember?
2 days ago.
2 days ago? Okay. Did you stay there the whole time, or did you ever pick him up and go someplace, or then come back? Or
Stayed there the whole time.
how did you get in? Was Shad there when you got there, or Shad let you in? Or did you just walk in on your own?
He was there, we went in, got some shit, we came back, and then, methamphetamine, you know,
Ice.
and then, ice, and then we came back.
Okay, so you showed up at his place. Then you and him left.
Yeah,
And you went and got some time.
yeah, so then, we went, and, I picked him up, went and got some ice, and then after that, we went to, back to Scott's. We smoked,
Okay.
yeah, and then, I did his hair,
You did Shad's hair
Oh, yeah, I did him a little bit.
at Scott's?
Yeah, and then after that, I trimmed his face, you know, feeling good. We left, we went back to his mom.
Okay.
I was looking for some crack. I never got no crack.
Right. Okay. So you went back it was just you and Shad that went back to his mom's? Or did Steve come?
Steve?
Or Scott?
Scott, yeah.
I'm going to do that occasionally, and I apologize if I do get names sometimes. But
Alright, yeah.
did Scott did come with you?
Scott stayed at home the whole time at Eastman. That's his residence.
Okay. All right, so you and Shad
He
went back
is
to
not
his place.
involved at all.
Okay. So you and Shad went back to Shad's mom's house. How'd you get in? Did you see, was anybody home?
The door was unlocked. We went in.
What time do you think this was?
That's a good question.
Was anybody home? Did you encounter anybody? I understand his mom lives there.
Tara?
Taylor?
I don't know. Is that the mom's name?
Yes.
Damn, the head. I can't believe I let the head go.
Where'd you do the body?
The body's there. Yeah. It's,
So were you going to take the head somewhere?
I like that.
You liked it?
Well, you're gonna have fun trying to look for all the organs, but yeah, they're all dismembered.
Okay.
Yeah.
So you dismembered the body too?
Yeah.
And what did you do with the body parts?
Oh, they're in the house.
Somewhere?
They're like,
Basement, upstairs, downstairs?
absolutely in the basement. I was gonna bring them with them. And then, I know I forgot the head. I wanted the head.
Did you bring anything with you?
Yeah, it's in the van.
What?
It's in the van. It's, what is it? I don't know, a foot maybe.
The what?
I think it's a foot.
A foot
leg?
in the van?
A leg maybe. I don't know. I'm like, I'm gonna bring it all, and then I'm like, man, this is messy. So then I just left it. I got lazy.
Okay.
I got lazy, and that's what I did. So I'm like,
Okay. So there's going to be maybe a foot or a leg in the van. And then,
yeah.
what did you do with the head?
I forgot that was in the van, so yeah.
What did you do with the head?
The head, I put it in that bucket, that black bucket,
Black bucket?
with the blanket on top.
Okay.
Actually, I can't really-
And then where'd you leave it?
Leave the head? The head's still in the bucket. It's right by the stairs.
By the stairs? Okay. How did you dismember his body then?
Knives.
With what?
Knives.
Knives? Just more than one knife?
About 4.
Where'd you get those from?
Kitchen. So I couldn't find mine and I wasn't sharp enough.
You weren't sharp?
No. It was alright. Bread knife works good.
Bread knife?
A bread knife works good, yeah.
Really?
I had to use what I used, so yeah. I got lazy last night, so
Where would these knives be now?
they're in with all the organs and all the body parts.
And where was that?
In the black bag. It's in the black bag
In the basement?
it's in the basement. They're all in the basement. I never left the basement. I just went up the stairs.
They get so all the body parts and knives will be in a black bag. What kind of bag?
Black zipper bag next to a pink and black Under Armour backpack. That Shad gave me. So I left it there.
Is it a big bag?
Medium.
What kind of stuff would you normally put in this bag?
Put anything in the bag.
Well, I mean, is it a trash bag or is it a garbage bag or is it, you know what I mean? Kind of bag?
Backpack.
No, the bag that has the body parts.
I have the backpack.
That's a backpack?
Backpack.
Is it a big one?
Yeah, the other one's like a little duffel, black duffel.
Okay. So you, at one point, did you bring these bags with you? Or were they already there?
I was gonna, but I got lazy. And
Right, you're gonna bring them with you when you left. But were the bags there when you used them? Or did you bring them with you with Shad? Or did you just find them there?
they were there, and I found them there, and I emptied them out and put them in there, and I was gonna bring it, and I got paranoid, and then I got lazy, and I never get paranoid, but this time it was just like, I think it was the dope.
So, did you want Shad to be dead?
No, it was out of random. Like, I wasn't expecting that, and it kind of threw me off guard. And it was in an open place, that. You went in the basement, right?
Mm-hmm.
It's pretty open.
Well, I haven't done it, but is it?
It is. So, like, it was weird. It was really weird. And you open the door to the outside, and you go down the stairs, and it's right there. Like, you can see everything. I was ready to go down the stairs.
And so, where did you get the chain?
I don't know. He pulled it out of his pocket.
He pulled it out.
He had 2 of them, one for me, one for him.
And can you describe them to me?
Chain link.
Chain link?
Chain link and silver.
Silver? Okay. And what size? Was it like a dog chain or a large lock type of chain? You know
They're
what I'm
like
saying?
this big. And then, and then it has O-ring.
Mm-hmm. So silver chains.
Yes.
And he had 2 of them. And what'd you guys do with them?
We put them around their necks.
You did. Okay. And then what were you doing while they were around their necks?
I was strangling them.
You were strangling them.
I was having fun with them, and then
Was their clothes on or off?
he had his shorts on.
You had shorts on. How about you?
I don't know. I didn't really care at the time. But,
Did he ever put the chain around you? Put the chain ever around your neck?
I put it around my neck.
Do you have any marks or anything?
You didn't get the chance to strangle me.
Yeah, just see. You didn't get a chance to strangle you?
No.
Was that, he was going to though? Or was that part of the?
Yeah, I thought that was the thing, and then like, I don't know, I just went a little crazy.
So when did you realize that Shad was not alive anymore?
You know, his face turned purple.
Okay.
He was coughing up blood, and he was pissing.
He was pissing himself. His face was all purple.
I still didn't stop. I don't know what was going on. I don't know the blood, and then
So his blood was coming out of his
I kept on
mouth?
feeling his heartbeat. Hearing his heartbeat.
I'm sorry?
Hearing his heartbeat spread.
Okay. Did you hear it stop?
No. Heartbeat. No.
Okay.
No.
So
I'm gonna try to do that.
did you figure he was dead then?
Yeah.
And what did you do?
Played with him a little bit.
Did you try to call his mom or dad or anybody else in the house? You tried calling an ambulance? Why not?
Attacked him before. So, yeah.
So do you want him? You want him to die or he did? I'm trying to understand.
I didn't want him to die, actually.
But he did.
He's my buddy, but like it happened.
Happen again. But then, did you feel a need to try to help him? Stop choking him or get an ambulance? You didn't feel a need to do that?
I don't know why, I just it happened so fast.
So then after you realized he was no longer, he was dead, his face was purple, he said his blood was going out of his mouth, what'd you do?
Clean him up a little bit. Sure. And then, I just played with him like a little,
You said play with him, what do you mean?
played with his big,
Okay.
like I put him up over the bed, and then, such with it.
Okay. And you had him on the bed? What kind of bed? Was it an actual bed or just a mattress or what? So then you had sex with him?
Yes. And I had a dildo.
Okay.
I played with him too.
What'd you do with the dildo?
And I just cuddled him and hugged him.
What did you do with the dildo?
I put it in his mouth, put it in his ass.
Okay.
Put it back. Put it back.
Where was this back? Where'd you put it back?
It's like in the, it's like on the wall next to the body, right? And then
Is it in a bag or on a shelf
it's
or?
in a wooden box.
Wooden box. Okay. And what color was the dildo? Peaches. So
Pink.
you had sex with him. You said dildo on. You said you cuddled for a while. And then what? You cuddled him. Where were you, on the bed with him?
Yeah.
Okay. So you cuddled his body, and then what did you decide to do?
Oh, Because like before, like I felt for his heartbeat, but then I still felt his heartbeat, right?
You did?
I did.
You felt it?
Yeah, so I kept on pulling more and more and more, and I went back and it's almost like he wouldn't die. I was like, dang. And then he was like rebuilding in the muscle, man. I don't even know. It was crazy. And then I don't know.
Just before you had sex with him?
As well.
While you're having sex with him?
We never had sex, but when we were getting there, I was just choking him.
I understand that. You said that she played with his penis
Yeah.
after he was dead.
Oh yeah.
Was it erect?
It was half. It was half.
Yeah. Did you,
Even
what did you do
after,
with his penis?
I cut it off.
Did you ever place it in your vagina or any of your body parts?
No, I just.
You didn't use it as a dildo or anything? Okay. So you're saying then you're like choking on and stuff, and was he struggling at all?
He has big neck muscles.
Okay.
He was good.
Were you trying to fight you? Sometimes people have a flight or fight, you know what I mean? The reaction that something happens, so they try to grab them.
Yeah, he did. And then
He didn't, or
no, he did.
did you get hurt at all? I see, you know, you had that cut on your thumb. How do you think you got that?
Oh, that was dismemberment.
How was this not?
That was a lot. Yeah, I got lazy in that process right now. So.
Did you use any other devices besides knives? Just those scratches on your arms and stuff, were they from him?
Oh no. I was.
And how did you get them?
So this one I did by myself.
Oh,
This one I probably did by myself. This one I probably did by myself.
so they weren't
That one?
him trying to grab you or anything? Did he try to grab you at all with his hands? Yeah. So the blood on your hands, would that be Shad's blood?
Oh, probably, yeah. I'm telling you, I got super lazy tonight.
How come?
I really don't know. I blame it being on drugs and then the come down that I'm coming down off of.
How many times do you think you've done this
I never
before?
do drugs. Like, I barely do drugs. I do drugs, but then, like, once in, like, a few, like, weeks. Not even like that. Like, months go by and then I'll do drugs.
I see. And where did you dismember this? In the basement, right?
Because I was looking for Donna and, yeah.
You do anything particular with the head or the body? What did you do with the blood? What happened to all the blood?
It's still in there, still in the tote. I mean, with the pill.
The pill.
There's a shower in the basement. You go in the next side over and I just dumped it out into the drain. There's probably still blood there.
Where did you dump it? The bucket?
Yeah. Well, I drained his head. Well, like, after I sweated his blood, I put it in the bucket, but then there's still blood in this bucket because it's coming out of the head. Should have took the brains out, but I didn't do that. And then
So you cleaned his head in the shower and then dumped the bucket?
I should have cleaned his head in the shower. I should have polished it up, but, yeah.
Okay.
I like that.
And what did you use to scour that head again?
The knives.
The knives.
Yeah.
Well, you said one was a butter knife. What kind of knives were they then? Big knives or knives? Butcher knives?
They were the kitchen knives.
A butcher block?
There was two like little knives there. And then they were like probably 4 inches. And then the other ones, they were probably like 6-inch knives.
And where were they in the
One was
kitchen?
a steak knife, one was a bread knife.
When you say
wanted
bread
bread
knife, is that
I
like a
wanted-
serrated edge on it, or is it a flat edge on the bread knife? You know what I mean by serrated?
It's great.
And where were these knives in the kitchen?
They were in, shit. They were right next to the oven.
Were they in like a knife holder thing, or in a drawer, or where?
They were in, if you know what I'm talking about, when the,
Yeah, that's some holder that put the
yeah,
knives
that's the one right there, like it was in the,
by the oven.
by the oven, next to the back oven. Right in the oven. I really like that, though.
How come you didn't bring it?
That's how messed up my head was. Like, I was really messed up. Like, I don't know what was going on. I was just going crazy. And then, I don't know what was going on at all. Because this, I think it was the open area. I wasn't in a room by myself. There was no door. It's an open area. It was an open area. I didn't like it. It was different. At all.
Or was there anybody else there?
Maybe upstairs.
Upstairs. And how come why did you leave? Did anything cause you to leave the house?
I kept on hearing footsteps,
Okay.
gunshots. So
What else? I'm sorry.
gunshots.
Gunshots. Why did you think you heard those?
I had no idea.
Do you have a gun with you?
No, I did not.
Did you hear a gun in the house?
No, I think it was outside.
Okay.
Yeah, and then
You afraid someone was coming
it was
there?
weird. I'm never paranoid, but then out of nowhere, like I got
Yeah, paranoid.
for a couple of seconds, and then we'll go away, and then like boom, we'll come back. It was weird. It was really. It was a weird night. Like,
Yeah, I would
I don't
imagine.
even know. Like, this one was weird. I didn't like the openness.
Yeah.
I did.
Too much room.
Yeah.
Okay. Well, I'm sure I'm gonna have some questions for you. I'll take a cake break. Maybe drink some water. And did you tell them what happened or no? You tell them what happened to Shad?
Yeah, he's got body parts in his hand, so he's got to get that out.
Yeah, we'll
I
get it.
forgot about that. I've been off of it right now. I blame the fucking drugs. Honestly, so.
Just a minute.
Yeah.
Are you supposed to take any prescription medications?
Nope.
Okay. All right. I want to look into a couple other things, and we'll be with you. And if you need anything, you knock on the door. Okay.
How you doing?
Good. Everything's okay? All right. How's it sound?
It's great. I need stitches.
You're gonna need some
I'm
stitches.
gonna need stitches.
The thing is, yeah, I don't know. We need to get there before.
Usually you're good. They would say I think it's stitches. You got 24 hours. Do you think you cut yourself over 24 hours ago?
Oh yeah, I just did it like 4 hours ago.
You did it 4 hours ago?
Yeah.
All right.
Well, that's actually one of the things that we want to kind of do is we call timeline, just to kind of get an idea of what you were doing since you first had contact with Shad. How did you call him up? Did he call you up, or did you just show up at his house, or how did you decide to go over to his place?
Hey. I said, hey, come over here. And then I went and got him. And
You called him, or he called you, or
yeah.
how? Do you have a phone?
No, Well, it was actually from my friend AJ, our friend AJ.
Okay.
Yeah.
Where were you?
That's Scott's.
Okay, AJ there too.
Yeah.
So you were at Scott's, and your friend AJ was there?
Yeah.
What's AJ's, any other, his last name or first
Big
name?
Gannon.
Huh?
He's Gannon.
Gannon?
Big Gannon, yeah.
How do you spell that,
Gannon.
What Scott know who he is?
Yeah.
Was Scott there?
He's referenced as Black AJ.
Is he a black guy?
He's a black guy.
Okay.
He's got Jew throats.
Was Scott there then when you and AJ were at the apartment on Eastman?
Yes.
Okay.
We walked over there.
So you called Shad using AJ's phone?
AJ
Okay.
talked to Shad.
AJ talked to Shad.
Yeah. And he's just like, hey man, come over to Scott. And then Shad was like, I might have got a ride, but can you come get me? And then, so then,
Did
I
you
went.
text them?
Yeah. So then he's like, wait, never mind, I'm alright. So then we went and got him.
Okay. And then who went out?
We didn't, I took him in.
Did you go by yourself or somebody else?
I grabbed him, I took AJ and I put him in the seat. And then,
So you and AJ went to Shad?
yeah.
What time do you think this was? Okay. So you and AJ were at Scott's. And AJ contacted Shad by text message probably, saying come over. Something like that. Were you and AJ using drugs at that time?
No, we were smoking the yield with Mary Jane, but that was about it.
Just smoking marijuana?
Yeah.
Okay. So then who went and picked up Shad?
We grabbed, I took AJ in the front seat and then we went over to Shad.
Okay. And so how did you get there?
Via van.
Did Scott know you were taking the van?
I said, hey Scott, I'm taking the van, I'm picking up Shad. And then
Okay.
he was just like, no! And then I'm like, okay, and I took it. Yeah.
Okay. So he didn't want you to take it, but you took it
But I
anyway?
took it anyway.
Okay. And where did you go?
To Shad's house.
His dad's house? Mom's house? Where?
Mom's house.
Okay. Did you go inside the house at all?
I knocked on the door, I said, hey Shad, come here. And then like, he came here, and then like, he came here.
Alright, so then Shad got into the van, and AJ was in the van, and you, and then where'd you go?
And then we went to, so me and AJ and Shad, we went to his dad's house, right?
Whose house?
We went to his dad's house.
Shad's dad?
Shad's dad, we went from his mom's to his dad.
Okay.
Yeah, and then, I don't know. And then, from there, we went and picked up some dope.
So was anybody at Shad's dad's house? Was Shad's dad there?
Yeah, Shad's dad was there.
Okay. Did you talk to him or have contact with him?
Good old Michael B, yeah.
Okay. How long were you think you were at Shad's dad's house?
I don't know, maybe like 10 minutes.
Okay. And where'd you go to store dope?
I don't know. Like, that's the thing. Like, I don't even know where it was. Like, I'm just like, put in the Addy. And he's like, what? And then he went and got it. And then,
So who made arrangements to get that?
maybe Shad? Shad?
Shad, maybe?
Yeah.
So, do you remember, was it a business, a house, or cars? You met somebody in a car? What did it happen?
No, he was just like, hey, you got any pretty girls inside? And I'm like, hell no, I'm gonna knock his ass out. So he says that, right? And then, like, for me to go in and get the dope, I'm like, I'm not getting the dope. I'm like, Shad, go get the dope. So Shad went and got the dope, and then he came back with the dope.
Okay, and where was this, do you think?
This was, I don't know, I have no idea. I just.
Was it a house or apartment or?
You said put the Addy in, did somebody use their cell phone to find the house address?
Could have been. Could have been.
Do you know who might have looked it up?
I have no idea.
I'm not sure.
AJ or Shad?
I have no idea.
But Shad is the one that went in to get the dope. How much did he buy?
Oh, that was all me. I gave him $100.
Okay, so you bought $100 worth of meth?
That's what I did.
Alright, and is the three of you still in the van?
Yeah. Yeah, when he got back in.
And where'd you guys go?
We went back to Scott. Scott.
Alright, went back to Scott's. Who's all there then?
Scott, AJ, Shad, and me.
And what'd you guys do?
We smoked.
Smoke what?
The reefer.
Marijuana?
We smoked the reefer. I didn't smoke the reefer. You know, they smoked the reefer.
Who had that with the reefer? Someone bring it with them, or is that already there?
It was, the reefer was there. The reefer was there. And then after that, me and Shad, we were talking on the bitch. And then after that,
So you and Shad smoked some meth at Scott's?
we had to smoke somebody.
So where were you guys located?
That would be Eastman. That's
Right. Were you in an
Scott's.
apartment? But were you in a bedroom, in a living room, in the kitchen?
Living room. Bedroom.
Was Scott using any of it?
He was chilling on the chair, rocking back and forth.
Did he see you guys smoking meth or marijuana?
No, that's all behind him. He can't see. He can't see it, no.
Why not?
Because that's behind him.
Okay.
He's facing this way, we're this way.
Okay. So then the three of you were smoking marijuana, and you and Shad smoked meth. And so then what happened then? Who went where?
I started cutting Shad's hair.
That's right, you said you gave him a
I
haircut.
gave him a good haircut and everything, and then right after that, AJ was just like, you don't let him go. So then I'm like, alright, see ya.
You left on his own?
Yeah.
Okay.
And then he tried it on foot. And me and Shad, we took out. I shot him up, and then I took him out. I had one shot too.
Then where did you get that stuff from?
That's the same place.
I know, but so you bought it with the meth, you bought the other stuff too? But where did you shoot them up with?
Same shit. The trazodone?
Yeah.
I crushed it up.
And where did you get the trazodone from?
The table.
The table, where's the table located?
It's right by Scott's
Was it Scott's trazodone?
Yeah, he is.
Are you sure it's trazodone?
It says it on the bottle.
So you took some pills from where? You said on a
From
table?
the counter.
On a counter?
Yep.
And it said trazodone on the label?
Yep.
And was it Scott's pills? Was Scott's name on there too?
Yeah.
And you crushed them up, and then what did you do with them?
I put it in the syringe. I pulled it back, and then I shot him.
Okay. And you said you took a shot too?
Yeah, I did.
Okay.
Where did you get the injection? Where did you inject them at?
I heard from a friend.
No, but I mean, when you shot,
Where did I shoot him up?
yeah,
Shit, probably in the arm.
in the army, then.
There.
You said you got the hypo from a friend? Did you? Have you used drugs, they call it intravenously, some needles before?
Yeah.
Alright, so were you guys in the bedroom, in the living room, or someplace else where, bedroom? Okay. And then what do you guys do?
And then, we just took off because we just headed over to his mom's house. We got cozy on the bed. We drove into the driveway, right? Opened the door. We went down the stairs. We chilled on the bed, and right after we chilled on the bed, he put the collar on.
So you and Shad left Scott's van. Did Scott know you were leaving?
I said, hey, I don't know, actually. I don't know.
Do you remember what time that was, or was it day? Dark out, light out? Night? You know what I mean? What time of day was it, you think?
Like 12 maybe, I'm just gonna guess. I really have no idea. I don't know the clocks, I don't have the phone.
Was it dark out?
Yeah.
Okay. So you went to Shad's parents' house, Shad's mom's house.
Mm-hmm.
Did you meet anybody as you were arriving?
No. He didn't.
Alright, and then you went into the basement.
Yep. Opened the door and then into the basement, down the stairs, and then onto the bed where he put on the collar.
Was it right away you started doing that?
I don't know. This is what I remember.
How long do you think you were in the basement?
Until I left. I really don't know.
Was it during the day at all?
I really don't know.
Did you sleep at all?
I mean, I was playing with him all night, so.
Okay, so you're playing with him all night?
Yeah.
What all during the day?
I mean, I went into the day. I still was playing with him. But like, are you talking about the choking session?
Well, from the time you got to Shad's mom's, how long do you think you were there before you left?
Like, until he like died, or like
No, until you actually left.
until I
And went
left?
back eastman. Yeah. So by the time you first got there to the time you actually left,
I don't know. I don't do times. Like, I really don't do it.
was it overnight?
Yeah.
So I'm asking because it was the time it's the boyfriend see.
Did at some point the boyfriend have to let you into the house?
Who don't unlock the door
Did he unlock the door
and open it?
and opened it for you guys?
He did.
Okay, so when you guys got there after shooting up the first time and coming back from Eastman, he did open the door for you guys.
Yeah.
Okay.
So then, from then till the time you left, how long do you think it was? The whole day? An hour? You know what I mean?
It was shit. I don't even know. Like he
So you got there and Shad's mom's boyfriend let you in.
Mm-hmm.
And you went to the basement. Did you start getting together right away, or did you sleep for a while, or what do you think you remember you did?
We went there. 5 minutes in, I was already choking him.
Alright, so it happened pretty quick.
Yeah.
And you talk about you were playing with him.
I was playing with his dick and with his corpse.
Okay. Was it light out at some point? Was the sun out?
When I looked out the little window, I seen it.
You could see light?
I could see the light.
So you were playing with him when it was light out?
Yep.
Okay.
Alright, so particularly you said within 5 minutes of getting there, you guys started, he pulled off the chains, I guess you were saying,
Mm-hmm.
and he put it around his neck.
Yeah,
Did you put one on, you never put one on yours, or did you put one on?
I did.
You
I
did?
did. It was tiny. I finally got it around and I put it on my neck and then I took it off. After he was on, but like,
So, you started choking him, and when you were choking him, what did he do? What were you guys doing, I guess, try to explain it as best as you can.
he was coughing up the blood, right, and I was just waiting for him to die, and then, like, I was looking at his purple face,
Well, did he
During his
expect to have sex with you?
because I felt like it was fucked up. I'm like, damn, I'm already this far, so then I just like, yeah.
I understand, but why would he put the chain around his neck?
Because he's like thinking about, yeah.
So was he expecting to have sex with you then? Kinky sex?
I would assume so.
But you said that he just started choking. How long did it take for him to die?
Like, 3 to 5 minutes maybe. But, I don't know. I have no idea.
You said that when you were choking, you started coughing up blood.
Oh yeah. I was like,
And
damn.
you just decided that.
I just like, I like to see what happens.
So you just
I'm
kept
curious.
going harder and, okay,
I
So
didn't
you
go
wanna see
harder.
what happened when he died?
Yeah, I just watched it, yeah.
okay.
Well, this one was different. This one was common.
Blood.
So when he put the chain around his neck, he thought that you guys were going to have kinky sex, right? You think that's what Chad was thinking, maybe?
Yeah.
What were you thinking?
I was gonna do the same thing. You know, I was going in, and I did. And I went in. But then he was like, choke me. But he didn't really say it, so I'm like, he put it on his neck. I already know I'm gonna choke him. And I did. So,
All right, so before that, was there any foreplay?
we launched onto the bed. We went from the stairs to the bed. And then, yeah.
Were clothes on and off?
Yeah, and now, yeah, now the,
But before the chain went around his neck, were you and Chad like kissing or any foreplay or anything?
no, we were chilling at home.
You just chilling. So all of a sudden, the chain went around his neck?
Yeah.
How come? I'm just trying to get it.
He likes it.
All right.
I was gonna walk him like a dog.
And he wanted that?
I have no idea. What I was gonna do it anyway.
Okay. And you claim it was his idea? With the chain?
Obviously mine. No, it was his idea. It was all him.
All right, so you're on the bed, the chain goes around his neck and you start choking him. And you just realized that he was gonna die or what?
I'm just like, shit. I think I went a little too far because I was blacking out while I was doing it, right? And then like, fuck. And then like, I look at him, I'm like, shit, he's already purple. I'm like, fuck. I'm like, I don't know if he's fucking, is he good? Is he good? But then like when I woke up, like, you know, during the blackout moment, I'm like, shit. Like he was coughing up blood. I'm like, I don't know. I just kept on going. Like, damn. Sorry.
You made the comment, you said that when you were choking, you was coughing up blood, you kind of were like, I'm going this far, I'm just gonna keep going. Did you realize that by continuing that may kill him?
Oh yeah, because I felt bad because I'm like, damn, he's gonna be losing after this. I'm like, might as well just kill it.
Okay. So you realized that by continuing that you may actually kill him then?
He was, I swear to God, he was telling me, he's just like, just do it. So I'm like, oh, and I did it.
Okay.
Like, I swear, I was like, oh, fuck. I'm like, I accidentally fucked up, and then I'm like, fuck. I'm like, ah. And then, yeah, that's exactly what happened. All those
And
movies.
you also said that you enjoyed it, right? And I enjoyed it.
Oh, yeah.
All right. What'd you enjoy about that?
I'm just,
Was it kind of thrilling, a rush, exciting? What was the feeling that you got out of it?
that's all it is. I don't know.
Okay. I'm just trying to understand what you were feeling. You're saying that you were kind of enjoy it. Did it make you happy? Was it just kind of exciting? Like opening Christmas presents?
Like,
or?
I don't know. like, this is the thing that I have, like, I've always had, you know, like, you ever love something so much that you kill it? Like, it happens to me. That's the feeling that I have. I love something so much that I kill it. Like, oh, I love it so much, and then I kill it. That's what happens to me. So,
All right, so he dies, he's dead, and then you just kept playing with his body. Okay. And when did you decide to? How long did you play with his body? You think? Is that when you thought it was looked outside and it might have been light out too?
I don't know, it's so dark.
Still dark.
Yeah. Oh, it's gotta be like, I don't know, maybe 2-3 hours.
Is that also when you used the dildo?
Yeah.
Yeah. Did you have sex with his body at all? At any point, or any type of sexual contact? You know, obviously the dildo and stuff,
Put
but.
the dick in his ass. I grinded on him, I put the dick in his ass.
You grinded on?
Yeah, I listened.
Did you ever put his penis in your vagina? Okay, you just grind on him?
Did you see before that you performed a roll on him?
Yeah.
Okay, and that was after he was dead?
Yeah. And then he got happy. He was like half hard while I was still sucking while he was dead. Yeah.
Okay. Okay.
And was that part of playing with him, or?
That is part of playing with him.
That was part of playing with him.
Did you?
Actually, I was just I was severing his head while I was doing that too.
You were stopping his penis?
Yeah.
So it wasn't only a couple hours before you severed his head?
Probably, yeah.
Did you fall asleep at any point in time, or? So how long do you think you were in that basement? Because you didn't leave until like 3 or 4 this morning, right? But what about during the day? What did you do during the day?
I don't know, like I was kind of like dozing off, like you know, nodding out.
He was dead already?
He was dead.
Was his head still on?
No, I took that off. That was the first thing I took off.
Okay.
I wanted the head.
What about the rest of his body?
I didn't even take it. And then the rest of his body, it's back over there. Like on the fucking I don't even know what it is. It's in a big blue container, you know. And it's big.
A container?
It's like a big Tupperware. It's not a Tupperware, but it's a Tupperware container, like a
big storage code?
Yeah, one of those. And then
So that's where the body parts are in? Or I thought just they were in a black bag.
they are. They're scattered around.
Okay, so both probably. But when did you start, cutting up his body?
I don't know, like almost right away. I was sucking and cutting at the same time.
Okay. But what about the rest of his body parts? Did that take all day? Did you?
I was getting pissed off at the dismemberment process, actually.
Did it take a while?
It took a while.
Yeah, because like I was nodding out. Sorry.
Okay, so you're kind of slipping, kind of nodding in and out. Have you taken any other drugs?
I should have took drugs. I probably would have helped, but I didn't. And I just sat there. Yeah.
Do you remember it being daylight at all? When you
Yeah, when I looked at the window and I seen the daylight.
And was his body together still then? Or?
Body was never together. It's just like, I had fun with him for that 2 hours and then boom.
So, but it took a while to cut the rest of the body up? Okay.
All messed up too.
So, I'm just trying to, so I understand the rules. So you said were you cutting and then you kind of nod off, kind of wake up and start cutting again.
Yeah.
So it took you a little while to cut the body apart. There were times where you went napped or whatever. It wasn't, you didn't work nonstop to dismember his body, right?
I mean, I probably did. Well, in my sleep, I do things in my
You
sleep.
do things in your sleep.
But yeah, but like, that's probably it right there.
Did anybody ever come downstairs at all?
Tara came down. She came downstairs and then with the kitty cat, and then she set the kitty cat down. And, looked over the kitty cat, and then the kitty cat was walking around. And I threw the kitty cat, and then yeah.
Did you talk to her?
I'm like, hey Tara. I don't know, it's just weird. Cause like it was an open space, you know, like there was no closed door, and I'm like, it was weird.
Did she think she saw anything?
I have no idea. I don't even have to ask her. The pictures with the big ass.
So you think she came down at one point and dropped the kitty cat off downstairs in the basement?
Yeah.
Nice.
How long was she in the basement? Just shortly to drop the cat, or?
Yeah, she just came down there to drop the cat off to go use the kitty litter,
Okay.
the box, and then she went right back upstairs. Yeah, and then
All right, so then throughout this process, you would cut off a body part with one of the knives, and you would put it in the bag or the tote or something like that.
yeah, I was still tweaking out, so like I'm over here cutting it, and then I'm like, wow, it's getting dull. So I grabbed another one, and then I was cutting it, and it was getting dull. And I was tweaking, so like I'm like, oh shoot.
Wow.
Done that. I didn't mean for all this to happen, and I'm like, I fucked up, I know I fucked up, and I'm like, shit. Yeah, I'm sorry. That's what happened.
No, you know, it's feelings, got a mom and a sister and a dad and family, and more and more of being sorry, you know. You killed them.
You gotta tell the sister sorry. Didn't mean for that to happen.
You didn't mean to kill them.
I
But you didn't try to help them?
No, I didn't. No, it works both ways. Like I have no idea. Like it.
You was gonna
Gotta
die.
be tugging the chain.
Right, you knew he was gonna die, so.
I mean, I didn't, but at the same time, I woke up like, fuck, that's bad. I didn't know what to do because like he was gonna be like, ah, like fuck, I didn't know. You know what I mean? Because like, I don't know.
But you liked it?
I liked it. I'm like, fuck, like it was, like I didn't know what to do, but like, oh, I liked it though.
Well, you knew that you didn't want to call the police or ambulance or anything, so.
Actually, I thought about it. And then I was getting angry at myself, very angry at myself because I didn't have the proper tools.
Yeah.
Sucks not having that.
Was it sexual side to you when you were choking, Shad?
Oh, yeah. Very.
Was it exciting when you were sucking on his penis after he was dead?
It was very exciting. Everything was, we should check on my panties. Boom.
Hey, can you see us? I gotta ask you a question. I just want to kind of clarify some things quick. Detective Grau will be here shortly. Probably, I believe he's gonna step in. It won't take long. So, after the incident where you choked him out, can you describe how you placed him before, because you said you cut his head off first, correct?
Yeah.
Can you describe where was he laying on the bed?
I pulled him.
Okay.
Like, say this is the bed.
Okay, so this is the top of the bed?
Yeah.
Okay.
And I pulled him, and then his head was hanging off.
So you're probably laying face up? So
Yeah.
his back was on the bed.
Back was on the
His
bed.
head's partially off the bed.
Yeah.
Okay.
And then, the tub was like right there.
The pail that you had the
Yeah.
head in before? Okay. So basically his head's here and the bucket's right here.
Yeah, and then, from there, I severed his,
You cut his head off.
yeah.
Okay. After you cut his head off, I know you said you dumped the pail at one point into the shower.
In the shower, yeah.
Okay. Did you leave the body there for a while to drain into the pail, or what? How?
It's all in the tub, in the blue tub. You found the blue tub, right?
I don't know if they're slowly going through the scene, so there's a lot of his blood. Did you pull the tub under there then?
Oh no, I moved the tub like real fast.
Oh, so you cut the head and then pulled the tub under there.
No, when I was dismembering the
Yeah.
body,
Yep.
it was, I mean, I'm going like this with a knife, so there's blood fucking going everywhere, sorry.
Okay.
Yeah, and then,
But initially, when you cut his head off, there was a pail underneath, correct? Okay, so the head went into the pail,
Yeah.
the blood went into the pail. Did the blood bucket fill all the way up with blood?
no,
No? Okay.
no.
Then, did you move them again when you started with the pail? Because you're talking about that blue Tupperware thing.
So I think there's a black pail, and then there's a blue Tupperware thing, right? And then his head was hanging off. And then I cut the head off, and then I moved it over, and I brought it back, and then I put it in the pail.
Okay, so initially the head went into the blue Tupperware thing, kind of?
Yeah. Yeah. There's a lot of blood in that one right now.
In the blue Tupperware thing.
Yeah.
At any point did you, like, before you, because you said you removed the head first, did you start removing limbs right away, or did you kind of wait a little while? And
That's the weird thing, like, cause when it started happening, like, I started, like, nodding out,
okay.
and then I was going crazy on the limbs, like, even while I was sleeping, and then it looked messed up, and I didn't like it.
Okay. But you believe the blue tub, that big tub, like, probably, I'm thinking it's the way you're describing it's only, like, Tupperware tubs about like this size, kind of that 2 cubic 1 foot one, and that's where most of the blood is, along with a bunch of his organs.
The organs are everywhere, too.
His organs are everywhere.
Yeah.
Did you, like, hide organs in the house?
Oh, they're in plastic bags,
In the tub?
In, backpacks.
In the back?
In the backpacks, and then in the,
Did you remove all organs, like his intestines and everything, or?
Yeah.
Where are the intestines? Do you remember?
they're gonna be in a plastic bag.
They're all in plastic bags.
They're gonna be in a plastic
So that
bag.
blue tub is always just all blood, is what you, I thought you were saying.
It should be like only like this much.
Alright. Okay, we're just trying to clarify a couple things, I'm just trying to make sense of something.
Yeah.
Okay?
Okay.
Alright, I appreciate it, thank you.
All right. Thank you.
Hey, how you doing?
I'm good. How about yourself?
Alright, can we talk a few minutes again?
Yeah.
So, I went at the house right now, there's, you know what a medical examiner is? They're the ones that kind of like take care of people that died and see how they died. And so, you know, they have a bunch of questions for us that we really can't answer. And the biggest questions that they have is exactly how did you dismember Shad?
Nice.
Did you know, cut arms, or I mean, or was it just internal organs, or?
So you started on the head, right?
Yeah, and then I don't know where I'm from there. I just want to.
Did you cut it, or did you remove his arms? Okay, can you show me where you would cut on the arms?
Right there.
Right at the elbows, was this part of the arm left on?
You gotta go in that blue bed.
Okay, look.
Yeah.
But you know that you cut off at the elbows?
Yeah.
Okay, you cut both arms off at the elbows?
I would hope so. Because like I was saying that dismemberment process I did was like really messed up because like I was nodding out, and then I was like sawing it off.
Did his
Did you
legs?
use just a knife? You
Just
said?
the knife, so like, yeah.
Did you remove any part of his? Did you dismember his legs at all? What would you have done to the legs?
I think there's one leg that's actually intact,
Okay.
and then maybe. Where is it? I have no idea.
And where was his body located when you did this dismembering? Was it in one spot or?
Yeah. It was all in the same spot.
And where's that again?
Blue tub.
So the body was in the blue tub as you were cutting it up? Okay, then did you empty the tub at points, or, you know what I mean?
Was there a bed down there or just a mattress or?
There was a mattress that was laid down there. Should be blood on the sheets. Like a lot of blood. But I tried to get it out. But I can't fucking think right now, I'm sorry.
That's okay.
I'm fucking nuts.
Yeah, you know, because like I said, just have, and they'll probably figure it out eventually, but they just had some questions about like where blood might have went or most of it went. And he said a bucket or that was drained or that. But it was when you took off his head, was he lying on a mattress or was he someplace else?
I had his head hanging off,
The mattress.
and then I was sawing it out.
But was the bucket underneath his head?
Yeah.
So it was high enough?
I don't know, it just dropped in there.
What's that?
It just dropped in there after I got the bone.
But it was high enough that it could stand up underneath his body, you know what I mean? So let's say the body visited the bed, the bucket was able to fit underneath there. Was that the bed was high enough for a bucket to fit there? Or would it have to be on its side or something, the bucket?
No, the bucket was just fine where it's at, on the edge of the bed.
On the floor or on the bed itself?
On the floor.
Okay.
So there's a box spring and then there's a mattress.
Okay. You know, what do you think should happen if somebody does something like this to somebody else?
I don't know, they obviously get prison time, I don't know. Whole lot, like, I don't know, this was out of random.
Think it was the right thing to do?
No, I did it anyway.
And I just want to clarify, when he had the chain around his neck, were you behind him
Yeah.
and kind of with just one end or two ends or with a chain or? And just one, but you hold it, how to, you know, I mean, because if you wrap a chain around someone's head, you just hold one end of the chain, the other end is going to go loose.
No, so if you've seen, there was a ring, and there's two rings, and then like you can pull the chain link from under the ring and then pull it back.
All right, so that a loop at the end of the chain that could go around, kind of like a dog choke collar.
Yeah, exactly.
Okay, do you think it was a dog choke collar?
Could have been, very much so.
Was it that size?
It was that size, very large dog.
All right, and so then you would have been, was he laying on the bed? Or kneeling, or something else?
He would have been on his stomach.
Something like that?
Yeah.
Is that what you're talking about?
Yeah.
Choker chain? Okay. And there were two of those, correct? You said there was one for you, one for, that was on him? Yours was
Yeah.
smaller?
Yeah.
Does this guy look familiar to you at all?
Mr. Gannon?
That agent?
Yeah.
Okay.
That's the one.
So he was lying face down on the bed? Or was he just on his hands and knees?
He was lying face down on the bed.
Okay, you're on top of him. On his back?
Yeah, I was on his back.
Okay, all right. Pulling the chain back. Okay. All right. Hopefully that
Hope then, you know,
Did you guys find all the parts here?
still going through the process of looking. So, did you remove any other? You said you had the heart and the liver. How about the lungs? Did you remove all that from the chest cavity, or did you leave them in there? Or?
It could be in there, yeah.
Do you remember? Or
They're all in plastic bags.
separate bags or one big bag?
They're all in separate bags, like Walmart bags.
Oh.
They'll find them.
All right.
They'll find them.
Long as you'll go. Okay. How you doing? You feeling all right? You need anything, or hungry or anything? Or
More than thing.
what?
I'm just going to
Well, you're right. I mean, you don't need any food or you got water, obviously. So if you need anything, or you go to the restroom, knock on the door, and then you realize that, you know, you're probably going to jail after this when we're done. So
I didn't know that.
I'm just, you know, telling them what it is, and I don't like to screw around with anybody. So
Alright. Yeah.
you've been forthcoming with us, so we're going to be forthcoming with you.
Thank you.
And we appreciate it.
I mean, like Dave said, if somebody kills somebody and dismembers them, do you not think that that person probably should go to jail?
Oh, fuck yeah. Yeah, this shit was fucked up, so, like, I don't even know, like, I'm like, god damn. Yeah.
So, you know, we see where we're coming from and what we gotta do, and nothing personal.
Yeah. Sucks.
All right.
You need something? You said knock on the door.
Thank you.
Detective Groff, the video that we all just watched, is that video accurate and consistent with what you recall from your in-person meeting with Taylor Schabusiness on February 23rd of 2022?
Yes.
Just want to address one thing. At the beginning of the video, she's wearing a yellow outfit. Toward the end, she's wearing a blue outfit. Can you explain that for the jury?
When she went to the hospital to have her thumb checked, the hospital changed her into the blue scrubs.
And then you indicated there was also the recorded interview from the 28th. I intend to play a much shorter portion of the interview from the 28th.
Yeah, so you took the ring fingers, is that why you hit Shad's head? And you kept mentioning that you liked it.
I was gonna take it and then I just left it there. I was staring at it, I was looking at it right as I was gonna go up the stairs and I just like, I left it there. Like I was gonna come back, I was gonna come back, and I left it there, and I don't know, and I had his foot.
Yeah. So you were gonna eventually take all the parts, you think, did you?
Yeah, I don't know. I really don't know how.
Did something spooky?
Oh, I kept on hearing like footsteps up and down the stairs, up and down the stairs, up and down the stairs.
Can I ask you a question? What would be then? Do you remember wiping up the concrete floor right then? You remember wiping up that?
No, before it's bleach, they were right there.
Okay. And then you put those in the bags, remember that? What did you do with those socks, please? What did you do?
I think, yeah, I have no idea what happened.
Okay, would you use those to wipe up the blood?
Yes.
Did you do that?
Yes, I did.
To cover that up?
Yes.
Okay. And you remember cleaning like the you know all the stand-up showers and then there's part of the basement? There's that shower.
Yes.
Do you clean that area up too?
To the best of my ability.
Like the water or whatever?
And that squeak.
So you used to speed. That's right, we were speeding. And it's still that you what you saw. Okay. feeling? Were you anxious, angry, excited?
Well, when I woke up and I seen that this happened and there was like the environment around me, and I was like, it feels like I'm on a hidden camera TV show right now. And I was like, what the? Yeah, I was going crazy. So I was really pissed off and freaking out a little bit.
Hate yourself?
Yeah, very much so. One, the victim was like my friend, right? And two, it's it was an open area. Very open area. I didn't like that one bit. The dismemberment process was awful.
Yeah. Can you go into a little bit on that? Questions? Or you jump into that? Sure. Were you cleaning up so that you would get caught?
Well, yeah, to the best of my ability. I almost like called on myself like 4 times because I'm like, there's no fucking way. There's people upstairs.
Sure.
There's people upstairs. I'm like, how am I going to get away with this at all?
That wasn't one of your thoughts when you were
Yeah,
chopping them up.
yeah. I was just like, there's no way I'm going to get away with this, and now I'm fucking screwed.
And that's part of the reason you put them in different bags or cleaning up, is that correct?
I was cleaning up, but then, like, when I said I was tripping out, the body looked like it was rebuilding itself because I already cut off his arm, and his arm came back on. I'm looking at this, I'm like, there's no way. There's no way, you know? And then, and I'm like, am I that high?
Would you cut it off again?
Yeah.
So,
And it took forever. Oh.
yeah, I know what you're talking about, because one of his arms had a pretty good cut it. It never cut off.
Yeah. That's weird because I cut it all the way off. And then, I'm just saying that, like, I don't know.
Was it sort of easily move him because he was a bigger guy than you?
Because I'm looking at this, I'm like, how do I get Shad out of here? Can't just leave Shad here and be like, hey mom, Shad's dead. So, yeah.
And Detective Graff, the portion of the video that we just watched from the February 28th, 2022 interview, does that accurately reflect a portion of your interview with Ms. Schabusiness on that date, February 28th?
Yes, it does.
And I would formally move for the admission of Exhibit 110.
Any objection?
Your Honor, can I confer with Mr. Lassay for 1 minute? Thank you, Your Honor. No objection.
That'll be received.
Detective Graff is not in the portion of the video that was recorded, but do you recall in the February 28th, 2022 interview whether Ms. Schabusiness mentioned having any contact with Stephen Hendricks during this incident?
I recall that, I recall correctly, I think at first she didn't mention that, but then later on she did.
And the contact relative to the eyeglasses?
Oh, yes. She did mention that at one point she did go up into the kitchen and had contact with Mr. Hendricks and borrowed some glasses, yes.
I have no further questions for Detective Graff. I don't know if the court wishes to take a break before cross-examination.
We will. Ladies and gentlemen, it's 10 minutes to 12. I'm going to ask you to be back here in the jury room. We'll take an hour and 15 minutes, so try to be back shortly after 1:05 or so. So then we'll get underway promptly. Right? And all rise for the jury. Anything to bring up before we recess for lunch? Mr. Saunders?
No.
Mr. Fraley?
No.
Can I ask Mr. Saunders, or Mr. Lezay, either one, do you have a sense of how many more witnesses do you have? Or is this the last witness?
This is,
Yes, it's our last witness.
Okay. Then probably what I'm going to do is distribute a draft of proposed jury instructions so that you can start taking a look at that. My judicial assistant is out, but I'll try to have those on your desks by the time you return. Okay? Very good. Then we are in recess until 1 o'clock.
Your Honor, there is one other issue. The defense then would have Scott Tomes as a witness, but apparently he's unavailable. And I have him under subpoena. You know, the timing of his unavailability is suspect for me, but I've conferred with the prosecutors and they've advised that he is simply not available. So what we talked about was talking about potentially some agreed facts that could be presented to the jury. It's an unusual situation for me to be in, but you know, as a lawyer, when you issue a subpoena, people are expected to appear. So I'm caught in a difficult spot.
Okay. Well, you can address it to me when you come back at 1 o'clock, okay?
Okay, thank you.
Very good. We're in recess.
Thank you.
He doesn't get it from softball up there. Eden Prairie. That's where they was going. Sure. We'll have fun. Yeah, it's gonna be hot.
The bailiff is in question is supposed to be in the room right now. I don't see her, but she'll be here shortly. Well, I need her to be brought in here. I indicated I needed her in here right away. So the juror approached the bailiff and indicated that he got a text from his buddy out of state who said, "I saw you on television. You're looking pretty dapper," or something to that effect, which raised concerns on the part of the juror that the jury was getting videoed, which of course violates my order. So then the bailiff approached my judicial assistant, who's here, and I've indicated to the bailiffs in the future they need to bring these issues to me, not to my judicial assistant. My judicial assistant, hearing this issue, went to the videographers from Law&Crime, who are in the back, and indicated this is being reported. They apparently indicated that we'd need to know when it was in order to look to see if it happened. My judicial assistant then went back, spoke to the juror to try to nail that down. Again, I've indicated to my judicial assistant that I want all those things to go through the bailiffs to me, but this is how it occurred. And I don't think on the part of anybody involved that there was any malice involved in how this unfolded. The juror then apparently was able to give some detail as to when this occurred. I think it was around or later in the afternoon yesterday, but I don't know that for sure. Some of the details I don't have, and that'll be part of what we'll talk about here in a minute. Then my understanding is that the video has been completely scanned, and there has been no occasion when the jury has been shown across the live stream or any other place. And that's the state of affairs. This has been developing this morning, and so it would appear, assuming that to be the case, in other words, that the jury never was shown, information is flowing into the jury. And I don't know if information is flowing out from the jury, but clearly I gave the jury instructions as to dealing with information that's coming in. That's the current state of affairs. And so the real question, I think I'm going to turn it over to each side and see if they have a thought about what to do. I have some thoughts about what to do, but I'm going to turn it over to the state first. Is there anything you'd like to address me on with regard to taking this issue up?
Judge, thank you, Judge. A couple of concerns I think come to mind. First, I'd be interested in knowing. I understand that there's the live stream, but I understand there may also be other sources of media that are here, or potentially other individuals who may have done some filming or photography within the courtroom, which I think would violate the court's order. But I don't know that that's not happened. I think it would be helpful to voir dire that particular juror to understand better who informed him of this information. Is that person potentially have other people who could be, other people know that he has jury duty and they might be in the courtroom and then texting him? So, for example, there are a number of just citizen members in the gallery. Maybe someone in the gallery also knows this juror and then sent a message to a friend of theirs or something like that. So voir diring, I think, the individual juror to know what was shared, how it was shared, by whom it was shared, might give us a better idea of how the information is coming in and going out from the jury.
Sure. Before I turn to Mr. Freilich, there's your comments have raised a few other pieces of information. First of all, my understanding is in the conversation that occurred between my judicial assistant and the juror, there were other jurors nearby, and they heard that that might be happening. And so I think there may need to be some kind of a statement made to the jury as a whole. To some of your other points, we also considered the fact that it could have been a member of the public who's using their cell phone. I've asked security to look at the security cameras to see if they can track down if that's the case. I don't have any feedback from that search yet. But what I can tell you is my understanding is that the juror indicated the feed came across YouTube. Anything can come across YouTube. But the feed is, my order is very specific. There are 3 cameras in this courtroom, and there's to be no other cameras. So unless YouTube picked up on a video that was illicitly obtained and then posted it, I doubt that that's the source of the concern. The concern, of course, then is potentially false information coming in to the jury. In any event, the state is suggesting that I voir dire or we voir dire that juror. And I'm going to turn to you, Mr. Freilich.
Thank you, Your Honor. All of this raises a question, I believe, of whether my client, Taylor Schabusiness, can get a fair and impartial jury with the jurors that we have. It's concerning. I know that my client has some concerns about this. I'd ask the court to consider a motion for mistrial.
Well, what I can tell you is I anticipated this kind of an argument. In other words, I know I denied a motion for change of venue or to bring in an outside jury. I'm absolutely convinced that there's nothing about this event that couldn't occur in any other jury situation, including had I brought in a jury from the opposite side of the state and sequestered them the entire time. So that is, everyone has cell phones that they have. Everyone gets text messages. And I expect the jurors are going to follow my instruction, which is, if someone tries to talk to you about this case, despite your telling them not to, you should report that to me. So the implication in there is you're not prohibited from receiving a text message from a friend about this trial. What you are prohibited from doing is discussing the case, and that your first step is tell them to stop doing that. And if they continue to do that, they're to report that to me. So I'm not going to grant your motion for mistrial because quite honestly, the issue is the same. We need a fair and impartial jury. All these jurors during voir dire have indicated we can do that. This is I'm not even sure if there's been an infraction because quite frankly, if this juror tells us, I got that text message and I said, don't talk to me anymore about this case, and then he reported it to the bailiff, that'd be precisely what I would want him to do. The problem is it spun a little bit, and it was, frankly, it was investigated, so we actually have more information than we did before. But I'm going to deny the motion for mistrial because I frankly don't see the basis for it at this point. But I think I'm going to avail myself of the opportunity to bring the juror in. Either of you want to, either side want to hear from either the bailiff or my judicial assistant about the steps they took or the things they heard. Mr. Saunders?
I think what I'd be interested in knowing is to the extent that the judicial assistant or the bailiff is aware that other jurors partook in this process or were aware of this process, that's the information I'd be concerned about from either the bailiff or the judicial assistant.
Let me just indicate, again, I've spoken to both of them. My judicial assistant is here. I'm going to recite because she's not near a microphone, but I'm going to ask her to indicate whether I'm reciting accurately. My understanding is when the juror shared this with her, there were jurors sitting there nearby who said, "Are we on TV?" And they were assured that they're not. Is that accurate, Ms. Pigeon? Okay. She indicates, because she's not near a microphone, she told them not to worry, they would not be on any video, which I think, frankly, was an accurate recitation because from my understanding is they haven't been on, that my order has been followed precisely by the media, which is what I'd expect them to do. Anything else, Mr. Lezay, from either of the two, the bailiff or my JA?
No, Your Honor.
Mr. Freilich?
No, Your Honor, thank you.
Okay. I'm going to excuse my JA. She can go back and take up her tasks. But I am going to ask if you could invite that juror in to we'll just bring him in. Actually, before we do that, I would expect we would just bring the juror right in here. Is there a request that we do it some other place? I don't know why this would be an inappropriate venue as long as they're not videoed. Mr. Saunders?
No, that's fine.
Mr. Freilich?
Your Honor, at least for me, I find this kind of to be a little unusual, and I'm concerned that if the juror has to answer some questions in front of a large crowd, it may be more uncomfortable, whereas if we're in a more private space with the lawyers in the court, the judge, might be a little easier.
Well, I've indicated to the jurors, and they've taken an oath to follow the law, to uphold their oath as a juror. I don't think I've noticed anybody on that jury who seems disinterested or unconcerned or upset in any way about what they're doing. They all seem very intent and very interested in serving in their role. So I'm satisfied that if I brought him in here, they'd answer this individual would answer the questions appropriately. And then once, so I'm going to bring the juror in here. After the juror is done, then we'll need to talk briefly about whether or not, and I'm inclined to indicate to all the jurors the circumstance, but we can also determine once we've questioned this juror the extent of the issue involved. So we're going to bring the juror in now, right here. All rise for the juror. No. Okay. You have a seat right there in that first chair, sir. Thank you. So the reason you're in here is because we are responding to a concern that you had raised earlier this morning with the bailiff, I think, regarding potentially having been videoed while you're serving on the jury. And I'm really interested in knowing what you heard because we're trying to get to the bottom of the issue.
Sure. And it was in conversation, I wasn't concerned, but so yesterday afternoon, a coworker of mine who works in Indiana, we work remotely, texted me that he had seen me at this trial, and I thought that was unusual, and I had seen the text when I went back into the room, and our phones are, and so I didn't think very much of it, and so then this morning when it was brought up, I had asked him where he had seen it, and he had said YouTube.
Okay.
And said that it was streaming.
Okay. And when did he indicate? Maybe he said that. What time?
He texted me yesterday at 3 o'clock sharp.
Okay. Okay. Questions from the state?
Just curious whether he texted you a screenshot or a link, or was it just a text?
Mr. Freilich, any questions?
Did you save the text?
It's on my phone in the other room.
So it's on your phone?
Yes.
Did you respond back?
I did.
Okay.
Thank you.
Okay.
Thank you.
Yeah. All right. Anything else that you feel you want to tell me about that event or issue?
No, other than you're free to look at my phone. I'm happy to show it to you. I'm happy to inquire further with him. I can consider him a friend as well
Okay, I am going to just indicate to you that perhaps, going forward, if you receive any messages from coworkers or friends, that you advise them you can't speak about this case at all until it's concluded.
Sure.
Okay?
Certainly. And my response was, thank you. That's what I said. I can show you.
Okay, very good. Okay, I think I'm going to excuse you then. Thank you. All rise. Be seated. Mr. Lezay.
Your Honor, I guess I don't have any concerns about how this impacts the integrity of the jury in any way. It seems like a very limited conversation. I think it is probably a good idea for the court to reiterate to the jury that you have given instructions that they aren't being filmed, just to potentially alleviate any concerns that they might have, and that you're confident that those orders are going to be followed.
Mr. Freilich?
Your Honor, I inquire, how is it possible that a juror in a case like this, or any case, is seen on TV? And that's concerning to me. I believe that, this juror, even by responding back, which he shouldn't have done, causes an issue for the defense, at least for the integrity of the jury. My client and I are concerned about, this jury, can it be fair and impartial? So I, again, based on what's been discussed here, make a motion for mistrial.
Okay. Well, I'm going to deny your motion for mistrial. A couple of things. First of all, I agree that the juror shouldn't have replied. First of all, the juror also indicated that he's not really concerned about it. And I think, one of the main reasons that we enter orders that jurors are not to be videoed is so that there's, for juror security. So this individual apparently wasn't concerned with that information. Secondly, I'm not even certain that it happened. It's hard to drill into why he would get a video from, or a message from a friend in Indiana about being on this case, and if he wasn't, I can't explain it, but I'm satisfied that that the cameras over which I have control in this courtroom, that being the media cameras, aren't filming the jury. It's possible, I suppose, that someone in the audience used their phone to make that video. I don't have the results of the efforts by security to try to track that down. Hopefully I will get something. But I'm not satisfied that this juror has indicated in any way that this is going to make it more difficult for him to serve on this jury. He indicated he wasn't concerned. So I'm going to deny the motion for mistrial. I intend to just indicate, I intend, frankly, to do two things. I'm going to, again, read the jurors the instruction that I've been giving them regarding communication. I think it's important to reiterate that for them. I'm also going to advise them that I've made a specific order that they're not to be videoed, and that from my investigation as a result of this issue, that they haven't been videoed. As part of that, I think I'm going to need to relate to them that a concern has been raised, only because beyond that they'll wonder, why are you telling us all this? But that's what I intend to relate to them. Mr. Lezay, any objection to that? No. Mr. Freilich?
No, Your Honor, but I have a concern.
Okay.
So would the court consider striking that particular juror because we have alternates? The other thing I'm worried about is there going to be discussion about, well, why did the court want to talk to you, to this male juror? I have some concerns about that as well. So would the court, consider maybe striking this juror? We've got several alternates.
Sure. Well, first of all, regarding a conversation the jury might have about why did the court want to talk to you, that's why I indicated I would tell them that a concern has been raised. And they'll get it, oh, it was the guy you brought out here. So, and I don't think the jury will in any way look on him disfavorably because he was simply reporting to the court something that occurred, which is what I want people to do. So that's that. But let me turn to the state. Mr. Freilich has asked that I strike that juror.
And I don't think there's a basis to do that at this time based on the nature of the voir dire with that juror.
I don't either. I frankly think this juror has perhaps skirted a little close to my rule. Instead of responding thank you or asking when it occurred, he should have said something along the lines of thank you, but please don't talk to me on this until this trial is over. On the other hand, friends might feel that's a bit terse to reply, but I'm going to reinforce that. I think the point is that the reply that he made was so innocuous that I'm not satisfied he violated my order to the point where he would have to be excused. Again, I think the notion that nobody on this jury is going to get any text messages from anybody while this trial is pending is something I simply can't control. So I can't find that in any way would cause me to strike him. And again, he's indicated he wasn't concerned with being shown as a juror, so he hasn't formulated any sort of bias or prejudice as a result of that event. He's just simply reporting what happened, which is what I expect a juror to do. So I'm going to deny the motion. Your motion is noted, Mr. Freilich. I'm going to deny the motion to strike him, and that's what I intend to do.
Thank you.
Okay. Anything else, Mr. Lizay?
No, Your Honor.
Mr. Freilich?
No, Your Honor.
Okay, we'll bring the jury. Be seated. Welcome back, ladies and gentlemen of the jury. And I need to take up an issue with you before we get started. A concern has been raised by one of your number that perhaps at some point in time, perhaps yesterday, that the jury may have been videotaped and put out on a live stream. And a couple of things I want to advise you about that situation. First of all, I appreciate the fact that that it was reported right to the bailiff, and that's what I need you to do. As a result of the report, the matter has been looked into by scouring the videos that have been taken of this trial, and at no point in the videos that I have authorized to be taken have you been videoed. Just to give you a little more detail about that. In this trial, I've allowed 3 cameras to be utilized. Those cameras are situated in such a location that you're not being videoed by them. When I need to, I look at the media room and I can stop the video feed at any particular time for a particular witness. Perhaps you've seen me do that and heard me do that. I've entered an order that no one in the audience is allowed to use a cell phone to take photos or videos. At this time, security is scouring the videos of this entire trial to see if anybody in the audience has been doing that. I can tell you that I can see everything from up here, and I haven't noticed it. And in case you wonder, this courtroom is also being monitored in various different locations. So we're being watched while we're being watched, okay? The people that are videoing it are being watched by the people that are sitting in the security office downstairs. So I want to assure you that order was entered by me. I'm endeavoring to great lengths to make sure it's abided by. And as far as I know, right up until this very minute, my orders have been followed to a T. That doesn't mean I'll stop looking into it. And I would encourage any of you, if you have a concern about that, as we go forward, report it to the bailiff. There's one other thing I want to do, because it's important. I'm going to again give you this instruction. You've heard it before and you'll hear it again. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use computer, cell phone, or other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you about this case. And if anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based upon the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decisions in this case. After this trial is completed, you are free to communicate with anyone in any manner. That's all I'm going to have to say about that for right now. I believe the case is still with the state. Actually, we're at cross-examination, however. Detective, I think you were on the witness stand. I'll have you come back. And I will just remind you, Detective, you're still under oath. Yep. I'm also going to remind everyone to please use their microphone. As you can see, we've switched court reporters. We are now using the DAR system, which is an excellent electronic system, but I want to make sure everybody's using their microphones. Having said that, Mr. Freilich, you've got a few complaints, so try to tend to your microphone, but I'm probably the worst offender. So go ahead.
Thank you, Your Honor. Detective Groff, good afternoon.
Good afternoon.
So on February 23rd of 2022, were you called down to the police department?
Yes.
What time did you get there?
I probably arrived about 4:45 in the morning, I think.
Okay. Is that kind of a normal shift for you, sir?
No.
What's a normal shift?
7 a.m. to 3:30 p.m.
And why were you contacted to get down there at 4:45 a.m.?
As far as my duties as a detective, we can get called after hours for major crimes, and in this case, I was called by a supervisor to ask if I would assist in a homicide investigation.
Okay. And were you told that there was a minivan that was found parked at the Eastman Avenue apartment complex?
Initially, my initial phone call, no.
Okay. At some point, then you were told that there was a minivan that was of interest, correct?
Yes.
And that was parked over at the Eastman Avenue apartments?
Yes.
You interviewed several people, correct?
Yes.
One being Tara Pakinich, correct?
Correct.
And did you also talk to Stephen Hendricks?
No.
Okay. Did you talk to Taylor Schabusiness as well?
Yes.
You talked to Ms. Pakinich and Ms. Schabusiness on the same day, fair?
Yes.
Did you talk to Ms. Pakinich first?
Yes.
Okay. And was it such that they were down at the police department when you arrived?
No.
Okay. You got there first?
I don't recall if I got there first or if Ms. Pakinich was there first, but Ms. Schabusiness was not there when I first arrived.
Okay. So you took Tara Pakinich into a room, correct?
Yes.
And what did you talk about? The fact that she found something in a bucket in the basement of her house?
Yes, of course.
Yeah. And you followed up with further questions with regards to that?
Yes, I did some preliminary questions, yes.
Okay. And did she indicate to you that Taylor Schabusiness and her son were friends?
Yes.
That they went to school together?
Yes.
They went to high school together at Bayport?
Yes.
And did she indicate to you that how she came upon the bucket in the basement?
Judge, I'm not concerned that any of this is particularly prejudicial, but it is all hearsay. Ms. Pakinich testified, and he can and did ask these questions to Ms. Pakinich. The statement that the detective took from a witness who is not a party is hearsay information.
Well, it's really not offered for the truth of the matter, Your Honor. It's just to get some background information. But I can move on.
When you move on, so the question's withdrawn.
So after you finished talking to Tara Pakinich, then was Taylor Schabusiness brought in?
Yes.
Okay. And initially you introduced yourself, correct?
Yes.
And Detective Kemp was there. Is that fair?
That's correct.
Were you sort of the lead detective on this?
Well, initially I was one of many detectives who came in to do the initial investigation, but throughout the course of the investigation, it took a more of a lead role.
Okay. So in the interview room, you swabbed her hands, correct?
Yes.
Did you take any pictures?
I did not.
You offered her some water, correct?
At some point, yes.
Okay. And then you told her that a few hours ago, officers went to a residence on Stony Brook Lane and a bucket was found with a human head in it, correct?
Correct.
And what was her response, do you remember?
Something to the effect of, oh, really, or something to that.
Did she say that it's pretty effed up?
Yes, that would be correct.
Pretty fucked up, correct? That's what she said?
Yes.
And did she indicate to you that Shad was her ex-boyfriend?
Eventually, yes.
Okay. And then did you confirm that she lived on Eastman Avenue?
Yes.
Apartment 1 at 2353 Eastman Avenue, correct?
Correct.
And she indicated that she lived there with a Scott Tomes?
Correct.
And then you had further questions, correct?
Of course.
You asked her questions about things that may be in the basement, is that fair?
Yes.
And did she give you comments like, well, that's a good question?
That sounds familiar, yes.
Did she say that she blacked out at some point?
Yes.
And did she tell you that she needed time to think?
Yes.
And you said, that's not a problem, take your time, correct?
That's correct.
When you were talking to her, was she smiling inappropriately?
I did not observe that, no.
Did you hear her laugh sometimes during the interview?
I believe so.
Her mood, did it kind of go up and down during your interview with her on March 23rd?
No.
Now, there were 2 detectives in the interview room with her, correct?
Correct.
And was there any sort of intimidation towards her at all?
Nothing.
During the time that you talked with her, did she say things that were sort of bizarre?
Well, some of the acts that she described that she did, were something that, was not common, but bizarre. I wouldn't say bizarre.
Unusual? How about that?
Sure.
Okay. And you told her that this was kind of an ongoing investigation and the detectives and the officers and the law enforcement personnel on the scene were trying to figure out what was going on. Is that fair?
Yes,
Because law enforcement really didn't know what was going on, correct?
absolutely not.
It was, would you say it was a situation that was unfolding and developing?
Yes,
She did indicate to you that, did she exhibit responses that were kind of short and snippy?
no,
Did she say that she did not know what was going on?
well, she did make a comment that at one point she had blacked out, and again, I assured her that she could take her time, and she had plenty of time to remember what she did.
Now, you've been on the force you've been an officer for 27 years, correct? You've got a lot of experience, is that fair?
37 years.
37 years, oh, sorry.
I'm sorry, 30 years, then yes.
30 years, okay. So, and you've been a detective for 17, yes?
Yes,
You've worked with people that have used meth, correct?
I have.
Meth is a very powerful drug, isn't it?
It can be, yes.
It can cause people to act and react in an unusual way, is that fair?
Yes.
When you were talking to her, she had some problems answering questions, correct?
No,
She would mumble and trail off when you would ask her a question, is that fair?
no,
She said a few times, damn, my head. Didn't she say that during the interview?
I don't know if she's referring to her head or Mr. Thyrion's head.
Okay. You didn't know what she was talking about, correct? On that topic?
I don't recall.
Did she tell you that she was coming off a high or a buzz?
No,
She did say that she was paranoid, correct?
she did mention the word paranoid in terms of why she had left the residence.
And she said it was really weird. She made that comment, correct?
I don't recall.
And she said, I think it was the dope. Didn't she say that to you?
She did make those comments, yes.
As far as the investigation was concerned, there were no human remains found at the Eastman Avenue apartment. Is that fair?
Correct. Not inside the apartment.
Correct. There was a minivan, well, strike that. At the apartment, Scott Tomes lived there, correct?
Yes,
And he also owned a gold-colored Town and Country minivan, correct?
correct.
When you were talking to Ms. Schabusiness, she did say something about she heard gunshots, correct?
Correct.
Did you hear any gunshots
When?
when you were either at Stony Brook or at Eastman Avenue?
I was never at Eastman, but when I was at Stonebrook, very briefly, it was much later in the day, and I did not hear any gunshots.
You reviewed a lot of different reports and talked to a lot of different detectives, including Detective Scanlon, Detective Kemp, Lieutenant Buckman, a lot of the other officers involved, correct?
Yes,
Did any of the officers provide any details or reports about any gunshots being fired at either Stony Brook or Eastman Avenue on or about February 23rd of 2022?
I don't recall who said, but I do recall that during the time that officers were called to the Stony Brook residence, that there was another call that officers were on that might have involved gunshots.
At some other location, though, correct?
I'm sorry?
At some other location, not Stony Brook or Eastman Avenue, correct?
Correct.
During the interview that you had with Taylor Schabusiness, did it go on for about 6 hours?
That's an estimate on my part. I'm not sure.
That's fair. That's fair. So you started in the morning, and then at some point you took a break because she had to go over to St. Vincent's Hospital,
Yes.
and then you came back and then resumed the interview, correct?
Yes.
All at the Green Bay Police Department?
Yes.
You had a chance to look at her hands, her thumbs, and her fingers, correct?
Yes.
She had some scratches and some deep cuts on her thumbs and fingers, is that fair?
She had a cut on her thumb and some scratches, yes.
And she got medical treatment for that?
Yes.
Were there, when you asked Ms. Schabusiness some questions, sometimes she was non-responsive, is that fair?
No.
She did not answer your question every time you asked one, is that fair?
I would not say that is correct.
She said some odd or weird things, though, correct? During the interview? Specifically, well, the arm or something like that would rebuild into muscle?
Well, yes, she made several comments of, when she was strangling Mr. Thyrion that, his muscle would rebuild, and made several comments about, that she forgot to leave the head behind in the bucket in the basement. Those types of comments in terms of describing her actions and what she was doing, but in terms of those being bizarre, I did not find that to be in any way, shape, or form.
You found it to be odd, though, especially when she laughed about it, correct?
Well, I did not feel that way.
Okay. But she did laugh about it when you talked about it, correct?
I think maybe at one point there was kind of a smirk or something, but it was in the context of just how she replied back to me.
And she did tell you that on some date before February 23rd of 2022 that her and Mr. Thyrion were smoking ice, correct?
Smoking, yes. Ice, or methamphetamine.
Yeah. She used the word bitch, correct?
Initially.
And then it changed from ice to methamphetamine, yes?
Yes.
And then she indicated that a meth pipe and a plastic bindle would be in the basement?
She said that.
She told you that it was a weird night, is that correct?
I'm sorry, can you repeat that?
Did she say that it was a weird night?
That's possible.
Okay. And then she did talk about drugs, and she talked about the fact that she's been off drugs, and then she's on drugs. She said words to that effect, is that right?
We did talk about her drug use in the days previous to the interview. I believe she did make comments of using drugs in the past.
Okay.
As term of her, how much, I don't recall that.
Okay. And fair to say that during the interview, oftentimes Ms. Schabusiness would say, I don't know. She didn't know the answer to your question?
I'm sure that she probably had some of those answers.
She would say, I have no idea, correct?
I guess I would have to know specifically what I was asking her.
And is it fair to say that some of the things that she said just didn't make sense?
No.
You sort of had a narrative and she kind of went along with it, correct?
I would not say that, no. I did repeat several of things that she would say to clarify, but I would not say that I led her in any way.
When you were talking to her, oftentimes she'd have her hand over her mouth, correct?
It's possible.
And she would talk very softly, correct?
I was able to hear her.
But she did talk softly, correct?
I don't know.
She said something about that she was tweaking out, or that she was tweaking. Do you know what she meant by that?
I do not recall those specific words. I would know what she would mean by tweaking out, though, yes. And I don't recall as to what time period she was talking about either.
Okay. Is it fair to say that the first part of your interview was about 3 hours and then you went to the hospital?
That's fair.
You came back, and then the second part, was that about 3 hours, or how long was it?
I'm not sure.
Not sure. A couple hours, though?
Sure.
Okay. Took a while to ask questions and try to figure out what was going on. Fair?
Right. As I was interviewing her, there are investigators who were at the house, and so it was an ongoing and continuing investigation to determine what happened.
Right. During the interview that you had with her, she said, "I didn't mean for all this to happen. I'm sorry." Is that fair?
I think that she did make a comment as to initially that she did not mean to kill Mr. Schabusiness. I'm sorry, Mr. Thyrion.
You had cases involving asphyxiation, correct?
Yes.
And can you tell me what we mean by that? Is it choking?
Asphyxiation?
Yes.
Choking is another word. Is when someone's windpipe or has been blocked and breathing has been obstructed.
Okay. Is it a situation where people that maybe are into this kind of thing choke each other to get some euphoria or pleasure out of it?
I have heard of that practice.
Okay. With regards to this case, law enforcement did find 2 dog collars or 2 chains. Is that fair?
Yes.
During the interview, Ms. Schabusiness said something about, "I can't think right now." Remember that?
No.
She said, "I'm fucking nuts." Remember that?
No.
Were you surprised by some of the things that she said to you?
Overall, in the context of what we were discussing and the information that had been provided to me?
Yes. And did she tell you that the body can rebuild itself?
She made that comment, yes.
There was a second interview on February 28th of 2022 back at the Green Bay Police Department, correct?
Yes,
And Detective Scanlon was there for that?
he was.
Did he kind of ask most of the questions for that interview?
I think it was 50-50 on both our parts.
And did Ms. Schabusiness indicate to you or to Detective Scanlon that she was freaking out?
I do not recall those exact words. It's possible.
Okay. Do you recall, though, that she talked about having a lot of issues with open areas? Remember that?
She was talking specifically about the basement area that she was in.
She didn't like the open area, though, correct?
No.
I'm correct on that?
I'm sorry?
I'm correct that she did not like the open area, is that right?
She did not like the open area of the basement at Stony Brook
Okay.
in Green Bay.
Thanks, that clears that up for me. Her emotions came out during the interview, is that correct?
It's possible.
Did she tell you that she got very angry at herself?
Once again, it was quite a lengthy interview. I do not recall every single comment that she made.
Okay. She did say during the interview that there were some times where she nodded out, correct?
Yes, I do recall that.
And she indicated to you that her and Shad went in the basement and within about 5 minutes got to it, correct?
Got to it.
Yes.
She stated that Chad produced a couple chains. Yes.
Yeah. Within 5 minutes of being down there, correct?
Correct.
And she told you there was no kissing, correct?
I do not remember that at all.
And she told you there was no sex, correct?
She said that it was starting to lead that way, but there was no sex while Shad was alive.
There was no penis to vagina sexual intercourse going on, correct? Is that fair?
Penis to vagina, no.
I'm correct about that, right?
She never stated that that occurred.
Okay. And did she indicate that her and Shad Thyrion had took a toke off of some meth at the Eastman Avenue apartment in the bedroom?
Yes.
Okay, I have nothing further.
Just very briefly, you were asked about a couple of terms, nodding out and tweaking. Are those terms that you have encountered in your experience as a detective or as a narcotics investigator?
Yes.
What do those terms mean to you, starting with nodding out?
Nodding out is a term typically heroin users would describe when they would become drowsy.
As a result of the drug use?
As a result of the drug use.
And how about tweaking?
Tweaking it can refer to methamphetamine users. It's a stimulant, so it could cause them to be hyper or sudden body movements, and that is a result of the use of methamphetamine.
No further questions.
Anything on that, Mr. Freilich?
No.
Okay, thank you. You can step down. Does the state have any other witnesses?
No, Your Honor. At this time, the state rests.
Okay. Ladies and gentlemen, the state has now rested their case. We're going to take a brief recess, and we'll reconvene in about 10 minutes. All rise for the jury. All right, be seated. The state has rested. Then, Mr. Freilich, the case would then turn to the defense. Do you intend to call witnesses, or do you want to address me on the stipulated facts?
Yes, before I do that, Your Honor, I'd like to make a motion for a directed verdict. Ask that the court consider...
Use the microphone.
Oh, sorry. Ask that the court consider that as it relates to the first-degree intentional homicide count, I would argue that there is insufficient evidence to support that particular charge. There's insufficient evidence to show that my client, Taylor Denise Schabusiness, had any intent to kill St. Shad Thyrion. What we have here is some testimony from a number of law enforcement officers. We also have some video footage from an interview between my client and Detective Groff and Detective Kempf. it's clear that my client likely did consume and ingest methamphetamine with Mr. Thyrion prior to his death. My client provided commentary and answered questions from Detective Groff. I would submit that what she indicated that was that she had no intent to kill. The question is, did my client do it or not? That's another question. There are a lot of different issues here going on, but based on what she said to the detective, I'd ask that the court consider dismissal of the first-degree intentional homicide charge on the grounds that there was no intent to kill. Also, there are really no eyewitnesses to whatever went on in the basement at 829 Stony Brook Lane in Green Bay. When Tara Pakinich and Stephen Hendricks went downstairs, they didn't find anybody down there. They found body parts, unfortunately, but they did not find my client there. My client was at 2353 Eastman Avenue, and that's where she was arrested. And there were no body parts over there. There were body parts in a van that was owned by Scott Tomes. That's not my client's minivan. That gold Town and Country Chrysler minivan belonged to Mr. Tomes. So there are a lot of issues here. As to the third-degree sexual assault charge, the state's got to prove that my client had sexual intercourse with Shad Thyrion. I believe, based on this record, and the video, there's no evidence to show that my client had any kind of penis-to-vagina contact with Mr. Thyrion. We have testimony from the DNA expert that indicated it was uninformative as to the dildo. And I know that my client claimed that the dildo was used on Mr. Thyrion, but there's no DNA evidence on that. And so I would ask that the court consider dismissal of the third-degree sexual assault charge as well for those reasons. Thank you. Finally, as to the mutilating a corpse, count 2, again, there are no eyewitnesses to observe what really happened in the basement on the dating question. So for all these reasons, I'd ask that the court consider the motion for a directed verdict and dismiss these charges.
Mr. Saunders.
A reasonable juror viewing the evidence in the light most favorable to the state could convict. The state's met its burden. His motion should be denied.
Okay, well, these motions are fairly common in cases like this, and the court does have to, in these circumstances, look at the evidence in the light most favorable to the non-moving party. This is by no way the court making a decision about what the ultimate verdict in the case will be. That's up to the jury, not up to me. But the court's task at this point is to take a look at the four corners of the record, the evidence, to see whether the state has satisfied their burden of proof, at least to this point, such that the matter can move forward and be given to a jury. Each of these counts has two elements. The homicide count has two elements. The mutilating a corpse count has two elements, and the third-degree sexual assault count also has two elements. And the court is satisfied when considering the entire record in this case that a reasonable jury could conclude that the state has met its burden and convict based upon the evidence that has been offered thus far. Again, I'm to look at the evidence in the light most favorable to the non-moving party. That isn't necessarily how a jury will look at it in their deliberations, but that's what I'm to do at this particular point. And in doing so, I'm satisfied that these motions for directed verdict should be denied, and that's what the court does at this time. So those motions are denied. And so I'm going to turn back to you, Mr. Freilich. My understanding is, as a result of Mr. Tomes not being here due to some health issues, that there's been a set of stipulated facts.
Yes, Your Honor, but before I do that, I know that my investigator had made attempts to contact Scott Tomes as part of the defense investigation in this case, and my investigator was not successful in making contact. But we did get a subpoena out, and the Brown County Sheriff's Department, I believe, subpoenaed Scott Holmes for court as a defense witness. The prosecutors did inform me promptly that he is not going to be available. Maybe he's got health problems or hospitalized, but they told me that he is not available. I've advised my client of this. I find that, and I'm not blaming the state, but I'm blaming him, that the timing of this seems suspect to me, that he's not available. I haven't seen any report, doctor's note, anything like that. So before I answer the court's question, I'd ask that the court consider a motion for mistrial because this witness is not here, has been properly subpoenaed, and I really have no recourse to call him and question him about the issues in this case. So I'd ask that you consider that motion.
Well, before I turn to the state and ask for their response, Mr. Freilich, what can you tell me? What was your expectation of what he was going to testify to?
Well, I have some highlighted sections from his statement that the state and I agreed on as to what his testimony would be about. But, you know, when you call a witness, there may be other things that come up. But I'm working off a statement. I've highlighted the yellow parts that would be told to the jury if the court felt that was appropriate. But I felt the need, because I'm at this kind of crossroads with this kind of problem, that I would make this motion first.
Okay, sure. But I don't think you have my question, because the question is, you've asked for a mistrial based upon the unavailability of this witness. So the question is, what was he going to testify to so that I can assess the gravity of his not being here?
I understand. Okay. Thank you. I believe that he would testify that on that Monday night, I believe that would have been February 21st of 2022, that that Mr. Thyrion and Ms. Schabusiness came over, that he did not know Shad's last name, but he saw him before, and that he believed that they hooked up to get some meth or do meth. That would have been about 9 p.m. on Monday night, and that he had this gold Chrysler Town & Country minivan, and his keys were on a lanyard which hangs on a hook by his front door, and that he indicated that Taylor Schabusiness has used his vehicle in the past, but with his permission, and that she's always asked to use it. And then he said she did not ask to use the vehicle last night, and that he did not give her permission to take the vehicle. And he said he did not call the police to report the vehicle missing. And then he indicated that he was drinking some whiskey and cranberry juice, and that he sometimes gets drunk but not inebriated. He indicated around midnight, Ms. Schabusiness returned home with his vehicle, and she went basically directly to her bedroom, that he had a suspicion she may be high on drugs, and that he believed the police arrived 15 or 20 minutes after Ms. Schabusiness got home. And then he talked about the living arrangements in the apartment, and that Ms. Schabusiness stays in the bedroom and he sleeps in his chair in the living room. So.
Okay. So the first thing I want to take up is Mr. Freilich's motion for a mistrial based upon the unavailability of Mr. Tomes.
I think the motion should be denied. Essentially, everything counsel stated, the state is willing and has prepared a stipulation to that effect. So obviously I don't think that the drastic remedy of a mistrial is necessary. I do want to be quite clear. The state does not control Mr. Tomes. We in no way told him to disregard a defense subpoena as part of our case. We chose not to call him. We were advised about the medical issue, and we passed that information along to defense counsel. So I don't want it to be this record that we are influencing his unavailability in any way. Obviously, counsel can still attempt to have him here and still attempt to produce him. It's an issue the state deals with fairly regularly in trials. That isn't being done, so I don't think the defense failing to produce a defense witness is grounds for a mistrial, particularly when the state's willing to stipulate to everything the defense seeks to elicit, essentially.
Your Honor, I want to let the court know that Mr. Saunders promptly let me know of this situation as soon as he found out about it, so that was appreciated.
Okay, I don't want all the details, but as far as a medical issue, I mean, if you have a bad cold, that's a medical issue. If you are in the hospital for serious surgery, that's a medical issue too. Is he incapacitated? Is he just staying at home because he doesn't feel like getting out? Do we have a sense of that?
I think the latter. The information we received is that he was in hospital and would be for several weeks. That was the information we received from a relative.
Okay. Okay, well, so in front of me then is a motion for a mistrial. A number of things. First of all, when I listened to the recitation of the information that Mr. Tomes was going to testify to, first of all, I'm satisfied that a lot of that information has already been testified to by other witnesses, particularly the individual, the mutual friend of Mr. Thyrion's and Ms. Schabusiness's, who was here yesterday, testified to some of the events that occurred at Mr. Tomes' apartment. Frankly, some of the other information that Mr. Tomes was going to be testifying to that was referenced by Mr. Freilich, I think was brought in through some other of the witnesses. The information about what Ms. Schabusiness did with Mr. Thyrion while they were at Mr. Tomes' apartment. There was reference to potentially utilizing controlled substances there, that perhaps Mr. Tomes was in either a different part of the house or had his gaze focused somewhere else while they utilized controlled substances behind his back so he didn't see. That kind of information has come in other areas. Really, the only piece of information that I heard that doesn't sound like it came in any other fashion, except by indirect statements from Ms. Schabusiness in her interview with law enforcement, was the comment that when she used his van in the past, she asked permission, and that she didn't ask for permission that night to use his van. And there's a couple of things about that particular piece of information. I remember the information in the video where the detective was asking her questions, and she indicated in response to her question, I don't know if he knew that I was leaving or not. I don't know. I think she was uncertain whether Mr. Tomes actually knew that she was leaving. And the reality of it is, if she was utilizing his van and she was uncertain whether or not she even knew about it, whether or not he even knew about it, then that might confirm a statement whereby Mr. Tomes says, yeah, she usually asked for permission, but that night she didn't. That would be very consistent with what she reported in her interview. Beyond that, I'm not really sure the extent to which that piece of information is so relevant that his presence is needed here as opposed to stipulating to the facts that are outlined. For all those reasons, I'm satisfied that the fact that he hasn't responded and arrived here today due to medical reasons, I'm not going to grant a mistrial for that reason. I am then going to turn to the parties to determine if there's anything else that needs to be recited regarding that stipulated set of facts, or whether, Mr. Freilich, you've actually gone through and recited it there. Is that what you would intend to have recited?
Mr. Saunders has it, Your Honor. So I'm just going to take another look at it real quick. And what I did was highlighted in yellow the relevant sections from the statement he gave to police, and then Mr. Saunders' office had it typed out, so it's in proper order.
Okay. Gentlemen, how do you want that submitted into the record?
I can mark it, and then perhaps the court can just read it at some point during the defense case.
You want the court to read it?
Yes, please.
Okay. Sure. Well, then we'll mark it as Exhibit 111.
Thank you.
Okay. All right. So then just for my own edification, Mr. Freilich, I would intend to read this to the jury as soon as they're brought back in.
Okay.
Other than potentially your client testifying, do you have any other witnesses that you, because then we're going to move right into other witnesses, but if you said, well, that's the only one, and then the only issue is whether your client's going to testify, then how we'll proceed is I'll bring in the jury, I'll read in these stipulated facts, I'll excuse the jury again, and then I'll have the colloquy with your client about her testimony. So can you give me a sense, do you have other witnesses?
Your Honor, I've looked at my list here. A lot of the witnesses I was going to call have already been called, so I think we're good. I will need some additional time to confer with my client on whether she wishes to testify or not, but
Okay.
that's where we're at.
All right, well then,
Just,
Mr. Saunders.
can I just quick, I know some of the defense, some of the law enforcement officers had defense subpoenas. Is it okay to cancel them then?
Yes, it is.
Thank you.
Okay, it sounds like all the other subpoenas that are out there are now canceled, okay?
Thank you.
Anything else before bringing in the jury, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay, so I'll bring in the jury, folks. I'll read them this stipulated facts. I'm going to excuse them again. We'll break for a little more so you can speak with your client about testifying, and then we'll come back and I'll have that colloquy with her and go from there, okay?
Okay, thank you very much.
Be seated. Ladies and gentlemen of the jury, the state of Wisconsin, the attorney for the defendant, and the defendant have stipulated or agreed that if Scott Tomes had been called as a witness, he would have testified as follows. Scott Tomes was interviewed by a Green Bay Police Department detective on February 23, 2022, and stated that on Monday night, the defendant had a friend over named Shad. Mr. Tomes did not know Shad's last name, but had seen him before. Mr. Tomes indicated he believed Ms. Schabusiness hooked up with Shad to get and do meth. He believed this was about 9 p.m. on Monday night. Mr. Tomes stated that he had his car keys on a lanyard which hangs on a hook next to the front door. Tomes stated his vehicle is a gold Chrysler Town & Country with Wisconsin tag 580ZJZ. Mr. Tomes stated Taylor has used his vehicle in the past, but with his permission, and that she always asked him to use it. She stated Ms. Schabusiness did not ask him to use his car last night and that he did not give her permission to take his vehicle. He did not report the vehicle missing. Mr. Tomes stated he was drinking last night and indicated he gets drunk but not inebriated. He indicated that around midnight, Taylor returned home with his vehicle. He stated she basically went directly into her bedroom. Mr. Tomes suspected Taylor was high on drugs. Mr. Tomes believed the police arrived 15 to 20 minutes after Taylor got home. Mr. Tomes was also asked about the living arrangements in his apartment and stated that Taylor stays in the bedroom and he sleeps in his chair in the living room. Mr. Tomes was later interviewed by a Green Bay Police Department detective on March 9, 2022. Mr. Tomes stated that A.J. Gannon and Taylor Schabusiness were at the Eastman Avenue apartment on Monday, February 21, 2022, before they left and came back with Shad Thyrion. Mr. Tomes stated that Gannon did leave on his own, leaving Taylor and Shad still at the residence. You will consider that testimony in the same manner as if it had been given under oath here in court. I have marked that as Exhibit 111, and that's being offered, Mr. Freilich?
Yes, it is, Your Honor.
Exhibit 111 will be received.
Your Honor, could that be published to the jury? Or probably not necessary, I guess.
I'm
I'll
not going to
withdraw
publish it to the jury because that would involve either putting it up on the screen or passing it through there, and I'm not going to have them read it. But it is Exhibit 111.
Thank you.
And then, ladies and gentlemen, I'm going to excuse you briefly again, so all rise for the jury. Be seated. Well, Mr. Freilich, my understanding is you'd like to speak with your client for a little bit about her decision as to whether or not to testify. Is that correct?
That's correct, whether she's going to testify or not testify.
My understanding is you can do that right back there to the side door. So we'll be in recess then. I'm going to be checking in on you, Mr. Freilich, by 25 after. But if you need a little more time than that, you need to let us know. But I'm going to check in with you about that time, okay?
Okay. Can you just give me till 2:30, Your Honor?
Sure.
Okay.
2:30.
All right, thank
We're
you.
in recess.
Anybody here that's done anything, and you know, maybe they should have had some doorway for the jurors to leave from. I mean, I saw a couple of them eating lunch together around the picnic table. I mean, anybody could take a picture of them, and then a friend would say, "What are you doing at the courthouse?" So I don't know. I just think that they're, but they said that they'll look and see if anyone is using their phone and taping. So I know, but that's a lot of trouble for something that probably just happened outside of instantly. Yeah. The anthrax. So should we take a cool or whether she's going to testify?
Your Honor, I've had an extended time period. I appreciate it to talk to my client. We've talked about this prior to trial, but we talked again about it today. I've advised her that she has an absolute right to testify if she wishes, and she also has a right to not testify if she so chooses. I've given her advice. I've conferred with her. We've talked about this particular issue. It's her decision not to testify and exercise her right to remain silent.
Okay. Then I'll engage her in a colloquy about that in just a minute. But Mr. Freilich, then would it be my understanding that that you have no more witnesses, what you indicated before, and that you'd be, when the jury comes back in, you'll be resting?
That's correct.
Okay. Okay. Then, Mr. Business, I need to address you personally. So, your attorney told me that he just spoke with you about some of your constitutional rights that are coming up right now, and those rights are that you have an absolute right to testify, and you have an absolute right not to testify. Do you understand that?
Yes.
Okay. Mr. Freilich, the microphone. Not yours, hers.
Sorry about that.
So, Mr. Business, those rights belong to you. They don't belong to Mr. Freilich. They don't belong to the state. They don't belong to me. Those rights belong to you and you alone. Do you understand that?
Yes.
Okay. My understanding from listening to Mr. Freilich is that you've decided that you would like to exercise your right not to testify. Is that correct?
That is.
Okay. Now, I know you've spoken with your attorney. Do you feel you need any more time to talk to your attorney about that decision?
No, I do not.
Has anybody made any threats or promises to you to get you to make that decision here today?
No.
Okay. Any further inquiry you'd like me to make, Mr. Lizet or Mr. Saunders?
No.
Mr. Freilich, any further inquiry you'd like me to make of your client regarding that decision?
Just inquire if there's been any pressure on her.
Okay. Mr. Business, has anybody placed any kind of pressure on you to make that decision?
No.
Okay. All right. Well, I'm satisfied based upon the conversation that I've had here with Ms. Schabusiness that, number one, she understands her rights. She has both of the rights to testify and to not testify. The issue, of course, being you can't exercise both of those rights at the same time. You can only choose one. She's choosing the right not to testify here today. I'm satisfied that she's done that after consulting with her attorney. They took a little bit of extra time. I gave them better than 10 minutes to speak about that. That was the amount of time that Mr. Freilich wanted, and they were back here when I came into court, so they've had an opportunity to discuss that. Ms. Schabusiness has indicated to me she doesn't need any more time to speak with her attorney about that decision, and I'm satisfied that her decision is freely, voluntarily, and intelligently made here today. Of course, when it comes time to address the jury instructions, Mr. Freilich will have to address, I think it's instruction 315, I think that's the instruction about that I could give to the jury potentially about, and I'm not sure if it's in your packet, but we'll certainly take it up. It's an instruction about instructing the jury that they're not to hold her decision not to testify against her, and that's another choice that she will have to make. If it's not in the packet, I'll get it for you, Mr. Freilich, but I'm sure you've done enough trials, you're aware of that instruction, and I'll make sure it's available to you, and we'll have that conversation later, okay?
Yes, Your Honor. Thank you.
Very good. I'm satisfied, therefore, that Ms. Schabusiness is choosing not to testify. Then what we do is we'll bring the jury back in. I'll ask Mr. Freilich if he has any other witnesses. Mr. Freilich, based upon the representations he's made, is going to indicate that he's going to rest. And then we have a choice really to make as to how far we want to go today with the jury sitting here. Either try to press forward or to release the jury and work on the jury instructions and start tomorrow with instructions and closing arguments. Does the state have a preference as to either of those? Mr. Saunders?
Our preference would be to proceed today.
Any objection to that, Mr. Freilich?
My preference would be to go with the jury instructions today and proceed tomorrow with opening or with closing statements.
Okay. Well, I can tell you that I don't have to make that decision right at this minute. I'm going to bring the jury in. We're going to finish up the case, and we'll go from there, and then I'll let you know what I've decided as far as that goes. All rise for the jury. Okay, be seated. Okay. Ladies and gentlemen, the case is still with the defense, so I'm going to turn to Mr. Freilich. Mr. Freilich, do you have any other witnesses you wish to call?
Your Honor, no other witnesses. Defense rests.
Ladies and gentlemen of the jury, the defense has rested, so the evidentiary portion of this portion of the trial is now concluded. Just to give you a little bit of a roadmap as to what occurs now, the attorneys and I need to work a little bit on finalizing the instructions that I need to give you regarding the law. Then the attorneys would do closing arguments, and then you would go into deliberations. What I'm going to do is I'm going to excuse you again, and I'm going to start working on these jury instructions with the attorneys. I'm not thinking it's going to take us too long, but probably longer than the other breaks you've had. But that's what's going on. Progress is being made. And I'm hoping that within a half hour, maybe slightly more than that, you'll have a better sense of the timing for the rest of today. If I run into problems, perhaps I would dismiss you for today, but at this point I'm thinking that I'm going to have you wait, and we'll get into instructions and closing arguments today. So that's a bit of a roadmap going forward, but with that, I'm going to excuse you again. All rise for the jury. Whether to move forward today or break, send the jury home early, and then come back tomorrow. I'm always keeping in mind just the timing that we gave them overall, that this trial would take about a week. I'm concerned, I don't know the duration of the next phase of this trial. I'm concerned that if we come back and finish this piece tomorrow, I don't know how long deliberations will go on the first phase, and then we have the second phase. So I'm not inclined to stop at this point. I'm inclined to push forward. And having said that, then, I think my judicial assistant should have put on your tables copies of the proposed jury instructions and verdict forms. Mr. Saunders, did you get a copy of those?
I did.
Mr. Freilich?
Yes.
Okay. Then what I'd like to do is just go through with you those instructions. There are going to need to be some modifications, which my judicial assistant and I will work on when we break. But starting out with, I would propose giving jury instruction 100. I will note that I'm going to jump way to the end after starting at the beginning, that instruction 602 is instruction after evidence has been received on issue of guilt, where a plea of not guilty has been joined with a plea of not guilty by reason of mental disease or defect. It's suggested that this portion, or that this piece, this instruction, be inserted to instruction 100 or given following the instruction on the offense charged. My inclination is to put it right at the end of 100 because in my mind that's where it makes most sense. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay. Then I would intend on giving 103 evidence defined. Then I would intend on giving also 115, one defendant, 3 counts. There's a couple of modifications that need to be made here. First of all, on the version that you have, I've used the initials SRT for Mr. Thyrion, and I think we already talked about that way back when we were picking the jury, that we were just going to insert Shad Thyrion, and that's what I would propose to do. In fact, I've already told my judicial assistant to make that change. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
All right. The other thing that I'm not sure if it was corrected on your version, I think it was, and I'll raise this issue. The criminal complaint had the date here as February 22nd, whereas the information had February 23rd. The first draft that I looked at that I had my judicial assistant work on had February 22nd. we changed it to the 23rd. I just want to make sure, I think in your copy that you have, it should say the 23rd. I just want to make sure that that's the date we're looking at.
Mine
That's the
says February
information.
22nd.
Yeah, it
It
says,
says the 22nd?
Yes.
Okay, so here's what happened. I made the changes in the version that she gave me. She didn't correct it in the version she gave you. But I'm aware of that issue. It's not something like, my God, I'm not expecting that we're getting all these typos. I knew about that issue. That's why I'm raising it. I fixed it in every other time I've read it to the jury. I had it as the 23rd because that's what the information says. But the first time that these proposed instructions were drafted for me to start reviewing was before we even selected a jury. I was working on these, and it said the 22nd. So I had her change it, but clearly that didn't happen in your version. It should be the 23rd, Mr. Saunders, am I correct?
no, it should be the 22nd.
Okay.
Tuesday the 22nd. The draft we have says Wednesday the 22nd. I think the information's right. The criminal complaint was in error, and that's the state filed an amended criminal complaint fixing that date. In any event, I think based on the testimony, it should be February 22nd.
And so now I'm wondering if I was mistaken, because I recall at the time I was preparing my initial instructions to give to the jury, I asked my judicial assistant to check with the information and make sure that the date that I instructed comported with that. So now I'm thinking she changed your versions, and I'm looking at the old version because mine says the 23rd, but yours actually has the right date. So I think the 22nd, because that is that's in the information. That's the instruction that I gave to the jury at the beginning. So we'll use the 22nd. Any objection to that, Mr. Freilich? That's what the information says.
Your Honor, just from my perspective, I'm looking at a criminal complaint that was filed on March 1st of 2022, and the charging date is Wednesday, February 23rd of 2022. You know, it's confusing. It's complicated because we don't know the exact date when this may or may not have occurred. Was it February 22nd, February 23rd? I don't know.
Sure. There's a couple of things I'd respond to that, Mr. Freilich. First thing I'd respond to that is the information is the charging document, not the criminal complaint. That's the first thing I'd say. The other thing I'd say is instruction 255, which has been proposed to me, is the instruction stating state need not prove exact date of commission. We'll get to that in a minute, but I'm satisfied that the charging document is the one we need to follow because that's the official charging document as opposed to the criminal complaint. So I don't know what was heard at the preliminary hearing in this case or what the waiver was to, but that's what the charging document says.
Your Honor, just to, the court probably already knows this, I just want to make a record. The criminal complaint does have February 23rd of 2022 as the charging date, filed on March 1st of 2022, Brown County, Wisconsin. And then the information, which is the charging document, that has a different date, February 22nd of 2022, and that was filed June 2nd of 2022. For me, it's a little bit different because I wasn't the lawyer at that time. It was Attorney Jolly, but I'm just noting that all for the record.
What, and to what end? Are you asking me for something?
Well,
I mean, if the state thought it was on the 23rd and then they changed it to the 22nd, it would appear to me that it's not clear what date this allegedly happened.
Okay. Well, what I'm indicating to you is that the charging document is the one that's going to be accurately reflected in the instructions. And I'm also noting 255, which we'll get to in a minute, addresses this very issue. So I'm going to change, I'm not sure if that's an official objection, Mr. Freilich, to, and I'm not sure what you're suggesting, but the instruction 115 is going to have Tuesday, February 22nd, 2022 in the city of Green Bay, Brown County, Wisconsin. And then where it indicates SRT, it's going to say Shad Thyrion. So 115 contains 110, first degree intentional homicide. It contains 1193, mutilating a corpse. And in that particular instruction, we need to look at the element piece. And it would seem to me that the word that has been utilized in this case is dismembered, but we have to make a alternative selection. Mr. Saunders?
Yeah, I have no objection to that.
Okay.
Dismembered.
Mr. Freilich, dismembered?
Are you asking whether to use mutilated, disfigured, or dismembered?
Yes.
Can I have a minute to confer with my client? Yes, we would agree with dismembered.
Okay.
Your Honor, that last comment was an objection, just to let you know.
Then the other selection we need to make there is in the very next sentence. This requires that the defendant acted with the purpose to conceal a crime or avoid apprehension, prosecution, or conviction of a crime. So, Mr. Saunders, does the state have a specific request?
I think conceal a crime fits the facts best. So,
Mr. Freilich?
Agreed.
Okay. Conceal a crime will be the alternative we'll select in instruction 1193. Then we move on to count 3. That's instruction 1218A, third degree sexual assault, sexual intercourse without consent. Again, the changes from SRT to Shad Thyrion will be made, although there aren't any other alternative selections that need to be made. So that instruction will be changed. You'll get a chance to review the final version, and then that's the one that I would give. Moving on, I would propose to give instruction 140, burden of proof and presumption of innocence. 145, information, not evidence. 147, improper questions. 148, objections of counsel, evidence received over objection. 150, stricken testimony. There was very little stricken testimony, but I think on only one occasion did I strike any testimony, but I'm going to give 150 because I think it's appropriate. 155, exhibits I will give. 157, remarks of counsel I'll give. There's 158. I've already given that at various times, so I will not give that again. That's recording played to a jury, and it's supposed to be done at the time, and we did that, so I won't give it again. 160, closing arguments of counsel. I will give that one. Next one is 170, circumstantial evidence, and then what I direct the attorney's attention to is the bold or the capitalized instruction indicating that if evidence of flight, escape, or concealment has been admitted, see instruction 172. That's included here. I would propose to give both instruction 170 and 172. Any objection to that, Mr. Saunders?
no.
Mr. Freilich?
No, Your Honor.
Okay. On 172, we need to make some selections. The first line, evidence has been presented relating to the defendant's conduct after the alleged crime was committed or after the defendant was accused of the crime. I think the first option is the appropriate one. Mr. Saunders?
I agree.
Mr. Freilich?
I agree.
All right. Option 1 will be selected. Okay, moving on. 180. There needs to be some work on that. I intend to give 180. The capitalized portion of the instruction indicates, add the following if a statement resulting from an unrecorded custodial interrogation is admitted at trial for a felony and no exception applies. I don't think that applies in this case because although there was custodial interrogation that was offered, it wasn't unrecorded. In fact, it was entirely recorded. So I think I take that paragraph out, but then continue on with the bottom paragraph. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
Taking off that bottom paragraph where it says continue with the following in all cases, you want to
No.
excise that?
No. The portion that says continue with the following in all cases, I would give it because, well, this is a part of all cases. The paragraph I would excise is the one just before it, where it starts, it is the policy of this state to make an audio or audio and visual recording. I'd take that paragraph out.
In the brackets?
Yes.
Okay, I have no objection to that.
Okay. Then I'll move on. I'll give 190 weight of evidence, 195 jurors' knowledge. I would give 200 expert testimony general. So there's some selections that need to be made there, or at least addressed. It says continue with the following if experts have given conflicting testimony. I don't think that's the case, so I would propose to delete that portion. Any objection, Mr. Saunders?
No.
Mr. Freilich?
And the bottom bracket as well, the two brackets?
Right, that's the part that they're saying continue with the following.
I'm just asking if you're going to take those out.
Yeah.
Okay, yes.
Okay, 255, this is the one, state need not prove exact date of commission, specific date alleged. That essentially says if you find that the offense charge was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt that the offense was committed on a date near the date alleged, that is sufficient. You're asking for that, Mr. Saunders?
Yes.
Mr. Freilich, any objection?
Well, it's kind of a conundrum because they file a criminal complaint with one date, then they file the information, which is the charging document, with a different date, but then they're saying they don't have to prove the exact date. So I'm kind of confused on that, Your Honor. So I have lodged an objection to that.
Okay, I'm going to give 255. I'm satisfied that the date in the information is the date that needs to be instructed because that's the charging document, but I'm also satisfied that this is an appropriate instruction to give in light of, frankly, the entirety of the evidence that I've heard. I'm satisfied that, frankly, given that the timing, the time of day that's occurring, that knowing when one day flipped to the next may not be so easy to pin down. So I'm satisfied this is an appropriate instruction. I'm going to give that as revised. I'm then going to give 300 credibility of witnesses. There is an option at the end that says give the following paragraph only when the defendant testifies. Given that the defendant didn't testify, I would propose to delete that and the bracketed paragraph just below it. And but then continue on with the last paragraph indicating there is no magic way for you to evaluate the testimony. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. Moving on, 325, impeachment of witness, prior conviction or juvenile adjudication. I don't think anyone was asked that question, and I don't think anybody was impeached with a prior conviction. So I propose to take 325 out. Mr. Saunders, any objection?
No.
Mr. Freilich?
I agree.
Okay, that'll be out.
Thank you.
327, impeachment of defendant as witness, prior conviction or a juvenile adjudication. The defendant didn't testify. I propose to take that out. Any objection, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
That'll be out. 460, closing instruction, I would propose to give that. Then I would propose 484, verdict submitted for one defendant, 3 counts, separate verdict on each count required. I would propose to give 515, unanimous verdict and selection of presiding juror. And that's it. You'll have another opportunity to look at these after I've made those revisions, but such as they are, Mr. Saunders, any objection to the entirety of those instructions or anything I'm missing or that you'd like me to add?
Yeah, 2 additions that I'd propose. Madam Clerk, are the copies? Okay, I have one for the courts and council. The first is based on some testimony that we heard. It'd be our request to make clear that voluntary intoxication is not a defense. In the case, there's not a pattern jury instruction that really says that. There's a part of 755A that does have that sentence, and the state would ask that just that sentence be read given the state of the law and the state of the voluntary intoxication defense.
So you're saying this is coming out of 755A?
Correct. It's not directly applicable, but as modified, I believe it's accurate.
Let me take a look at it. Mr. Freilich,
Yes.
any response to their request for 755A? Just so you know, Mr. Freilich, and I know you don't have the benefit of having your computer sitting right in front of you, regarding 755A. 755A is an instruction that is titled as follows: involuntary intoxication or drug condition. So it looks as if Mr. Saunders has utilized that pattern instruction. Mr. Saunders, if I'm correct, you've utilized that pattern instruction to craft this, and he's proposing that this be given. Any objection to that?
No, Your Honor.
Okay.
I know the law.
Okay. So that's fine. I will give this modified 755A. Generally, other than sometimes rearranging where the closing instruction goes, I give these in numerical order. That would put it right at the end. I don't propose to put it right at the end, because the last one I generally give is 515, unanimous verdict and selection of a presiding juror. I think that is the best to have at the end. Proposal as to where we insert it, Mr. Saunders?
I would say right after the 115, the substantive jury instructions. That makes sense.
Any objection to inserting it there, Mr. Freilich, right after 115, the substantive instructions?
Your Honor, if I could just have a minute. Yes, that makes sense.
Okay. Very good. Okay, we've taken that one up. Then, before I move on, do you have a Word document with these on it that
I
you
do.
can forward to my judicial assistant?
Okay.
One of you, so that because I'm going to be heading over there shortly to finish these off, and we'll need it. But let's look at, you don't have to do that till we're done, but let's look at your other request then, Mr. Saunders.
Yeah, so obviously that issue, or this issue, has been addressed in litigation. There was a motion to dismiss regarding the state doesn't need to prove that a crime victim was alive or deceased at the time of the sexual intercourse. And I think the state just envisioned a jury having that question, given the two elements don't clearly explain what I think is an accurate statement of the law. So our request would be to add something to address that issue, because obviously it's the facts and circumstances that the state's alleging in this case.
Okay. Well, let me just, before I turn to Mr. Freilich to take a look at his position on this, I'm just going to pull up the statute. Because we did have this issue that was raised as at the motion hearing on June 13th. This was heard by the court. And I know at that point I denied a motion to dismiss that count. And the assertion in that motion was that had been filed by the defense, that really the charge should be dismissed because at the time the alleged victim was deceased. And then we looked at the statute. Okay, and I know it, so the instruction, the one that I'm proposing to give in any event that everybody's agreed to, 1218A, references the statute 940.225 sub 3 sub A. And so I've looked at that statute, and under 940.225 sub 7, it indicates specifically this section applies whether a victim is dead or alive at the time of the sexual contact or sexual intercourse. Okay, so what you're proposing that be done in this case, because of issues that have been raised and frankly that were argued on that date, that it be inserted, that the following language be inserted, quote, it is immaterial whether Shad Thyrion is dead or alive at the time of the sexual intercourse, close quote. That's what you're asking to be added?
Yes.
Mr. Freilich, any objection to that language?
Your Honor, I know that the jury instruction says person. What about the statute? What we have here, and not to be crass, but human remains, body parts that are in different locations. So that was the issue that I had with that.
I'm sorry, your question, you said that the statute says person?
I know the jury instruction says person, but I don't know if the statute says that, but it talks about any part of a person's body. So it talks about a person, and what we have here is, a body part, body parts.
Statute says 3A, says as follows. Whoever has sexual intercourse with a person without the consent of that person is guilty of a class, it's guilty of a felony. So the instruction mirrors the statute as far as person. So when you get down to sub 7 where it says this section applies whether a victim is dead or alive at the time of the sexual contact or sexual intercourse, they're using the word person, or using the word victim instead of person in sub 7, presumably because at that point in time, using the word person could get confusing as to whether you're talking about a victim or a perpetrator. If you just said the section applies whether a person is dead or alive, can you perpetrate? I don't want to get into all the machinations, but it would seem as if the word victim is used in sub 7, perhaps for that reason. So the question, of course, is whether there's an objection to insertion of the language, it is immaterial whether Shad Thyrion is dead or alive at the time of the sexual intercourse. Any objection to that?
I know that's in the statute, but is that in the pattern jury instruction that we have, Your Honor?
It is not.
It's not.
He's asking for it to be added in.
Yeah, he wants to add something, correct?
Yes.
I'm going to object to that.
Okay. I'm satisfied that, first of all, adding that language in is a correct statement of the law. It is. It's not as if modifying the instruction to something that incorrectly outlines what the law is. It's an accurate statement of the law. Secondly, this is a bit of an unusual circumstance where typically when you see these assaults occur, you have someone in court testifying that they were the victim of a sexual assault. That's different, of course, when you have someone who is deceased. So the circumstances of this case are a little bit unique. It's already been put into this case. It was argued, and I'm satisfied that it's an appropriate addition in this particular case. These pattern jury instructions are not by any means mandated by law to be used. They're guides, and while we usually follow them, it's certainly permissible for courts to look at them and modify them as needed, and I think this is an appropriate addition. So I'm going to grant that request. And so that will be added to instruction 115, the subpart under 1218A. Anything else, Mr. Saunders?
No, thank you.
Right, Mr. Freilich, again, you're going to get a final opportunity to review these, but any additions or changes that you're looking for besides what we've already discussed?
No, Your Honor, thank you very much.
Okay. Let me just ask you then about the proposed verdict forms. Obviously, there are 3 counts. There will be 6 verdict forms, 1 for guilty and 1 for not guilty for each count. Mr. Saunders, have you had an opportunity to review those?
Yes.
Right. Changes or corrections on those?
No.
Mr. Freilich?
One moment, please. Your Honor, I have reviewed all the verdict forms. They appear to be in proper order.
Okay. My judicial assistant and I are going to get underway on these right away. Mr. Saunders, if you can make sure you send a Word version over to her. I invite the attorneys to get up and move around if you want, but don't get far, because as soon as I'm done, I want to get back on the record, and I don't know how long it's going to take me. So just stay close, but you can certainly move about the courthouse, okay?
Thank you.
We're in recess. the judicial assistant should have given each of you a copy of the revised instructions, and I want to go through those again. First of all, I would propose giving 100 opening instructions. I'll note that on the next page, I've inserted 602. I indicated that that's where I thought it was most appropriate to insert 602, so I'll give 100 followed by 602. Then I'll give 103, evidence defined. 115, one defendant, 3 counts. Changes that have been outlined in there, we've talked about. It'll say that the counts will be listed as Tuesday, February 22nd, and I've revised the initials used for Mr. Thyrion. It will say Shad Thyrion. I've made the agreed upon elections on the 1193, mutilating a corpse, and then of course we move into 1218A, and I have inserted the language that was requested by the state. Mr. Freilich, I believe, objected to that. I ruled, however, that I was going to give it, and that sentence is, of course, under the subheading meaning of did not consent. It's the very last sentence, and I added that in. Then I'll give the modified 755A that was agreed upon and designed by Mr. Saunders. I will give 140, burden of proof and presumption of innocence. 145, information, not evidence. 147, improper questions. 148, objections of counsel, evidence received over objection. 150, stricken testimony. 155, exhibits. 157, remarks of counsel. 160, closing arguments of counsel. I'll give 170, circumstantial evidence. I'll give 172, circumstantial evidence, flight, escape, concealment. I will give 180, statements of defendant. 190, weight of evidence. 195, juror's knowledge. 200, expert testimony, general. I'll give 255, state need not prove exact date of commission. I'll give 300, credibility of witnesses. I'll give 460, closing instruction. 484, verdict submitted for 1 defendant, 3 counts, separate verdict on each count. I'll give 515, unanimous verdict and selection of presiding juror. We'll then select the alternates. A couple of things I want to take up. First of all, I did want to, because we didn't bring this up at our instruction conference, but it's not too big of a problem. I'm going to ask my clerk if she could hand one of those to each of the attorneys. This is what Mr. Freilich and I had spoken about earlier, 315. And Mr. Freilich, I know you didn't have a copy of that, but you can have a brief moment to review that with your client and take a few minutes to talk with her about whether or not you and she would like me to give that.
Okay, Your Honor. Thank you. Your Honor, I have reviewed instruction 315. I'm fine with that. And I showed it to my client.
Okay, and I appreciate that, Mr. Freilich. I think I need more than just I'm fine with that. This has got to be something that you either ask me to give or ask me not to give. And I'm going to have a colloquy with your client about it. Do you need some time to speak with her about it? Because if you do, I can leave the bench and come back in a few minutes.
Yeah, maybe that would be a good idea, Your Honor.
All right. We'll take about 5 minutes and have a conversation with her, Mr. Freilich.
Thank you.
Okay, so Mr. Freilich, I want to direct my attention to you. Have you had an opportunity to speak with your client about 315?
Yes, so I just want to put this on the record. I talked to my client. We've talked a number of times throughout the duration of my representation. I've advised her that if the case went to a jury trial, she has a right to testify. She has a right to take the witness stand. She has a right to testify in her own defense. But anything that is said could possibly be used against her. So she understands that she has a constitutional right to testify. I also told her that she has an absolute constitutional right not to testify. She has a right to remain silent. She can invoke her Fifth Amendment privileges against self-incrimination. And we've talked about this at length on numerous occasions, several times today. We've reviewed this jury instruction 315, and she's indicated to me that she wishes to exercise her right to remain silent. Before, when you asked the question, I wasn't quite sure what you were asking, but I agree to the court reading instruction 315 to the jury. Thank you.
So you're asking that I read this instruction to the jury?
Yes.
Okay. Ms. Schabusiness, you have a right to have this instruction read, or you have a right not to have the instruction read. And that right belongs to you and to you alone. Do you understand that?
Yes, I do.
Okay. Your attorney indicates to me that he would like me to have this instruction read to the jury. Is that correct?
Yes.
And you agree with that?
Yes.
You feel you need any more time to talk to him about that decision?
No.
Okay. I'm satisfied. Well, first of all, Mr. Saunders, any further inquiry you'd like me to make regarding 315?
No.
Mr. Freilich?
No, Your Honor. Thank you.
I'm satisfied that Ms. Schabusiness has indicated that she would like me to read 315 to the jury, and as a result of that, I'm going to do that. The only other topic I want to take up with the attorneys, and then of course I'll ask generally whether you have anything you want to raise with me. Oftentimes I get a request, I usually read these in order, oftentimes I get a request to have 160 closing arguments read just before you give the closing arguments, which would mean it's right after 315. Before closings, and then obviously after closings I read 460. Any objection to my reading 160 just before closings, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay, I'm going to have 160 then. I'll slide that in just before 315. Strike that, just after 315. Okay. Mr. Saunders, are there any other topics or issues regarding the instructions that you'd like to bring up with me?
No.
You're satisfied with the instructions and the order in which I propose to give them?
Yes.
Mr. Freilich, any topics you'd like to raise regarding the instructions?
No, I would not, Your Honor. I'm in agreement with the form of the instructions.
And the order with which I propose to give them?
Yes, I am.
Very good. Then, before I ask you about durations of closings, I guess what I would just indicate is I intend to bring the jury out. I intend to instruct them right up through the closing instruction. Attorneys can close. There will be potentially some rebuttal closing. And then we'll select the alternate, and the deliberations will be underway. Anything to bring up before we do that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. Then with that, we'll bring the jury in. Okay, be seated. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. In this first phase of the trial, you have heard evidence that dealt solely with the defendant's conduct during the alleged incident. You are to determine only whether the defendant is guilty of the charges of first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. If you find the defendant not guilty, the trial will be over. If you find the defendant guilty, the trial will proceed to the second phase, where you will determine whether the defendant was not responsible by reason of mental disease or defect. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. The first count of the information in this case charges that, count 1, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did cause the death of Shad Thyrion with the intent to kill that person, contrary to sections 940.01 sub 1 sub A, 939.62 sub 1 sub C Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, the defendant caused the death of Shad Thyrion. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill Shad Thyrion. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that her conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Shad Thyrion with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count of the information charges that count 2, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did 1 sub C of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 1 of the Criminal Code of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. First, that the defendant dismembered a corpse. Second, that the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The third count of the information charges that, count 3, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did have sexual intercourse with Shad Thyrion without that person's consent, contrary to sections 940.225 sub 3 sub A and 939.62 sub 1 sub B of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense be charged beyond a reasonable doubt. Third-degree sexual assault, as defined in section 940.225 sub 3 sub A of the Criminal Code of Wisconsin, is committed by one who has sexual intercourse with another person without consent. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. First, that the defendant had sexual intercourse with Shad Thyrion. Second, that Shad Thyrion did not consent to the sexual intercourse. Sexual intercourse means any intrusion, however slight, of any part of a person's body or of any object into the genitalia or anal opening of another. Emission of semen is not required. Did not consent means that Shad Thyrion did not freely agree to have sexual intercourse with the defendant. In deciding whether Shad Thyrion did not consent, you should consider what the defendant said and did, along with all the other facts and circumstances. This element does not require that Shad Thyrion offered physical resistance. It is immaterial whether Shad Thyrion is dead or alive at the time of the sexual intercourse. If you are satisfied beyond a reasonable doubt that both elements of third-degree sexual assault have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. An intoxicated or drugged condition is a defense to criminal liability only if it is involuntarily produced. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing the testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remark suggested certain facts not in evidence, disregard the suggestion. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was actually restated here at trial. And whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all of the other evidence in determining how much weight, if any, the statement deserves. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than the testimony of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. If you find that the offense charged was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt that the offense was committed on a date near the alleged date, that is sufficient. It is the duty of the jury to scrutinize and to weigh the testimony of each witness and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based upon the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then, give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence and under the instructions given to you by the court. We're now ready for the attorneys to give their closing arguments. I want to speak briefly, however, to both the attorneys that are giving the closing arguments, if you could approach. And ladies and gentlemen, in the event you were wondering, you are going to get a copy of these instructions during your deliberations, because I know they're lengthy. Having said that, Mr. Saunders, are you prepared to give a closing argument?
Yes, Your Honor.
Very good. Go ahead.
Good afternoon. I want to start with something that we heard yesterday, or actually Monday, during opening statements. Counsel told us that there's always two sides to every story, and with all due respect, this is not one of those stories. This is a story that pretty clearly shows what happened. It's a story of the defendant taking a dog collar that was around her friend's neck and pulling it so hard and for so long and with such force that it caused his death. That in that moment, she made a deliberate choice to end her friend's life. She then, after the fact, degrades his body, engages in sexual acts with him. This is a story of the defendant then dismembering him and leaving his remains all over the house for his mother to find. And this isn't the state's story. This isn't law enforcement's story. It's the defendant's story, as you heard today, right? So, as we go through this, it's easy to sit here and say, yes, the defendant confessed, and it's true. She confessed to every single element that you will see that the state needs to prove. But we didn't just stop there, right? We could have been done with this case on Monday, played her interview, and called it a day. But you should expect more, right? We have the burden of proof, and obviously we called a number of witnesses to establish what this story shows. So I want to walk through that story. And I know there's a lot of law that was just read to you, but I'm a visual learner, so I like to see kind of what we're looking at here. So as I go through these 3 offenses, there's really, as you'll see, 6 things the state needs to prove beyond a reasonable doubt. Not every fact that was testified to, not what time somebody got to Scott Holmes' house at the end of the night. The 6 elements are what the state needs to prove to you beyond a reasonable doubt. Okay? So first, count 1, first-degree intentional homicide. First, that the defendant caused the death of Shad, and that she, second, acted with intent to kill him. Okay? And again, as I already mentioned, as we go through these elements, you heard earlier this morning that the defendant is acknowledging every element that we hear. Okay? Independent of the information you heard today, with the investigation you heard, the DNA, the other information, Dr. Tranquita's testimony, I would argue would prove all these elements as well. But you have on top of that the defendant's admissions to all these elements. Okay? So the defendant caused the death of Shad. I mean, that should be fairly clear here. Obviously, she admits that. You heard Dr. Tranquita's testimony of how Shad died, the cause and the manner of death, strangulation, excessive force being placed on the neck, producing his death. That was the sole cause of death that we heard. So let's talk about intent, right? Because that admittedly sometimes is a tricky topic, right? We can never know anyone's intent truly, and as you're told, you're not going into the mind of somebody, right? Kind of looking at all the facts and circumstances that you see. In this case, you have the benefit of the defendant opening up her mind to you and telling you what her intent was here. But you also have other signs, right? So what does intent mean? That somebody had the mental purpose to do something, right? Some volition. Or that they're aware that what they're doing is practically certain to cause that result, right? And you heard both, really, from the defendant. So I want to walk through that because there's a lot of points in that interview where the defendant is telling you exactly what her intent was in this case, right? His face was turning purple, right? She describes that and how he's coughing up blood, and you know that's accurate, right? Because you heard Dr. Tranquita's testimony and you saw those photographs. She's seeing that in person, and yet what does she say? I still didn't stop. No. She felt a heartbeat at one point, right? She talks about feeling his heartbeat, and she kept pulling more, and he wouldn't die. And I just wanted him, and I was like, damn. Right? She admits even that Shad's struggling in this moment, that he's fighting back, right? You heard from Dr. Tranquita as well about how it looked like at one point there were signs of that, where the collar slipped up along the tongue. She's telling you, I was waiting for him to die. I liked it. She figured I'm already this far, and she's pantomiming the act. It's like she's starting a lawnmower. That's how hard she's pulling on this chain, right? Took 3 to 5 minutes, she thinks. And again, that's consistent with Dr. Tranquita, right? This is not an accident. This isn't a whoops. This is an intentional act, right? I don't need to prove that she went to that house with this intent, right? We talked about that in voir dire, and we kind of talked through that concept of how, as you're instructed, intent can be formed in the instant before an act, the instant before the pull of a trigger, the instant in this case before Ms. Schabusiness decides, I'm going to go further and pull on this chain so hard that it causes the result that we saw in Shad, right? So we have the mental purpose, right, from the defendant's own mouth, and that's consistent with everything else we're seeing in the case. But you also have Detective Kempf asking her, I mean, in that moment, did you kind of realize if you kept pulling on that chain that he would die? She's like, probably, yeah. Yeah, she was aware of that. Right? So that goes to this kind of the second either-or part of intent, right? Was aware that her conduct was practically certain to cause that result, and it's probably obvious as you sit here of what's going to happen when you're pulling a metal chain like that hard for that long, seeing the result of what's happening to another person, that is going to be the result, right? So you're told you can't look into a person's mind. the defendant told you exactly what her intent was in this case. But as I mentioned, you also have other indicators, right? You have Dr. Tranquita's testimony describing the amount of force that would need to have been done to cause the injuries that he's observing, right? Down to the inner neck muscles, and he was talking about how strong and thick those neck muscles are, and there was hemorrhaging that deep. That's how hard and how long and how much injury the defendant was causing. Right? This isn't an accident. If it's an accident, you're not going forward. You're not seeing this result and keep pulling. You're calling for help. You're stopping. You're certainly not after the fact, after you finally finish, then cutting up his body, right? You have all the evidence in this case points to intent, right? You have her acts after the fact, like I said. You know, if this was an accident, something happens, right? You call for help, and you have the exact opposite. You have the defendant cutting him up and cleaning up, getting rid of the remains, pouring it down the shower. We heard a lot of testimony about that. Kind of wiping up with the Clorox wipes, which the defendant is acknowledging as well. So you have the defendant's statement in the case, and it lines up with everything else in the case, right? Even little facts that she's remembering and telling you about, right? The timeline of the February 21st night, right? We heard from A.J. Gannon. You heard the stipulated testimony from Mr. Tomes. You heard from Mike Thyrion. It's all consistent. Yeah, they were coming and going. You then heard from Steve Hendricks about, yep, they got back sometime in the early morning and I let them in. Defendant's telling you that same thing. Steve is talking about how at one point during the day on the 22nd, she comes up and asks for her eyeglasses, and we heard the defendant talk about that as well. We heard Detective Graff testify about that. So everything she's saying is consistent with what we're objectively seeing, what law enforcement is finding. And in some respects, the defendant's leading the investigation, right? Because when they get there, when law enforcement gets there, we saw Officer Wanish's body cam. We heard from Detective Scanlon and even Dr. Tranquita about how it was really hard to determine what exactly happened when they first got there. And all that information is being provided by the defendant. Okay? So it's an intentional act. She had the mental purpose. We heard about that. It's not, as I talked about, it can be formed at any time before the act, right? It doesn't need to be premeditated. That's not the law in this state. And it's really important, too, to not confuse this with motive, right? We heard evidence about motive, right, and her interest in Jeffrey Dahmer and all that entails. But intent doesn't mean motive. This is what intent means, and we proved intent, right? She caused his death, and she acted intentionally, and she told you as much. So those are the two elements. Those are the two things the state needs to prove beyond a reasonable doubt. Count two, mutilating a corpse. So again, there's two elements for this crime. First, the defendant dismembered a corpse. Second, did so with the intent to conceal a crime. So the first element, I think, is pretty clear, right? And we heard extensive testimony from many people, and we saw Dr. Tranquita's diagrams, and obviously I can't imagine this element is going to be in dispute, right? And so again, though, we have this concept of intent, the purpose to conceal a crime, right? And I mean, as you're instructed, you use your common sense. Like, why is somebody going to this length, not only cutting up a body? We heard from Dr. Tranquita about the multiple sort of start and stop kind of signs, the total evisceration of Shad, bagging him into other bags and attempting to carry out. Like, that's the intent, right? We use our common sense that that's why you're doing that. But again, she was asked about this, the defendant. And remember in that February 28th interview, the second interview with Detective Graff and Detective Scanlon, she's saying exactly what her intent was, right? It was because there's other people in the house. Like, what am I going to do? Leave the body and have Mom find it? She admits, again, this was her intent, and it's obvious with our common sense, but it shows that the state has proved both elements of this crime as well. Okay, count three. It's third-degree sexual assault. So the defendant had sexual intercourse with Shad and did so without consent. So let's talk about the first part. Sexual intercourse is defined in this state as inserting any object into the genital or anal opening of another, or engaging in oral contact with the penis. We heard about both, right? The defendant admitted to both. She's talking about how she's put the dildo in Shad's anus after she killed him. She's talking about how she was sucking on his penis, and there were other phrases used to that effect. So again, we have, for both elements here, the defendant's admissions. And we heard from Mr. Scott, didn't we? We heard from Mr. Scott about the DNA testing that was done, right? And for some of the reasons why, even though the defendant's DNA is on that dildo in Shad's house, Shad's DNA wasn't found on there, and nothing excludes that possibility. And again, everything the defendant's telling you is consistent with other things you're seeing. So there's no reason to believe, a reasonable hypothesis to believe, that she's not also telling you what's happened in this case too, right, for this count. And the second element, did not consent. I mean, that, as you're instructed, is kind of inferred by the fact that at the time that the defendant's telling you she's engaging in these acts, that Shad's deceased, right? So he's not in a position to consent. Okay. So those are the two elements for count 3. So in total, 6 elements for the 3 offenses. And again, you're given a lot of law on how to assess credibility of witnesses, and that's good, and you should follow it. Really, you kind of just use your common sense as jurors. And again, the defendant's telling you what happened, and there's nothing in the case to disbelieve what she's saying, right? So you have the defendant's admissions, as I mentioned earlier. There's other evidence that kind of just only should bolster the conviction in the defendant's guilt, right? We heard from Kevin Scott, who heard or testified about the DNA testing he did. Shad's blood on the defendant's hands, on her clothing, on the sweatpants, about how the knives that were found that had Shad's blood on them, right? Even absent her confession, I mean, there's ample evidence here to convict on all 3 counts. You have many witnesses coming in to talk about the integrity of the investigation, how law enforcement didn't just take the confession and go home, right? We do more, right? Send things in for DNA. We speak with other witnesses. We corroborate the defendant's timeline of things. You heard all that. And that's really important, right? We have the burden of proof. And we talked about that, and we embraced that burden of proof. You should hold us to that standard as the state to prove something beyond a reasonable doubt. And that's why we call people from Madison to come up to talk for 5 minutes about, I received this piece of evidence, and it was fine. And I returned that piece of evidence, and it was fine. Right? Because it's important. We want to show that law enforcement did a thorough investigation in this case. And they did. Because we have the burden of proof. You're instructed on what the burden of proof is and what it's not, right? It's a reasonable doubt, a reasonable hypothesis consistent with consistent with innocence. You should find the defendant not guilty. You're not searching for doubt. You're ultimately searching for the truth. So even if it's a heavy burden, it doesn't mean the decision is difficult in cases. You are instructed not to search for doubt. You're to search for the truth. And there's not a reasonable hypothesis in this case consistent with the defendant's innocence. There just isn't, right? There's one truth in this case. There's one side of the story, and it happens to be the defendant's story as well, but it's consistent with everyone else's story. It's because that story is the truth of what the defendant did to her friend Shad. And based on that, we would ask that you return guilty verdicts on all 3 counts. Thank you.
Mr. Fairley, are you ready to make a closing argument?
Yes, I am, Your Honor. Thank you. Your Honor, may it please the court, ladies and gentlemen of the jury, Mr. Lizay, Mr. Saunders. Well, as the attorney for the defendant, Taylor Schabusiness, I'd like to share with you that I believe this case is a puzzling, unclear, confusing, and bizarre set of facts. It is unknown what really happened between February 22nd of 2022 and February 23rd of 2022. What we do know in this case is that numerous law enforcement officers testified. We had detectives, we had police officers, we had Dr. Trunkita, and DNA experts, forensic specialists, lots of different people, some citizen witnesses. I'd ask that you consider setting aside your emotions and decide this case based on the facts that have been presented. You've sat here for the last 3 days. You've been here in court. I know that you've listened very closely, but don't assume anything. When you deliberate about all of the facts. What we do know is that law enforcement officers on February 23rd of 2022 went to 829 Stony Brook Lane in Green Bay, this small Cape Cod home, and made contact with the occupants, Tara Pakinich, Stephen Hendricks, and Ava Wheelock was woken up, but they were all sitting at the kitchen table, and officers came in to see what was going on. There was a concern, obviously, that there was a bucket down at the end of the stairs. And we heard from Detective Roth that this was an ongoing investigation, law enforcement. They were trying to piece this together. It was an unusual situation, and so they were trying to find out what happened. Unfortunately, I believe it was Officer Plonky and Officer Wanish, they testified, they came here and indicated that they went down to check out what was in the basement, and there was the head of Shad Thyrion in that black Fleet Farm bucket. And the investigation continued on. But what I submit to you, ladies and gentlemen, is that there really are no eyewitnesses as to what really happened down in the basement. There was no Taylor Schabusiness there, no other people there, and so that'll be something that you'll have to consider and think about. Then law enforcement realized that there was a secondary scene, and that was at 2353 Eastman Avenue, apartment 1 of that parking lot. And you saw the video. The officers, I think it was Officer Garth Russell, and a couple of other ones, they walked up. Microphone. Sorry. Thank you. The officers walked up and they parked a distance away, and they walked up in the snow and they saw a line of cars in front of the apartment complex. And they saw that a minivan. It was a gold Town and Country Chrysler minivan, and that was a vehicle of concern. Had some snow on the back windshield. There were vehicles on either side. And the officers walked up and they saw some lights on the van, and then they saw someone come out the front door, and it was my client. It was Taylor Schabusiness. At that point, she was arrested by Officer Russell, and another officer then realized there was a male inside of the apartment number 1 down the hall. Ended up being Scott Tomes. And he was told to lay on the ground and held at gunpoint, and then he was arrested. So 2 people were taken from the apartment building and taken down to the police station. There was a search of the Eastman Avenue apartment. We don't have any body parts there. I would submit that there really wasn't anything of evidentiary value there. And that was that. Later on, officers and detectives realized that that minivan was something that they were concerned about, so that was taken down to the police storage garage. And then we found out that from Dr. Tranquita and some of the other forensic specialists, Andre, I believe it was investigator Andre, and Zarnecki. And so they donned Tyvek gear, protective PPE equipment, and they methodically investigated the back of the minivan, and they found the crock pot box that was in a laundry basket sitting on a seat, and there were human remains in there. Nobody saw Taylor Schabusiness driving this minivan. So these are some of the facts that you got to think about. Don't rush to judgment, but talk about it, analyze it. As jurors, you have to analyze the facts that you hear, and you have to apply the law that the judge gives you. It's a daunting task. So then we hear, you saw the video, the interview between Detective Groff and my client, Taylor Schabusiness. She was taken down to the Green Bay Police Department. Photographs were taken of her, and clothes were taken, and she was put in a yellow suit and then later a blue suit, but she was asked questions. And you got to remember what she said and what questions were being asked. She did say during the interview, "I can't think right now. I'm effing nuts." She said that she was up all night, that the body would rebuild itself. She said weird, odd things. Consider her credibility. Consider what she says. Consider what she said to Detective Groff or Detective Scanlon. She said stuff, I would submit that she said things that didn't make sense. She says, I have no idea to some of the questions that the detectives asked her. You remember seeing the video on the screen. I'd ask that you recall that she had inappropriate laughs, inappropriate smiling, odd responses. I would submit that she indicated that she did not have sex. She did not have penis to vagina intercourse with Shad Thyrion. She indicated that she came to the residence and they went downstairs, and within 5 minutes they got to it, whatever that means. She talked about, during the interview with Detective Groff, rebuilding muscle or rebuilding into muscle. Sometimes she wasn't responsive. She talked about hearing gunshots, but I believe Detective Groff said that there were no gunshots in the area of Stony Brook. Eastman Avenue was some other place. She said she was paranoid. She said weird things like, I don't like open spaces. I don't like open spaces. No clothes came off. No kissing. She said that she allegedly put the dildo into Mr. Thyrion's backside, his butt area, his anal area. There's no DNA. We heard from Kevin Scott, DNA expert. He must have done real well in school, in chemistry and all that. But the swab from the dildo, item J1, it says the possible contribution of DNA from Shad Thyrion is inconclusive due to the complexity of the mixture. I would argue that his DNA is not on the dildo. So I would argue that even though the state is charging out third-degree sexual assault, there is no shred of evidence to support that particular charge. And I'd ask that you take that into account. No evidence at the Eastman Avenue apartment. When Detective Groff had my client come down to the Green Bay Police Department with Detective Kevin Kempf, they were talking with her for a while. The interview was maybe 3 hours or so. And then they took a break because Ms. Schabusiness had cuts on her thumb, scratches on her palms, other cuts on her fingers. Some of them were deep. You saw the pictures because I believe they were published. And she was taken over to St. Vincent's Hospital for medical evaluation. I would submit that the blood on her hands may have been her own because of the deep cuts that she had suffered or that she had. The defense had subpoenaed Mr. Scott Tomes. He was unavailable, and he gave an account of that night. And he had indicated, at least on Monday night, that would have been February 21st, that Taylor Schabusiness and her friend Shad came over. He had seen Shad before, but didn't know his name. And then he thought that they hooked up to do meth. And then he talked about his vehicle. And he talked about that Taylor Schabusiness had used his vehicle in the past and didn't get permission on that particular night. Then he indicated that he was drinking. And then he indicated that Taylor Schabusiness returned to his house around midnight with his vehicle, went to her bedroom, and he had a suspicion that she may have been high on drugs. And then he had indicated that Taylor had the bedroom and that he would sleep in his chair. So that's, something else that you have to think about. We heard from Lieutenant Buckman. He was a veteran on the Green Bay Police Department, and that he was doing some investigating, and he wasn't sure if Taylor Schabusiness was a suspect or a victim because it was an ongoing new investigation. So that's something you have to take into account as well. The state brought up some photographs, a picture of Taylor with her phone. And young girls, I submit, they like their phones. So do all kids, young people. They like their phones, and they look up things on the internet for a variety of different reasons: shock value, curiosity. But we have a situation here where Taylor did do some searches about Jeffrey Dahmer. I would submit that that's a ruse, that doesn't necessarily mean anything, and that people search the internet for all kinds of things on the internet, and that it's for shock value. So that shouldn't really play any part in this case. I would ask that you discount that and set that aside. Now, I would argue that I would argue that it's not a clear case here. Was this an accidental death? Did Taylor Schabusiness kill Shad Thyrion? Was there intent to kill Shad Thyrion? Did Taylor Schabusiness have the mental purpose to kill Shad Thyrion? Different theories, different things for you to think about. You are all like analysts, and you have to assess and decipher the facts. The facts here are very complicated, confusing, unclear. 2 different locations, no eyewitnesses. Taylor Schabusiness, we learned that she went to school with Shad Thyrion, middle school, Bayport High School. They were friends. They hung out. You heard from A.J. Gannon. He hung out with them as well. Can you trust what someone says when they're hopped up on meth, on drugs? The state wants you to look into Taylor Schabusiness's mind to find out what her intent was. And that's a difficult task. Did she have a clear mind on February 22nd of 2022 as to what was really going on? Accidents can happen. When accidents happen, people can make other choices in a panic. Something for you to think about. This sexual assault charge, how can you have sexual intercourse with the facts that have been laid out and presented to you? It's mind-boggling. How can you have sex when genitals are in one place and body's in a different place? It's foggy, it's cloudy. It's hard to imagine, almost impossible to try and figure out what did or didn't happen. I would submit to you that no sexual assault occurred. I'd ask that you find her not guilty of third-degree sexual assault. You can't rely on everything Taylor Schabusiness says. Think about that, please. She chose not to testify under our Constitution of the United States of America. She doesn't have to testify. It's what the law provides. You don't have to take the witness stand. You have a right to remain silent. And you can't use that fact alone against her. I would argue that based on all of the evidence and the testimony in this case, that you find my client not guilty of all the charges. Thank you very much for your time.
This case is puzzling. This case is bizarre. This case is in absolutely no way unclear. It is crystal clear what happened to Shad Thyrion, and we know that. We know that because the defendant told you. She told you what she did to Shad Thyrion. Is it bizarre? Is it unnatural? Is it strange? Yes, absolutely. People do bizarre, unnatural, strange things. They engage in criminal conduct. People kill other people and they dismember them. That's what Taylor Schabusiness did. And we know exactly what she did because the words from her mouth told you with specificity what she did. Can we trust always what Taylor Schabusiness says? No, but as Mr. Saunders told you, we trust but we verify. We didn't stop at taking her statement. We corroborated. She guided the investigation with the specificity of her statement. How can we not trust her statement when she describes in detail the mechanism of injury, which is exactly what is described and confirmed by Dr. Tranquita? Excessive strangulation over a period of time with layers of injury, exactly as she described it. Described that his tongue would be out. She described that. Dr. Tranquita described that and showed you that. She described his struggle. He's struggling for his life and she continues to pull that chain, demonstrating her intent to kill Shad Thyrion. And we know that because we see that in the physical evidence. We see the marks on Shad's tongue. We see the damage to his neck. She described to you what she did with his body after she killed Shad. And we know that it's true because the body parts were exactly where she told you they were. Detectives are finding everything she says on scene, and you saw it with your own eyes, that just what she told you is exactly where those things were located in that residence. She wasn't cloudy. She wasn't unclear. She wasn't hopped up on drugs. She knew where to find the drugs. She knew where they'd find the pipe. She knew where they'd find the chains. She knew where they'd find the knives. She knew the name of the bag, where the body parts were going to be located. She could tell you that she put the organs in plastic bags. She could tell you that she cleaned up with Clorox wipes and she put them in the bags as well. She could tell you that his lower extremities were in the car. This is the most specific confession anyone could ask for, and it is corroborated in detail by the work of the Green Bay Police Department. This is bizarre, this is strange, this is unnatural, but it is in no way unclear. We know exactly what happened. We know exactly what Taylor intended to happen for all three of these offenses. She engaged in intentional conduct in each of these acts. You are asked to look at each of the 6 elements, and there are only the 6 elements that Attorney Saunders described to you. That as to count 1, she did cause Shad's death. There is no doubt she had the mental purpose to do that. And that she knew that her conduct was practically certain to cause it. She described to you how she visualized him struggling, blood coming out of his mouth, but she did not stop. He's turning purple, but she did not stop. He's coughing up blood. He's pissing himself, in her words, but she did not stop. This was a deliberate choice on her part to kill Shad Thyrion, and she knew that her actions were going to cause that. And in fact, she was asked whether or not she liked it, and she confirmed that she liked it. She was asked whether she was sexually aroused by killing him, and she said she was. Her mental purpose was clear. As to the mutilating the corpse, again, there's no doubt that she intentionally did that. She described the detail. She described her frustration as she's mutilating this corpse, and she described her purpose in doing so. How else am I going to get the body out of the house? How else am I going to get away with this if I don't cut this body up? And she didn't just cut it up and leave it there. She cut it up, she packaged it, she cleaned up after herself. Her purpose in dismembering Shad was clear. She wanted to attempt to get away with this crime. A crime that she intentionally committed. A crime that was not accidental, that was not a surprise to her. That she didn't wake up from this nightmare and then call the police and call Shad's mom. No, she made the second deliberate choice. After deliberately choosing to kill him, she deliberately chooses to dismember him and attempt to cover up her crimes. And likewise, the sexual assault is equally clear. There's no doubt that she had sexual intercourse, and for counsel to say that we can't merely accept the word of the defendant, you're asked routinely in sexual assault cases, juries are asked routinely to take the word of a crime victim with no physical evidence. We don't have to take the word of the crime victim. We have the word of the defendant who confesses to this crime and tells you exactly what she did, again with specificity, and tells you, you know what, I did this and I did it with that dildo. And here's where you can find the dildo. It's in the wall, it's in the box, I put it away. And what happened? They found it in the box, put away exactly where she described that it would be. And she clearly was sexually aroused by this whole incident, and she described that to you herself. So clearly it follows, it makes sense, it's logical, it is reasonable that she did exactly what she told you she did. There is absolutely no reasonable hypothesis consistent with her innocence. The only hypothesis, the only choice that you have before you here today is to find Taylor Schabusiness guilty of each and every count for which she is charged. All of those elements have been proven beyond a reasonable doubt, and I ask that you return a verdict of guilty. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 6 forms of verdict will be submitted to you concerning the charges against the defendant, Taylor Schabusiness. 1 reading, we the jury find the defendant, Taylor Schabusiness, guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, guilty of third-degree sexual assault as charged in count 3 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of third-degree sexual assault as charged in count 3 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have a question, the court will talk with the attorneys before answering it, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with this verdict. Now, ladies and gentlemen, this is the unfortunate time, because now is the time when we select the alternate jurors. Let me tell you what the process is going to be. The computer has selected 4 of you. We're going to read those names here shortly. If your name is read, I'm going to ask that you simply stand up and go have a seat in that first pew right there, because I'm going to want to address you, first pew right here, because it's open. And I'm going to address you after the other jurors have been excused. The remaining 12 jurors are going to participate in the deliberation process, and you will accompany the bailiffs to the jury room. If you're selected as an alternate, your participation in the case at this point will be concluded. I will make sure, however, that you are addressed by a bailiff who will assist you in retrieving any items that you may have in the jury room. So at this time then, I'm going to ask that the clerk read the names of the 4 jurors that have been selected by the computer randomly.
Nicholas Rozek. Sean. That you will, to the utmost of your ability, keep all jurors sworn on this trial in some private and convenient place, subject to the direction of the court until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
I do.
Thank you.
All rise for the jury. Might be seated. I want to first address Mr. Rosick, Mr. Lynette, Mr. Beerhalls, and Ms. Schrader. I want to thank you very much for your service on this case. You've all paid careful attention. I've been able to observe all of you throughout the trial, and I really appreciate that, and so do all the parties. At this time, your service in this case is completed. Many jurors ask if they're allowed to discuss the case with others at the conclusion of their service. Because your role in this case is over, you are not prohibited from discussing the case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than from the court. This includes the parties, the lawyers, the media, or anyone else. If you do decide to discuss this case with anyone, I would suggest that you treat any discussion with a degree of solemnity such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. Finally, should any of you have any questions before you leave today, please let the bailiff know before you leave. And you can confer with me at any time before answering any questions asked by anyone if you choose. The bailiff is standing right back there. I'm just going to ask you to get up then and accompany her out that door, and if there's anything that you need to retrieve. But again, thank you for your service. Anything to take up before we recess? Mr. Saunders?
No.
Mr. Freilich?
Not at this time.
Very good. Then we are in recess. I'd ask the parties to remain very close here to the courtroom for at least 30 minutes. Oftentimes, if questions come in, they come in early. After that, if you just simply leave a cell phone number where we can reach you, then you're free to depart. But I'd still ask you to remain close to the courthouse. But at this time, then, we are in recess.
Thank you.
understanding is the jury has a verdict, is that correct? Yes, yeah. Okay. Anything to bring up before we bring the jury in? Mr. Saunders?
No.
Mr. Fraley?
No.
Very good. Then we'll bring the jury in. Okay, be seated. Ma'am, are you the foreperson? Yes. And my understanding is that the jury has reached a verdict. Is that correct? Yes. Right. If you would hand that to the bailiff then, please. Okay. First verdict reads as follows. We, the jury, find the defendant, Taylor Denise Schabusiness, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this date, July 26, 2023, signed by the foreperson. The second verdict reads as follows. We, the jury, find the defendant, Taylor Denise Schabusiness, guilty of mutilating a corpse as charged in count 2 of the information, dated this date, July 26, 2023, signed by the foreperson. The next verdict reads, we, the jury, find the defendant, Taylor Denise Schabusiness, guilty of third-degree sexual assault as charged in count 3 of the information, dated this date, 26th day of July, 2023, signed by the foreperson. The verdicts appear to be in order. Do either of the parties request that I poll the jury? Mr. Saunders?
No.
Mr. Fralick?
Yes.
Okay. Ladies and gentlemen, I'm going to do what's called polling the jury. It's a very simple process. All I'm going to do is go down the line and ask each of you if this is your verdict. Your answer is either yes or no. I'm going to start in the back corner, ma'am. Are these your verdicts?
Yes.
Ma'am, 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 are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
In the front to the right, ma'am, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts? Okay, the jury has now been polled. Ladies and gentlemen of the jury, for today, your tasks are concluded. We're going to start tomorrow morning on the second phase, at which point in the beginning I will give you some further instructions, and then we will get underway on that phase. The attorneys and I have a few things that we're going to need to take up before that phase starts, so I'm going to ask that you be in the jury room by 9:15. I want to start right at 9:15, and we will hopefully get our matters resolved ahead of that time. But for today, your service is concluded. I am going to, again, read you that instruction that I've done every day since you've started. Please do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based upon the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. We are done for today. Have a good evening. We will see you tomorrow morning at 8:50 or 9:15 sharp. All rise for the jury. Be seated. Is the matter regarding Dr. O'Donnell still a contested issue? I'm seeing nods from the state.
As of last night, yes.
Okay. So here's how we're going to handle this. I've indicated to the jury that I want them to report at 9:15. Mr. Freilich, it's entirely up to you if you want to bring Dr. O'Donnell here tomorrow morning at 8:15 for me to hear from. But I'm going to indicate to you the parameters of where that situation is. I've reviewed your memorandum, which is all I can really work with because this is what you've essentially said to me. This is what he's going to testify about. The first opinion is that Ms. Schabusiness was acutely intoxicated and impaired by acute methamphetamine use at the time of the alleged asphyxiation. The problem I'm having with that assertion is I'm not sure it's relevant given the status of the intoxication defense. So I'm not sure that having it here is going to assist you in that, but and I need you to understand where I am regarding that topic before you decide that's what you want to bring it here for. The next point is that the long-term and excessive use of methamphetamine has chronic brain damage consequences. The problem with that situation is I don't know that he is competent to diagnose chronic brain damage. So while he could assert that long-term excessive use of methamphetamine has chronic brain damage consequences, I don't think he's going to be qualified to testify that as a professional I can say to a reasonable degree of certainty used in my profession that Ms. Schabusiness has chronic brain damage. Frankly, I think the only opinion that's been asserted regarding her mental health condition as far as a diagnosis is bipolar, and that was done at Nicolay, and there's some dispute about whether that was an accurate diagnosis, but I don't know that one would qualify bipolar as being a chronic brain damage. So I'm concerned that if he's going to come in and start opining about that the connection won't be made. And then, of course, even if he is able to say that she does have chronic brain damage, the next step he has to take is that somehow that impacted responsibility, and I think there's a concern there as well. But I'm putting you on notice of that view that I'm starting to develop regarding the submissions you've made to me. The second bullet point is that long-term adolescent use of marijuana arrests brain development. Again, I'm not familiar with the diagnosis that any qualified psychologist or other professional qualified to make such a diagnosis has actually made in this case. I don't know that one equates brain development with bipolar. I've never heard that, but I'm not an expert. So the notion that you can opine that someone who uses marijuana as an adolescent might have brain damage, I'm not sure is going to be useful to this jury because we don't know if your client has that. And the next step is, how does that affect responsibility? And I'm not sure he's qualified to give that opinion either. The next bullet point is, Ms. Schabusiness was not treated with psychotropic drugs to control or mitigate her psychiatric illnesses. He certainly, and again I want to say, I'm satisfied that he's qualified as a pharmacologist. I'm not questioning his qualifications as that. Certainly I reviewed his CV and listened to his testimony at the prior hearing, and he's a qualified pharmacologist for sure. But as far as psychiatric illnesses, again, the only thing that I've heard about from the testimony in the records is a bipolar diagnosis at Nicolay, which these other psychologists have repeated. So that the only thing that one could conclude from this assertion is that she was not treated with psychotropic drugs to control or mitigate her bipolar disorder. And then the question is, how does that impact responsibility? Many people have bipolar, so the next question you have is does someone who has bipolar, will the consequences be that you're unable to appreciate the responsibility in a criminal case? That's another concern I have with whether he's going to be qualified to even testify about that. The next point is psychotropic drugs do have efficacy in a large percentage of patients who take them. Well, I'm satisfied he'd be competent to testify about that. I'm not sure how that actually, first of all, how that relates to whether or not, what she has been diagnosed with, how that would affect an individual by taking psychotropic drugs, and can he say how it would have affected somebody to a reasonable degree of certainty used in his profession regarding the impact of untreated bipolar disorder. That certainly might be within the ken of your other expert, and I do want to indicate you have another expert who might be qualified to testify about some of these things, but I'm very skeptical that this witness is qualified to do so. And then the final point is that Ms. Schabusiness' use of methamphetamine worsened her untreated psychiatric condition. So really, the issue is the impact of methamphetamine on untreated bipolar, and the impact of methamphetamine untreated bipolar on someone's responsibility to commit a crime. And I'm just concerned there as well that there's an inability to connect all of those dots with this expert. And so while I'm willing to hear from your expert, because you've asked that, and I think the state is of the mind, we don't even need a hearing on a Daubert hearing on this, but I'm affording the defense an opportunity at 8:15 tomorrow morning. If you want to bring Dr. O'Donnell in to opine on some of this, but you need to understand that's the concern I have. It'll be a rather short Daubert hearing for this reason. This proceeding tomorrow is in the nature of a civil proceeding, and I'm pretty certain the judge is not even mandated to hear testimony in a Daubert hearing. I can do a paper review and make a determination, and so I can tell you that I've done that paper review so far, and those are the concerns that I have. And I'll want to drive directly at those issues tomorrow. I'm not going to want to hear about a lot of things that if I can testify, I might be able to say a whole lot of things. I'm going to want to know specifically about my concerns, and if they can't be directly addressed, then I would be satisfied that he's not competent to give those opinions. Even though, again, I want to indicate out of respect for Dr. O'Donnell, I'm satisfied that he's a very capable and competent pharmacologist, but I'm concerned about some of these opinions, particularly when the psychologists who would be rendering the diagnoses that he is referring to aren't even in agreement on it. Nonetheless, that's where we're at. Let me just turn to the state. Mr. Saunders, questions on what I've indicated?
No, I don't.
Mr. Frail, questions on what I've indicated?
No, Your Honor, it's very clear.
All right, very good. We'll see everyone then tomorrow morning at 8:15.
All right, Thank you.
Stand up, please, okay? Chance, find your back.